just say that the parties know this because we discussed this via email earlier this morning, but one of our jurors will not be back. He has been hospitalized. His wife phoned the court, actually phoned the jury administrator to say that he was hospitalized and wouldn't be able to be here today. I went ahead and excused him from further service since we have 3 alternates. So just getting that on the record. Is there anything else we need to take up? Here's what I'm thinking. We'll see how far we get in your proof today. At some point, let the jury go, talk about instructions, and see where we'll be tomorrow.
And Judge, I know they're not here, but I feel better approaching. If we could approach.
You want white noise?
Yeah, I guess.
Hold on. So we are going to actually go ahead and argue instructions. So I'm going to tell the jury what's going on.
Clear.
Okay, perfect. And then I actually have to come back and get it. Sorry. All right, well, you all can go ahead and have a seat. We'll talk about instructions. So when we were here last week, I indicated to counsel for both sides that generally with instructions, what I will do is look to see where they're different and go through them that way. However, because I did not get instructions until this morning, I have not had time to do that. So, I'm just going to kind of go right into it. All right, let's look at
Sounds like we aren't going to have a defense mounted.
Commonwealth's instruction with regards to presumption, the defendant's instructions with regards to presumption of innocence. Is there any objection during that inclusion? It appears to me to be the standard Cooper's instruction for presumption of innocence. It's this. I'm looking at the defense's version of instructions, their first page of actual instructions.
I have it under instruction.
Oh, do you?
Yeah.
And so then does the defense have a position on whether it comes before or after the instructions as to the various counts of the indictment?
Judge, I don't know that the court is compelled to do it one way or the other.
It doesn't matter to me.
It's our preference that it go first.
Okay. And then the Commonwealth also included a definition for unanimous verdict. Do you want that included as well?
That's fine. I wasn't sure. I couldn't remember. I thought I did have that
Maybe you have it at the end.
near the end. Right
That's
before
fine. We'll just continue going through yours. All right, definitions. Are you all aware of any differences in your tendered definitions?
Yes, there are a lot. The Commonwealth is only asking for an instruction on intentional murder. So that cuts out a lot of the definitions that we submitted. We submitted on definitions on intentionally, complicity, and official proceeding.
For the defense,
Judge,
what is the basis for including wantonly or recklessly?
well, Judge, the indictment says wantonly in it on all three of the murder counts.
Mm-hmm.
So based on the actual charges themselves, we thought that it should be there. There wasn't any amendment, nor do I think that we would object at this point to an amendment of the indictment or of the charges.
I don't think recklessly is in there.
No, I was
Okay, but just for
referring to
wantonly.
wanton.
Okay.
Judge, we are asking for lessers, and I don't know if the Commonwealth appears not to have proposed those, but it is our motion as part of our proposed instructions to ask for lesser included, which would include manslaughter in the first, manslaughter in the second, reckless, which are the standard lessers on any homicide, and then also based on the evidence that's been presented, as well as the deals that were offered to the co-defendants, we believe that facilitation should be an option for the jury.
All right, just a moment. So as to wantonly, I think based on the charge, wantonly should be included, but does someone have any objection to the wantonly definition being included?
We do, Judge, because there's been no evidence presented at trial that would support anything but intentional in this case. I realize their defense is that he is not the one who did it, but the evidence at trial is that these
Can I tell you what my concern is? My concern is that without wantonly, the jury would not be able to find that even if the purpose wasn't to intend to kill, that it doesn't fit under intentional murder instead of wanton.
if the court is going to give a wanton murder, then we would request that it be a combination instruction, as is allowed under the law.
Can you tell me what you mean by that?
I'm sorry, an instruction that's on one page says.
Oh, yes, that's what I'm
intentionally
talking
and
about.
or wantonly. It's
That's
two
what I
separate
that's what
things.
I was referring to as the indictment reigns.
Yes. And the courts have commonly found that throughout the years that is a proper instruction, and that it is proper for a jury to find if they are considering intentional and wanton, that it could be under the facts of the case that some could find intentional and some could find wanton, but it is still a unanimous verdict.
Judge, we respectfully disagree with the Commonwealth under the facts of this case. One of the issues, Judge, separate wanton murder instruction. But the significance there is that the penalty results would potentially be different. So for a jury to reach a conclusion and have us not know whether they found it to be intentional or wanton prevents us from knowing how to proceed in a possible penalty phase. And I can go into more detail about why.
I mean,
that
it
is.
doesn't. It might change your strategy, but it certainly doesn't prevent you from being able to do that.
Judge, if in fact the jury found guilt under a wanton murder instruction, then it would no longer be an aggravated murder, and therefore 2 of the possible penalties would disappear. So that's a pretty significant difference.
Is that correct? I didn't think that that was true. If they found first, if they found wanton murder, not manslaughter, not just wanton murder.
I believe, Judge, that under the aggravating statute, 532.025, I'm going to pull it up, but
Thank you.
I don't expect you to take my word for
No,
it.
I mean, I do understand that you know what you're doing.
That the aggravating factor requires multiple murders that are intentionally committed.
I see. 532.035 is repealed. Ms. Jones Brown? Oh, you're looking too? Okay.
So it's 532.025 for the specific one.
Oh, I see.
Number
Aggravating or
6.
mitigating circumstances.
Yes.
Well, to that, I would say, Judge, that the law does allow accommodation instruction. I understand their point as to penalty. I would think that a way to cure this would be to ask in penalty, like to make that part of the penalty phase instructions if we get to that point, so that they
Yeah, we've
cannot
done that
impose
before.
the aggravator unless they have found that it was intentional.
It seems like it's inviting confusion, Judge, to give them instruction that defines murder and the actions in one phase one way, and then defines it differently in the second phase.
Well, it's not defining it differently, it's just splitting up the definition.
Yes, if we're comfortable with that in the second phase, I don't see why we wouldn't be comfortable in the first.
To split up the instruction invites the possibility that you could have 6 jurors who believe this was an intentional murder, 6 who believe it was a wanton murder. They're not unanimous on either count 1 or count 2 under the proposed instructions. Therefore, they can't sign either of those jury forms, but all 12 believe that this was a murder. That's not the state of the law. The state of the law is that it is a unanimous verdict, even though some might think intentional and some might think wanton.
And we would respectfully disagree that would be appropriate under the charges in this case, and specifically under the wording of the indictment, counts 1, 2, and 3. I can say, Judge, a lot of courts do give, the separate instructions just for the clarity, just so we all know.
And the Commonwealth objects to like intentional or wanton.
I mean, it is our
Separate
preference that
instructions.
this just goes forward unintentional. But I understand what the court's saying, so I'm not objecting to the wanton. I am just asking for it to be a combination instruction, and then on penalty, they would have to find beyond a reasonable doubt that these murders were intentional to get the 2 aggravated possibilities.
That is, in fact, how we did it last time, and there was just a case published that talked about that being appropriate.
I apologize.
We did that for are you finding it to be a violent offense?
see the analogy, though I don't know that it necessarily is controlling in our case, Judge.
No, I understand. All right, I'm going to come back to I'm going to do one or the other. I'm either going to do a separate instruction for one or combine it, and then so the jury to make a finding and sentencing as to intentional or one. Let me come back to that after we've talked about other lessers.
Yes, Judge.
All right. So what is the defense's position as to why a facilitation charge should be included?
Judge, I believe that the evidence itself has, the Commonwealth is asking for a complicity instruction. And if we look at the definition of complicity, which we included in our definitions, and the definition of facilitation, you can see how in any complicity case, facilitation is raised. And in particular, in this case, there has been more than a little bit of evidence suggesting that Mr. Rhodes may have been present and may have participated, but may not, in fact, have been the one who caused the deaths. And that is classic facilitation. The Commonwealth has sort of forged a trail for us by the manner in which they've dealt with the two co-defendants, where they concluded that, in fact, their actions, even though they were involved and present, merited a facilitation result. It is our position that the facts as presented at a minimum allow the jury to potentially reach that result for Mr. Rhodes.
Okay.
The Commonwealth objects, Judge. The way that the Commonwealth and various defense counsel choose to settle co-defendants does not then bind this court, who sat on this trial and heard this evidence, as to any certain theory. There has been no evidence in this case that the defendant was present but didn't do anything and just allowed it to happen. The evidence has been, this is sort of an all or nothing. He either was there directing all this and participating in this, or he wasn't. So facilitation is more of a disinterest in the outcome, which is distinct from complicity, in which somebody is engaged in and participating with a view towards the outcome that happens.
Judge, if the Commonwealth thought that the only issue on the table was an all or nothing, where Mr. Rhodes had actually committed the act, then complicity wouldn't be part of their instruction and part of their indictment.
I don't believe that there has been any evidence put forward other than a theory where this was Brice Rhodes' idea. So I don't think a facilitation instruction is appropriate. In that case, because of that, and because I just don't believe that from the evidence that's been presented, any juror could find that Mr. Rhodes' actions were facilitation. I think he's all in or nothing on that. I'm going to deny that instruction. First degree manslaughter.
We believe that the evidence, that a reasonable juror could conclude that there was an intent to injure and seriously injure, as defined by the statutes, without an intent to kill, which is a classic manslaughter in the first result, Judge.
And can you tell me any particular evidence you point to in reliance on that?
Yes, Judge. And again, we're talking about the role specifically of Mr. Rhodes, the discharge under the evidence of what appears to be a single shot is not necessarily an intent to kill. I'm not in any way saying that Mr. Rhodes was holding the gun or pulled the trigger, but I'm saying whoever. I don't think that that's sufficient to to necessarily automatically amount only to murder charge. And as far as Maurice and Larry,
Okay. And as for second degree manslaughter, same question.
well, Judge, we believe that the Commonwealth's indictment listed wanton murder, and the court has indicated the intent to go forward with instructing the jury on wanton murder. Manslaughter in the second degree is almost identical to a wanton murder and is contained within a wanton murder. The difference is what is the additional element of manifesting extreme indifference to human life. That is a nebulous concept that I think lies with the jury rather than us. And I believe that if a reasonable juror could find a wanton murder, that same reasonable juror could find manslaughter in the second degree.
Commonwealth, what is your position on both first degree and second degree?
Judge, I don't think that there's been any evidence in this case that would allow a first degree murder. The evidence that has been presented is that the intent in going to 41st Street was to kill somebody with a price on his head. That he stated, the evidence is that he stated that intent to the witnesses as they testified. He shot a man. They've already got the wanton instruction, which I think covers whether it was an intentional or just something that we in the court under these definitions consider wanton. There's just no evidence that he intended to shoot but not kill him. As for the second degree, I think that once you give a wanton murder, you have to give a man too. So I'm not contesting that one if there's a wanton given.
Okay. What I said is here.
I might be wrong about that, but I feel like there was a case a couple years ago.
I feel like the instruction's wonky though.
Unintentionally so, Judge.
I know.
Just one.
I'm sure.
And I have a copy of Cooper's that is.
I've got it.
There's another instruction in there that says and wasn't. It has the optional and wasn't in self-defense and stuff like that. But that's in the plan.
Actually, Judge, in Parker versus Commonwealth in 2007, so this wasn't even recent. With the wanton murder instruction should come instructions on lesser included offenses, notably here an instruction on second degree manslaughter.
Does somebody have their phone playing something? I keep hearing some like video playing or something. Okay. The way it's written is fine. So shooting him with a firearm and accidentally, it does match up perfectly with Cooper's. I was just looking at the wrong thing. Sorry about that. Okay. In reading the Second degree manslaughter, obstruction. Well, let me also hear any arguments regarding the reckless homicide and what evidence you believe supports a reckless homicide instruction.
I'll be honest, Judge, I didn't read any case law that required it. I'm used to it being given when a man two has been given. Usually they sort of go hand in hand. They have a lot in common as far as the mens rea and issues like that. So we proposed it, but I'm not aware of a case that requires it. We think it would still be appropriate along with the same argument basically as the manslaughter in second degree.
Unless the Commonwealth wants it included, I'm not included. No, okay, I'm going to deny that. I don't think the evidence supports that. And then that also means that I'm looking at removing recklessly from the definition.
If you're looking at the definitions for the defense, Judge, I think you had excluded manslaughter first, which means EED shouldn't be in there.
I did not include manslaughter first.
No, exclude.
Oh, yes. Okay. Thank you.
So I was just saying, there are other definitions we can take out.
Facilitation can come out. Well, I guess I'll come back to that because we haven't gotten to the other instructions. I think that's it for now. Okay. All right. Let me not get these all out of order. Numbered.
I'm sorry.
It's okay. I just might
But if the page number,
lose
Judge,
track.
take one out, then we're all confused because the page.
All right. Now, here's where I need the defense to tell me what comes after the reckless homicide instruction as to Christopher Jones. Is it more, is it like another presumption of innocence, or does it go straight to intentional murder?
I think you go straight to the next count, Judge.
Okay. And that is the intentional murder as regards to Maurice Gordon.
Yes, Judge, I believe so.
Miss Jones Browning, objection to how that's written. On the reckless homicide, since I'm not allowing it, I think that because there's going to be the second degree manslaughter charge, to me it makes more sense to have one instruction for intentional, one instruction for wanton, one instruction for man two. So that during closings, you're able to explain to the jury what the differences are.
I agree with the court.
Rather than trying to explain those differences later. If it was, if we weren't also having the second degree manslaughter put in there, I think I would think a little differently about it, like decide later. But I think as long as they're going to have to decide for one act and then act two and then act three, for as long as they're going to have to decide each one already, why not just have them go ahead and decide it based on a separate instruction for each one?
and this might not be the case where it really matters, but theoretically in a case where a jury is having trouble deciding intentional or wanton, how does that scenario account for the fact that they are allowed to convict on murder even if they disagree on the theory?
Mm-hmm. Yeah. Yeah, that's a good point. You all want to add anything on that for the defense?
Judge, I think that's raising an issue that is an unlikely event. I think the more
Famous last words.
Yes,
Mr.
Judge, it is
Griffiths.
great. I think the more likely result is we understand these. Hopefully, we understand them pretty well, right? I think that they're confusing to the average person, and setting them out with separate instructions is just a lot clearer to the jurors. It makes a lot more sense to the jurors.
It might, and I understand that, but I agree with the Commonwealth. I think it's too great of a chance of them not understanding and not knowing. You know, if some of them think it's wanton and some of them think it's intentional, we'll be in a rough spot.
Would that be? Could that be resolved by an additional instruction or an admonition?
It could, but I don't really see the point of that. But I guess the question for me really is, should we have a separate instruction after that? Like, if you have found the defendant guilty under instruction number blah, 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 do you unanimously agree it was intentional? And go ahead and knock it out prior to sentencing.
I think that would. I think that would work, Judge. I think that
Okay.
would fix it.
All right.
So
And I'll
that-
go back and look at that other one we did for how we put that in there, and I'll let you all know what it is.
And would that then go sort of near the end?
Yeah.
One of the last ones?
It'll be like the intentional or wanton instruction, and then the next one, if you found guilt under the last instruction, and then the language, do you believe it was wanton or intentional? And then very next thing, if you did not find the defendant guilty under instructions 1 or 2, you may find him guilty under instruction 3, if and only if for the second-degree manslaughter.
Are these going to be numbered like 1A, 1B for murder
Yeah.
and manslaughter
Yeah.
for Christopher Jones?
Yeah,
and then
I'll
2A,
rewrite them
2B,
all.
3A, 3B?
Yeah. And so, go ahead.
I was just going to say, we tried to do that. Like the ones I have at the back, Judge, are by count, and that may satisfy what the Commonwealth is talking about.
That's how I'll do them. I'll do them by count.
Yeah, 'cause I think if you do A and B, it helps the jury not find him guilty of both. I mean, not.
All right, let's move on as to the count with regards to Maurice Gordon. Are anybody's arguments any different? If not, I'm just going to rule the same on each one.
No different.
The only difference, I mean, the facts are different, obviously, Judge. I think Maurice Gordon and Larry Ordway, those two are pretty much identical as far as the arguments go. There is additional evidence regarding actions of multiple people rather than a claim of actions of a single person,
Okay.
which I think would justify the facilitation instruction on count 2 and count 3.
I understand. Ms. Jones-Brown?
I don't have any additional arguments to what I've already made. And we would continue to object to facilitation.
So from my perspective, the testimony, there was not anyone whose testimony supported an idea that that Mr. Rhodes was facilitating someone else in committing those crimes. Can you point me to what you would rely on?
Specifically, Judge, just the testimony that literally said things like everyone stabbed, rather than just.
Well, the testimony I heard was like, Brice made me also stab. Was there a witness who testified to something other than, being told to stab the person after they had already been stabbed?
Even the witnesses who testified that two other people that weren't here, that we never saw, one who was identified, one who was not identified, also were involved and also were stabbing. And both of the witnesses called to the Commonwealth said that two other people stabbed both of the victims in count 2 and 3. So we believe that that would also support a possible verdict of facilitation rather than.
Okay. I do not believe that any evidence that was produced would allow the jury to find Mr. Rhodes guilty of facilitation to murder or first-degree manslaughter for the same reasons, that there was not any testimony other than testimony that it was his idea, that he was directing the actions of others. So we need to make additional record with regards to Larry Ordway, or is it the same argument?
Same argument.
Okay. Same ruling. And then we get to tampering. Are your all's tampering instructions the same?
They're largely the same. They just have evidence. I listed some items of evidence.
I don't. That's fine, Judge.
I'm relying on the case.
I wasn't.
Packet versus
If
Commonwealth.
that's fine. That's
Yeah.
I'll use yours as it is.
I do want to change, have an amendment to mine. I would like it to say and or instead of and. I believe that the jury could find any one item was tampered with and it would support this.
Oh, you mean on the final line of A?
Yeah, so it would say
Yeah, I gotcha.
and
Or the
blanket
backseat of
or-
the blue monster. I'll allow that. Okay. And then abuse of a corpse. Looks like they are largely the same, although the Commonwealth is a little more like fact, just barely a little more fact specific.
You don't object, Judge, to the Commonwealth.
Okay, we'll do that for each of them. Okay, so now we get to the other instructions. Let me briefly go back to definitions. So the Commonwealth's definitions are just intentionally, complicity, and official proceeding for the intentionally, wantonly, physical force, deadly physical force, serious physical injury, and complicity.
I think we can get rid of the serious physical injury due to, that was for manslaughter in the first degree.
That's correct, Judge.
And so I think I could then just add in official proceeding. So the definitions would be for intentionally, wantonly, physical force, deadly physical force, complicity, and official proceeding.
I think that's right.
Force from, which is, where is that?
Deadly physical force. I think that might be from,
That might be a man one.
that's what I was thinking.
I believe that's why I put it in there.
No.
I think it's from extreme emotional disturbance. So removing that due to removing manual.
It does. It does.
The need for that.
Okay. So then add in official proceeding. Okay. All right, and then at the end of each individual instruction, the Commonwealth has presumption of innocence, which we're putting at the front. We won't need it there. Both of you have unanimous verdict. Let's see. Okay. So let's talk about this right to remain silent instruction. Any objection to that?
I have it at the end of presumption of innocence, but I don't object to it being separated out.
I gotcha. Then right to remain silent. All right. Let's go ahead and talk about the spoliation potential instruction. The defense is requesting a tainted evidence instruction.
Yes, Judge. We believe that primarily applies to the car seat, lack thereof. There was a lot of testimony. There was admission by the police in this case that that they did say under oath on 2 occasions, as well as 4 years later, 3 years later, excuse me, in this courtroom, that there was a car seat, and it was included in the police report. And now, of course, the court is well aware we have not seen one, and they're saying that there isn't one. There's different versions of this instruction, Judge. This is the one that I put in. We wanted to change the language to missing. Obviously, that's fine with me too, but this is the one I thought best matched the facts in the case. It's frankly less confrontational in some sense. But so I chose a version form that I thought would work better with the facts that we heard and the evidence in this case.
I mean, the court's very well aware of what was testified to. And I think an inference or an argument on their part can be made to the record keeping of the police department or the procedures of the police department, or even if they want to shoot for the credibility of the lead detective, but there is no evidence that the backseat was recovered and then lost. So we would object to this.
here's part of the problem. Part of the problem here is that I don't feel it was ever established whether a back seat ever existed. That's the problem I'm having, is that it is not as though we know A, there definitely was this piece of evidence, and B, then it was lost. In fact, I think it's statutorily they're not, if it did exist, it potentially could be a violation of the law if it was destroyed or not kept, if it contained bodily fluid. KRS 524-140 talks about how if an item is found that contains biological markers such as bodily fluids, it is a violation of the law to dispose of it. The problem is, I don't really feel like it was ever established that it did in fact exist.
I think the question to me, it revolves around the reason I submitted the instruction is I believe that the court and the jury are able to rely upon sworn testimony. And the officer in the case, Detective Tonelli, testified under oath at the preliminary hearing. And he testified that there was one. He testified under oath at the grand jury that there was one. And then in this courtroom, 3 years later, told Judge Cunningham that the biggest piece of evidence that they had to bring was the car seat. And actually, he may not have been under oath that third time, Judge.
And it doesn't matter. But here's the issue that I'm having, and I'm leaning towards allowing the instruction, but the issue that I'm having is that I just don't really feel like it was ever firmed up. You know, Tonelli's testimony was basically, yes, I said that, I was wrong. But I don't know. I really wish this had been a pretrial hearing, to be honest. But I don't feel like there was ever any testimony that it did in fact exist. Like to me, Tonelli's testimony was more like, I thought we had the physical back seat, but we never did. But I don't feel like it was very clear. And frankly, I don't really think that the defendant should be penalized when it wasn't clear. And in fact, there are at least 3 instances of Tonelli saying that there is a back seat.
Well, Judge, at the PC hearing, he said, we believe the seat was located. We are waiting for our forensics analysis to make sure and confirm that. He qualified it. And that is what he believed up until he got the CSU report.
Which said?
Well, which listed the items taken from the dumpster and did not include the back seat.
And when was that?
Not until that fall.
Post grand jury presentation?
Now, 3 years later, yes,
yeah,
we were just sitting here and we were throwing out ideas. I mean, it was just like this.
I know. But, you know, if you're the defendant and this detective is twice saying that there is a back seat, even though it's not listed in discovery, and then 3 years later he mentions bringing it into court, I think it was reasonable for them to rely on thinking there was a back seat too.
But then that was cured a week later when we came to court. And this was subject to extensive litigation under Judge Cunningham.
Oh, it was?
Yeah.
Was there a missing evidence instruction argument?
No, but I was accused of prosecutorial misconduct. I had to respond to a motion about this. It went on for quite a while.
The biggest problem I have is that I still don't really have any conclusive testimony about whether it ever did exist. You know, all these CSU people in here. Why not just have someone definitively say, no, we never had a back seat?
Judge, I feel like that was conclusively testified to because the defense asked it of almost every witness to testify. And it was not found in the dumpster. Now, I thought what the court was saying was, we don't know if it was ever in his car. And that is something that we don't, like, maybe it was taken out 3 years earlier. Maybe he bought the car with no back seat.
Right.
But every police witness who testified when asked said that they recovered no back seats. and the person who would have what Detective Sinelli was testifying about at the PC hearing and the grand jury was the dumpster search. And Detective Peters and Rebecca Kimmer from CSU testified that no backseat was recovered in the dumpster, although they initially thought something might be a backseat.
What evidence rule is missing evidence covered by? There's a Cooper's heading somewhere in there, Judge, about it. I understand the court's looking it up. Judge, just to respond, for what it's worth, I think this ambiguity is why it ended up as a truth. I mean, that's kind of what I'm leaning towards is like, the problem is it's been left pretty unclear. And I think that should lean towards the defendant. Let me look at this 2.06. But there was not ever a spoliation or missing evidence instruction before now, right? No. Okay. So we had no argument on that point. I'm going to allow the instruction. I do think that based on the evidence as it came out, and I'm looking at the case law in Beglin and coincidentally a case called Ordway, the Commonwealth. So it says the court held there is no special or unique threshold of proof involved, so long as the trial court is satisfied that a reasonable juror could believe from the evidence the substance of the first clause, the instruction is in order. And I do believe that the way that the proof came out, a reasonable juror could believe that the backseat existed at some point. So I'm going to allow that instruction. All right. And then we have the unanimous verdict instruction. They are substantially similar. In fact, I think that the Commonwealth is just a little bit longer, but they're pretty much the same. Does anybody have any position on whether it should say the verdict of the jury must be in writing, must be unanimous, and must be signed by one of these foremen, or actually foreperson, or the verdict of the jury must be unanimous in finding the defendant guilty or not guilty and must be signed by one of you as foreperson. You may use the form provided at the end of instructions. Anybody have a position on that?
No, Judge. I mean, I'm not looking at Cooper's on it. I think whatever the
Okay.
pretty close.
All right. Then we have our verdict forms. So these will be as we discussed for the first 3 counts of the indictment will be A, B, or C. And then the others will just be guilty or not guilty. So our jury, oh gosh, they're already back. Let me get these written up so you all can have about 5 minutes to review them, okay?
Yes. And Judge, we found some typos. Do you need us to communicate those, or do you already have those?
I don't think I already have them, but when I put this all together, we'll see if they're still there or not.
Okay.
Thanks.
All right, you all can, it's going to take me about 10 minutes, so we'll take a 10-minute break. John, would you mind to let the jurors know it's going to be about another 10 minutes? Thanks.
Okay, a 10-minute break. Let me see. I really thought that I thought that the defense would mount a case, but it doesn't look like it. So this is a bit surprised. I thought that I had a doctor appointment, which I had to postpone from August 31st because I had seems like it was a verdict that day too. And no, it wasn't a verdict. It was supposed to be the Jared Lysick preliminary hearing that I was going to go down for, and then it turned out to be canceled. And so it's like, I canceled the appointment for nothing. And now we're going to be on verdict watch. If we're not still having closing arguments, I expect we'll be verdict watch by that point. So I think since it's not critical, I'll probably call up and say, I'm stuck in court today. Okay, so it's virtual court. Let's see. Okay, it doesn't look like the Elijah McClain murder trial still going on over in Colorado.
You're a lot like this chocolate deluxe bar.
Full of energy and ready for whatever the day has in store.
Let's see, I was trying to find if the hearing was still going on for Ruby Frankie. It looks like it is. Let me take a look. I think we'll save that for later during verdict watch. Let's see, do we have anything 10 minutes or under here? Oh, here we go. KUTV, which is the local news station, has it cut down to 10 minutes. So let me just get this set up here.
Case involving Jody Hildebrand are intertwined with this case. Our office will not be making additional statements to the media at this time. For further information, we refer you to the pleading document that support a guilty plea and the factual basis and the plea terms in that.
What are the plea terms? Just basically.
And I can do that also. Like I said, We'll be happy to, if you contact our office, we'll be happy to release this if we get it up before the court gets it up. But the plea terms are relatively simple. She pled guilty. The state agreed to dismiss the two other counts. She agreed to serve a prison term, and that the term for the 4 different counts will run consecutively and not concurrently. And she agrees, I'll read this one verbatim. She agrees to testify truthfully against Jody Hildebrandt, and in return, the Washington County Attorney's Office agrees to remain neutral regarding future hearings before the Utah Board of Pardons and Parole.
And how long is the plea? How long is she serving those sentences?
So those sentences, each count is a 1 to 15 year term, but under the Utah sentencing guidelines, that's all flexible and up to the Utah Board of Pardons and Parole.
Will they know that more in February during her sentencing?
No. So in February, she'll be sentenced, and then the Board of Pardon and Parole will hold a review hearing, and that typically happens about 6 months after people go to prison. And at that point, they set the date for the next review hearing, but that's all up to them and how they handle that.
Any time served kind of count towards that?
Typically, almost always time served counts towards stuff.
Can you go into the decision to remove 2 of those counts of child abuse?
I can't get into any more on that until both cases are resolved and appellate times have run.
And you said she'll be testifying against Hildebrandt?
She agrees to testify against Hildebrandt.
Okay.
So
Thank
thanks, you guys.
Okay.
So again, just to recap for you, you just heard from the prosecution about those 4 different counts. So the charges 1, 3, 5, and 6 that Ruby Franke agreed to plead guilty here. And you just heard that she also agrees to testify in that upcoming hearing with Jody Hildebrandt if things go that way. Now we're waiting to learn more about what happens next. As of now, things were looking to be scheduled on December 27th, but as it pertains to Ruby Franke, you heard those 2nd-degree felony aggravated child abuse charges. She did say at the end when they asked her how she was going to plead with that final charge, she did mention things, I'm paraphrasing here a little bit, as with my deepest regret for my family that I am guilty of that charge. Relatively quick hearing, took all of that of about 5 minutes. There was a lot of this between the defense attorney and the prosecution to come up with this plea deal. But again, we will learn more, obviously in the coming months, about how long in terms of prison sentencing that looks for Ruby Franke. But everything really quick here in St. George today, as we expected, hearing from the defense attorney last week that they were going to go forth with a plea deal. And we did have a little representation from Ruby's family in there. When she came into the courtroom, she looked back at her sister, her mother and father, gave a little smirk or a smile, and then went forward with the proceedings. So you heard it there from the prosecution, Lincoln and Ron, but as we have it here, things are wrapped up in terms of Ruby Franke, in terms of what she's going to jail for. Just don't know for how long.
And obviously, the prosecutors think this is beneficial, I guess, for everyone involved, but especially for their prosecution against Jody Hildebrandt.
Well, you're right. And that's what her attorneys also referenced in that statement they shared with me at late Friday afternoon. There was a lot of pointing towards what happened with Jody Hildebrandt and what took place over the last 3 years as it pertains to Ruby Franke. Isolation from her family, her husband, of course, who has now filed for divorce, and ultimately what happened with the children. Of course, we're keeping the children kind of way out here in right field in all of this to protect them and the future and their integrity. But a lot of this had to do, as we understand, what took place over the last 3 years, specifically between Ruby and Jody. So now we wait to see what happens with Jody. Same 6 charges. Will the plea deal look similar? How will things be changed? I think it's interesting that it's 4 out of the 6 charges, and you just heard from the prosecution that he will not get into the reason for dropping out on those 2 charges. But in terms of those charges, 1, 3, 5, and 6, pleading guilty, there you have it, those four charges of aggravated child abuse here, both 2nd-degree felonies. And then again, we will wait to see what that looks like for the future of Ruby Franke.
And Brian, I wanted to clarify, make sure I heard him right. He said those sentences, whatever they are, would run consecutively, not concurrently. Is that correct?
Yes, consecutively, from what I understand. And I believe that was also mentioned in the court. From my quick hearing of that as well, I believe they will be consecutive.
And a lot of times in cases like this, if you're testifying against a key defendant, your prison time gets cut. And I guess that's a possibility here too.
Well, not to speculate, but that's obviously the interesting part here when you have these two hearings separate, Ruby first, Jody second, and then of course the statement here from Ruby's attorney kind of shifting the focus towards Jody, and now we know that she will testify against Jody Hildebrandt. There is, you are seeing that pointing of the finger, so to speak, towards the other individual. So there is a chance that it could be all of those charges for Jody Hildebrandt. It could be one less, but I'd find it hard pressed to see it less than the 4 counts that Ruby ultimately pled guilty for today.
Okay, Brian Schnee, thank you so much. We were told earlier as well that Ruby Franke said in court no one had pressured her to do anything into this plea agreement. Were you in court for that as well, Brian?
Yes, I just stepped out very quickly to talk to you guys. She said a couple of things. She did say, in terms of the proceedings, she did acknowledge that she's ready to move forward. She said that no one was pressuring her, no under the influence of anything. The judge, John Walton, did ask if there's anything outside of the plea agreement that he needs to be aware of. She said no. And then again, towards the end of reading off that, admitting guilt to those 4 charges, did really put forth an amount of regret towards her family. So as we learn more, hoping to speak to other folks here today about what this means for the future, obviously of Ruby Franke, but her business partner, Jody Hildebrandt, at one point. So as we learn more, we'll bring it to you both on air and online, and of course our social media platforms.
Okay, Brian Schnee, thank you very much for being with us. Big developments in this case. Of course, we've been covering this all along the way. And if you want to catch up on some of our past stories, you can go to KUTV.com. We have it all there for you. Now, coming up here at noon, and about 40 minutes from now, we will have more in-depth coverage of what happened in that courtroom today.
Yeah, hear from our other reporter there, Amanda Gilbert, as well. You can always find our past reports at the KUTV YouTube page as well, and on KUTV.com. This is a story we'll be following for the entire day, so be sure to tune in for the very latest.
Okay, that looks like it was 2 minutes shorter than the projected time slot. Looks like we are almost... Okay, now we've got a countdown clock over here, so it just ended over on long crime, so theoretically the jury should be back to, I presume we're going to have closing arguments here. Let's go back over here. Meanwhile, I see, Oh, no, that's Fox. Fox will get you demonetized. A drunk driver slammed into the presidential motorcade. Biden is supposed to be unharmed. I guess that was yesterday, or last night, I should say. Oh, we had a case out of Los Angeles. A 4-year-old died in a road rage shooting. The Pope has approved same-sex marriage blessings. Or at least I assume it's marriage. It says same-sex blessings. Let's take a look and see what else is out there in YouTube land. Oh, I see a interesting short. According to this short that I'm seeing, the Snow White live action from Disney is scrapped, but I'm not seeing any verification of that. That would be huge if that were the case, because it was a very expensive project. Not seeing anything at the moment beyond a few tidbits and a couple of stories which are on Fox. Let me take a look and see if there's anything interesting on the local news. Looks like there's a fun seasonal story about Jimmy Stewart being in a local movie church Christmas film. I remember when I was working as a production assistant on a film shoot down at the BYU Motion Picture Studios, I stumbled across the set design plans for that, and the set designer was very happy so that they could add that to the archives. UHP seizes nearly 35 pounds of drugs in southern Utah stop. Let's take a look at that. Cedar City. I've been there many times. An illegal window tint started an investigation that led to a large drug bust in Iron County on Sunday. The investigation began when Utah Highway Patrol troopers spotted a Dodge Charger on I-15 just before 11 p.m., driving slowly in the left lane with significant tint on its front driver's window, a police booking affidavit states. The passenger window side had no tint. 2 women were in the vehicle along with 2 children, ages 2 and 15, laying down in the back unrestrained, the affidavit states. A trooper attempted to question the driver. The driver provided a name and date, which was later discovered to be false, that did not return out of Utah. The female struggled to spell her own name. That's surely a sign of a problem. And give us a description of the trip the group had taken. She also struggled to determine ownership of the car insurance status and did not know what year the vehicle was, which had only been registered 3 days prior, says the affidavit. The trooper became suspicious of further criminal activity and called for a drug-sniffing dog to do a walk around. The dog indicated there was possible presence of drug in the trunk, the affidavit states. If a black bag in the trunk, we located 12 packages of blue M30 pills consisting of fentanyl on the floor of the back seat, behind the driver's seat, and in the rear near the children. We found multiple loose fentanyl pills. Oh, good grief. Underneath the driver's seat, I found a sealed box containing 2 vacuum-sealed kilos of unknown powder and a garbage bag with 2 more kilos. Throughout the container in the front seat area of the vehicle, we found multiple rubber-banded stacks of U.S. currency, the affidavit states. In total, 12 packages of pills were combined for a combined weight of approximately 25 pounds, and 4 vacuum-sealed packages had a combined weight of approximately 9 pounds of unknown powder. Throughout the vehicle, we located approximately $7,400 of currency in various denominations, the trooper wrote in the arrest report. The driver, Andrea Carbajal, 23, was booked into Iron County Jail for investigation for more than a dozen charges, including 2 counts of drug possession with intent to distribute, money laundering, and 2 counts of child endangerment. The affidavit states Carbajal was driving with a revoked license for DUI and was on probation out of California for drug trafficking. It was not immediately known whether the passenger was also booked into jail. It doesn't specify who the trooper was. I have met one trooper down in who lives in Parowan, and so it might have been him. He's the next door neighbor to one of the rental properties which I helped my friend oversee. And he was actually responding to a traffic stop along the freeway when he got hit and pinned under a car by a passing motorist, and very nearly died, but he's managed to make a full recovery. Let's see. This 10-minute break has been a lot more than 10 minutes. Oh, let's see. This is running behind. Oh, but not. Okay, the 10-minute break has been Over 25 minutes. Okay, let's see. That's it on the local news feed. Let's take a look at Twitter. It's funny, the logo is changed to X, but it's still twitter.com. Okay, interesting. This is from a couple of days ago. It says Bill Gates and Bill Clinton say they will leave the United States if the Epstein client list is released. That kind of indicates that I thought it was released. Oh, client list as opposed to the Lolita Express list. No doubt to a country without an extradition treaty. And that would be interesting. Would Bill Clinton get Secret Service protection in a country with non-extradition? And if it turns out that he were wanted for criminal charges, I don't know if that's really going to happen. But let's see. Not much there today. Let's see. Let's see what we've got in the way of short videos on my watch list. Thank you, Kat. I've got a lot of great videos for Verdict Watch, but it kind of destroys the flow, and I really expect that we're going to get in. Maybe we'll go to a let's take a look at what else we've got in other courtrooms. You've got probation violation in Kristen D. Simmons courtroom. Let's see what else we may have. Oh, let's see what Judge Middleton has. Landlord-tenant matters. Well, probation violations, I think, is what we'll go with. Just as soon as
Okay, on the record in the matter of the people of the state of Michigan versus Jabril McCullum, file number 22-01756. Appearance, please.
Assistant Prosecutor Peter Petrosky and
Assistant Public Defender John Lee on behalf of Jabril McCollum.
Okay, this matter was scheduled for a probation violation hearing. And we had reset this because he needed to have an intake done, had that intake. And are we having a hearing today?
No, we are not.
You want to plead guilty, sir?
Yes.
Raise your right hand. You solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury. Thank you. You can put your hand down. You were previously arraigned and advised of your rights as it relates to probation violations. And the violation again on this matter is that you tested positive for cocaine with the result of 573 nanogram. And you understand that if you're found to be guilty of violating your probation, could be sentenced to a term of jail time. You understand that your probation can be extended, or you could have other sanctions or oversight imposed if you're found to be guilty of violations. And as to the violation that you tested positive, you're willing to give up your rights and enter a guilty plea to that violation? Anybody threatening you to get you to give up your rights? Any promises being made to you in exchange for a guilty plea? Violation number 13, that you tested positive at EverHealth on October 5th for cocaine with a result of 573 nanogram per milliliter. How do you plead? Factual basis, please.
Okay. Mr. McCollum, were you sentenced to a period of probation in case 22-01756? And as part of that probation, were you ordered to refrain from the use of alcohol or controlled substances without a prescription? Yes, sir. And do you deny that and were you also ordered to undergo random testing to check to make sure that you were avoiding those substances? Yes, sir. And do you deny that on October 5th, 2023, you did in fact test positive for marijuana and cocaine? So you do admit that you tested positive on that day? Yeah, it wasn't.
I can't hear him. We can't hear you.
I'm sorry. It wasn't voluntary.
What does that mean?
I have bought some marijuana. I got some marijuana. I do have my marijuana card. Just this week, I had to down on my blood, so I have bought some weed off the street. So that can be the only cause for this. I will not gamble and try knowing that I was this close to my discharge, I would not gamble and take the risk. You know what I mean? So I don't. That could only be the cause of it.
So when you just said under oath that you use marijuana, you weren't aware that you used marijuana? You were I'm sorry, that you used cocaine. You weren't aware that you used cocaine?
No, I did not actually use cocaine. Whether it could show up in my testing is if it was only marijuana. I know that's a strong allegation. That's the only case. That's the only thing that makes sense.
Well, you know, we can pull your results and see if you had marijuana in your system too.
Yes, okay. Yeah. I do have my marijuana.
Your Honor.
I do have my marijuana.
He's got a medical marijuana card. He does suffer from some disabilities. However, on this occasion, he went outside the chain of what is a legal way to purchase and use marijuana, bought marijuana on the street, voluntarily consumed the marijuana on purpose, not realizing that it was laced with cocaine. He did test positive for both marijuana and cocaine.
What do you mean you didn't realize it was laced with cocaine?
You
didn't, it just felt the same when you were ingesting it?
Yeah, I wouldn't say, it was like, it made me like nauseous, but I want to say because I was already under the weather. So I'm thinking that the nauseous was just coming from like the throat because I had already been throwing up and I had caught a little bug. So I'm not even thinking nothing of it. I knew it was kind of like different, but I'm not, you know what I mean? I'm not assuming that was the case.
So this is the concern that I have. The concern that makes me less inclined to buy this story is a case where you pled guilty to use of cocaine. And this is not your first violation for use of cocaine. This is not the second violation for use of cocaine. This is the third violation for use of cocaine, but your fifth total violation on probation. This is your fifth probation violation.
I thought this was just my third. I'm sorry about it.
No, every time you're arraigned doesn't mean it's just one violation. If your violation sheet lists more than one violation, we arraign you on each violation, possibly at that one time. But this is your fifth total violation. 3 of those violations that you've had were for the use of cocaine, and then the underlying charge is for use of cocaine. For you to come before me today and say, oh no, I didn't use cocaine, I smoked marijuana and I didn't even know it had cocaine in it. You're someone who has experience with cocaine. I don't believe that you could smoke marijuana and not know that it was laced with cocaine. I don't even think that you believe that you were just purchasing marijuana. There's a legal way for you to get cocaine and you didn't do it. I mean, get marijuana, you didn't do it. And now you want to tell me that you went on the streets and you bought some marijuana and it was laced and you didn't know, and that's the only possible way that it could have been in your system.
And this case, yes, ma'am. I have not used. I have not used at all.
Anything else you want to add for your factual basis?
Nothing further.
The court is satisfied with the factual basis. I'll accept your plea. Find your plea to be made freely, voluntarily, and intelligently. The violation recommendation states, again, this is your fifth violation. It says that this is your third violation for using cocaine. You had one on the 5th of January, one on the 9th of May. In previous violations, it says you have been given treatment in an attempt to help you stay clean, but you continue to use. It says you have been on probation for 10 months with little improvement. Your probation officer suggests terminating probation and sentencing you to a term of jail time, which I agree with. You can make allocution.
Thank you. Your Honor, we would ask the court to consider that it is indeed a very real struggle for Mr. McCollum. He's given an effort. Clearly there have been some failures, but even as a As a father, Your Honor, he contributes significantly to the life of his 4-year-old son. He has joint full custody and has him 3 or 4 days a week. So he is a contributing member in his family, overcoming significant odds, having been diagnosed legally blind. So we would ask Your Honor to consider a method and or a way of admonishing Mr. McCollum that does not involve taking him out of his household and putting him in jail, perhaps an extension of probation time and or
He's already used this excuse before. The last time he had a violation, I don't know how these got in my system. This is not the first time you use these same excuses. I don't buy it. You know how they are getting into your system. We're not going to continue to go back and forth with us supervising your unwillingness to make a change in your life. If you want to ingest poisons and damage your body and potentially put yourself at risk for death or being strung out somewhere, I don't see how those things are contributions that are meaningful to your child. I don't see how. Where do you work? How are you making meaningful contributions to your children and you don't have a job?
I take care of my son every week. I got to take him to school. Well, not me, but I have to find rights. It's not like the mother helped me. She's not around. So it's like I do everything by myself.
Well, you know, you're not paying for it because you don't have a job.
Yeah, I use my income. I know how to manage my income. I get like $900 a month.
You're not making meaningful contributions to your children if you are using drugs and you're using the money that you're getting on this limited income for drugs. You're trying to tell me that you, with this little bit of money that you just told me you get, that you take care of yourself and a child, and then you still have money left over to buy cocaine. Yeah, you said that to me before when you had benzos and cocaine in your system. You said you had no idea. Doesn't know how these substances got into your system. And that was for the second time that you used that excuse. Today will be the third time. And so because you can't figure it out, what we're going to do is going to go ahead and terminate your probation. You're going to be sentenced to 7 days Ingham County Jail. You'll be remanded immediately.
So I'm gonna take it back. Right, yeah. Take it out.
We ready with Tijerina?
Yes, we are.
On the record in the matter of the people of the state of Michigan versus Anissa Tijerina, file number 23-02267, counsel appearance.
This is the public defender, John Lee, on behalf of Anissa Tijerina.
Okay, today was the date and the time set for pre-trial and operating while intoxicated. And we reset this because there had not been a report received yet. Was there an offer extended?
There was, Your Honor. We would extend our offer would be to amend the charge to an operating while visibly impaired.
Okay, did you find one accept that offer?
Yes, she does, Your Honor.
Is that correct, Ms. Tijerina?
Yes, it is.
Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes, I swear.
Okay, thank you. You can put your hand down. Ms. DeJarina, you're being offered a reduction in charge to plead guilty to operating while visibly impaired. You have the right in that matter to proceed to trial, and you have the right to a jury trial. At the time of your trial, you have the right to the presumption of innocence, so you're innocent until proven guilty. Do you understand that?
Yes, I do, Your Honor.
You have the right to require the prosecution to prove your guilt by proving each element of the charge being brought against you beyond a reasonable doubt. You have the right to remain silent at trial and not have silence be used against you. You have the right to see, hear, or question any of the witnesses that the prosecution intends to call against you. You have the right to call your own witnesses to your trial or present evidence that you believe further defense to the charge being brought against you. Do you understand those rights?
Yes, I do, Your Honor.
And are you willing to give up each of those rights today in order to accept the offer?
Yes, I am.
Has anybody made any threats to you to get you to waive those rights?
No, Your Honor.
Has any promises been made to you in exchange for a guilty plea?
No, Your Honor.
Are you currently on probation or on parole?
No, I am.
You understand that a guilty plea could result in a conviction that may have impact on your travel or your ability to travel or immigration status that you may be seeking?
Yes, I do, Your Honor.
Understand that a guilty plea could result in a conviction that you may need to report to your current employer, or you may need to report this conviction on a future job application.
Yes, I do, Your Honor.
As to the added count 2 of operating while visibly impaired, how do you plead?
I plead guilty.
Are you pleading guilty because you believe you're guilty?
Yes, Your Honor.
Actual basis.
Thank you, Your Honor. Ms. Tijerina, on or about January 22nd, 2023, were you driving in a vehicle on 312 South Hayford Avenue in the city of Lansing, County of Hingham?
Yes, I was.
And do you have any reason to dispute that at that time, your blood alcohol level was greater than 0.08 grams of alcohol per 100 milliliters of blood?
No, I do not dispute that fact.
No further questions, Your Honor.
Any questions from the prosecution's office?
No, Your Honor, thank you.
If the court is satisfied with the factual basis, I'll accept your plea and find your plea to be made freely, voluntarily, and intelligently. The matter will be set for sentencing
February 6th at 9 a.m.
February 6th at 9 a.m. Today is Monday, so no later than Wednesday at 4. I'm sorry, I'm gonna give you till 2:30 Wednesday. You need to report to the 5th floor of City Hall at our probation department, okay? You need to report in person.
Okay.
And then they'll get you set up for your pre-sentence report interview. Your attorney or you need to provide probation with a copy of your assessment, okay?
Okay.
Otherwise, you'll be ordered to undergo a new assessment before sentencing, and you don't need to unnecessarily accrue that expense, okay?
Okay. And you said I need my assessment to the 5th floor when I go to probation?
Yeah, you can, your attorney can either forward it to them or you can sign a release so that they can get it, but you need to make arrangements so that they can get your assessment so that you don't have to get a new one before sentencing, okay?
Okay. Thank you.
Do you have any questions?
For February 6th, will it be in person or over Zoom?
You can appear via Zoom.
Okay. Thank you, Your Honor.
No problem. Any other questions that you have?
No.
Any additional matters for the record, counsel?
Thank you.
Thank you. You're all set.
Yeah.
Listen, if you don't have anybody out there waiting for court, do we? Okay, sounds good. Okay. Was this Mitchell? On the record in the matter of the people of the state of Michigan, versus Evan Patrick Mitchell, file number 22-02861. Council appearance.
Okay, Chelsea, on behalf of the people.
Okay, Mr. Mitchell. Looks like you're back so soon.
Yes, unfortunately.
Yeah, it's unfortunate. It says here, probate, a request and summons for probation violation that you failed to do random testing at cognitive consultants back on November 27th and December 4th, according to my amended order from just one day prior, November 27th. And that you were unsuccessfully discharged from IOP for lack of attendance. I have here something that was added to the file from probation indicating on December 12th, 2023, that you failed to appear for drug testing. So I'm assuming that's going to be another violation forthcoming. So you have the right to have a contested hearing. You're well aware of all these rights because we just did this 2 weeks ago, but I'll repeat it. You have the right to be represented by an attorney at your contested hearing. If you're found to be in violation of your probation status, your probation can be revoked, and you can be sentenced to a term of jail time. I can almost promise you that if you're found to be by violation, this will be the 7th and 8th time, that you will more likely than not be sentenced to a term of jail time. Do you understand that? If you're found to be guilty of these violations, you will more likely than not be sentenced to a term of jail time. Do you understand that?
Yes.
Did you want to request an attorney to represent you?
Yes, I do.
To grow into a plea of not guilty on your behalf. Set it for a probation violation hearing, and then you can meet with the public defender today, okay?
Okay.
January 9th at 1:30 in person. You have any questions today?
No.
We'll get your copy of your notice, and then you can meet with either Mr. Raleigh or Mr. Lee. They're both back there. Okay? So, for today. Melton? No? Mr. Melton didn't appear?
I'm not sure if that's the end of court or if that is just buffering. The courtroom looks rather empty. Let's go back to our seal of Kentucky and I just saw somebody move in front of the camera, so I'm hoping that means that we were actually going to have something happen. But we'll take a quick look and see what else we've got. It might be short. Let's see. Let's see. Do we still have? Oh, let's try refreshing that. I thought we were going back to the courtroom. I mean, that we were going to go back to being on the record. Let's go to Judge Boyd down in Texas.
You could just hear him go.
Is anything happening? Or let's see.
Yes.
It's like they just started.
Hello? Yeah.
All right, just have them pull they'll need to pull the file and then we'll take it up. Thank you.
Oh, what happened here? Let's try refreshing. Oh, it's somehow my computer
Because
spontaneously
this is a
jumped.
case that has a couple of indicted cases, and then there's also an MTR, and there's a couple unindicted cases. Due to some of the workings, the indicted and the non-indicted may not be proceeded on.
Okay.
So we're asking for a reset. I have sent off an email last week. I resent that email today, have not got a response, and so I'm gonna have to follow that up. I guess personally, I know that Mr. Bartholomew has also personally spoke with McCluskey, and he has not gotten back to him also. So it's one of those cases that.
All right, I'm gonna help people communicate better. Ms. Ferguson, bring this back for a jury trial in January 2nd week.
That'd be fine, Judge.
Well, Judge, it might not work out for me because I got a lot of cases to take that week. Can we go a little later in the month?
No, we'll see where we are. All right, January 9th is gonna be your jury trial date.
Okay.
All right, and we'll put, no, Merry Christmas, Happy New Year. All right, when you said Merry Christmas, was that from the heart? Are you saying it, Jason? Sometimes people say Merry Christmas, but it's like,
No, Judge, it wasn't one of those.
okay. All right, we'll set the MTR on January 9th as well.
Ms. Shawner,
It's all about inflection, but I appreciate it.
Oh, just one second. Yes.
question, Judge.
Yes.
Mr. Torres is supposed to actually expire on January 9th. Now, he's done everything on the probation, as far as his terms, his classes and everything that's concerned. He's paid off all of his fees and so forth. However, he has 200 community service hours left to do. In the conditions, it did not state anything about if he completed his parenting classes, if those could be taken in consideration, but
has he completed his parenting
yes,
classes?
completed them.
All right,
And
I
the
normally
parenting
do that, so I would do
classes
that.
It was a supplement off of the original conditions. So would you give him the hours for the community service? I mean,
Yes.
For the classes?
Yes. All right, so, and the MTR will be set for January 9th as well.
Thank you, Judge.
All right, once you sign the reset form, you're excused.
Thank you, Judge.
You're welcome. Now that sounded like a good thank you, like it was from the heart.
Well, Merry Christmas was.
I don't know, I'm gonna ask my mom about that.
Judge, may I?
Yes.
I just want to let you know, I think so.
Okay.
I'm in training. So I'm right here. I can come back. I can text you next week.
All right, no
That's
problem.
okay.
Yeah, no, that's fine. Okay, thank you. Enjoy training.
Oh.
Usually those are preceded by ho, ho, ho. Merry Christmas.
Okay,
Bye, Judge.
bye-bye. Have a good one.
Thank you. Have a good holiday.
Yes. Okay. Oh, yeah, you can let him go. All right, and give him the number of his attorney. Okay. Okay.
They sound like they're in a great mood there in Texas.
Kent Yates. Hi. All right, Mr. Yates. Defense, my understanding is there's still an evaluation that's pending.
Yes, Your Honor, I thought Mr. Yates might be better today, and I approached him, placed a file, and was basically trying to get him to look at it. He's really not interested in looking at it, so I don't know whether he's competent or not. It sounded like, I can't really tell.
All right, so Ms. Ferguson, do we have a setting for when his competency? Just one second.
It was filed in November, early November, it's been about a month ago for the re-examination.
Ah, okay.
You're in court in the back on that day. Spoke to him briefly, and I didn't think he was competent at that time, but I can't tell him at all. Right now.
All right, so what we'll do then is we'll put it for February 1st, and we'll see where we're
I
at.
don't know how long. The charges are pretty serious, so I don't know how to proceed without his input.
All right, we're gonna, Mr. Yates, do you have any questions? Okay. All right, so this is what's gonna end up happening. We'll have the competency done. If they determine that he is competent and if he still does not want to communicate with you, then you will be going to jury trial with the client who's not communicating with you. So that's the way we'll do it. All right, Ms. Ferguson on Yates, we're bringing him back on February 1st.
Yes, ma'am.
All right, Deputy Laura, Deputy Mejia, you can take Mr. Yates away. Isaias Guerra. Thank you. And this is a plea. And there's no application. Court is calling 2023 CR 8177. You're on this side. State of Texas versus Isaiah Guerra. Can I have the parties announced for the record for the state?
Hank Wilkins for the state, Your Honor.
Defense?
I represent Mr. Guerra, Eric DeWalt.
All right. And are you Mr. Guerra?
Yes, ma'am.
How do you pronounce your first name again?
Isaias.
Isaias. All right. I mispronounced it. I'm gonna blame it on the deputies for
Fine.
telling me.
Not the only one.
All right. Counsel, have you received all the discovery? Did you review it with your client?
I have, yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Guerra, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
I do, Your Honor.
State, are you proceeding on the indictment as presented?
Well, we are, Your Honor, but with it's a 1244 Commissioner Judge.
All right, I'm going to show you what's entitled Court Admonishments. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with the offense of unauthorized use of a vehicle? That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow the plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
In my opinion, he does, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Guerra, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Satisfied with the way you've been represented?
Awesome.
I need a yes or no. All right. Are you a U.S. citizen?
Yes, sir.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial, showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 20 days in the Bexar County Jail under 1244. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
It is, yes, ma'am.
Showing you the waiver of appeal paragraph. I'm sorry, everyone, just one moment. All right. Counsel, did you understand that to be the plea?
Yes, I did, Your Honor.
State, is that the plea?
Yes, ma'am.
Showing you the waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
Contest.
State, any evidence?
Your Honor, I offer State's Exhibit 1 in the attachments. Your Honor, we've had an opportunity to go over that in its entirety. No objections to its agreements.
All right, and state you continue to confirm.
Thank you, Judge.
Mr. Guerra, I'm showing you what's entitled Waiving Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Please, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, we started off by my client, he'd missed his court date and you allowed me to approach. He's been very adamant about meeting all meetings with me and coming in front of you today. And we've discussed this case with the state and believe that the outcome is reasonable. And we hope you find the same.
All right. Then the court will follow your agreement, find you guilty, sentence you to 20 days in the Bexar County Jail under 1244, give you credit for any time served. The court will show that the judgment is satisfied. Going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? Did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right. And I did say the judgment is satisfied. I'm assuming it is. Is that correct?
Yes, 23 actual days in, Your Honor. Thank you very much.
All right. So we're off the record. I read the police report. There are other things going on in the police report. If you have a drug or alcohol problem, you better do something to solve it, because otherwise the last time you use could be the last time you use. Do you have children?
Yes, ma'am.
I don't think you want anybody to have to identify somebody who's found on the side of the road or anything, right?
Yes, ma'am.
And you don't want that to be you. So if you want to be in your children's life, you need to be in it clean and sober. You understand?
Yes, ma'am.
All right. Good luck to you.
Thank you.
You're welcome.
Merry Christmas.
Merry Christmas.
Over there.
All right. You too.
Was that face better than?
That was.
Interesting. Thank you.
You too. All right, Norma, the people we have left, we need Alberto Acevedo on Robles.
Everybody during my lunch Friday.
Okay, okay,
They said they were coming and they were gonna be here.
all right. Everyone whose attorney's not here, you probably want to call your attorney, because we are breaking. We're not staying past 5 o'clock. If they're not here, you'll have to come back tomorrow.
I'm gonna send you a text message from Lorraine.
Okay. All right, let me see her client. No, I don't have those files. All right. All right, we'll need to have those files filed by tomorrow, because he's really not a fugitive. He's in federal custody. So,
Yes, and we'll work on the throughout the afternoon.
all right, thank you. And Norma, we can put it on. She said he's set for trial on February 5th on the federal case.
Correct.
So let's put it at the end of February.
Listen.
The 29th.
Okay, we'll do the 29th then.
Setting correct.
Yes.
I got your email. I was here this morning. You probably didn't see you. I don't know if I'm praying with my phone. I guess I need to approach the judge because he's asking me to ask for more time before he makes a decision.
David Barfield or Barfield?
Good afternoon, Judge.
Good afternoon.
Find the right side. Yes, sir. Okay.
All right, Mr. Barfield, today is your plea deadline date. Are you accepting the state's offer or no?
I was asking for
He's
more
asking
time.
for more time, Your Honor, before we make that decision. I mean, there's about 30 videos that we've needed to go through. I need some more time to go through those videos to.
All right, Norma, on this case, if you set it the fourth week in January, that will be your final plea deadline date.
Thank you, Judge.
Fourth week, are you can do the 23rd?
All right, we'll come back on January 23rd.
Yes, Judge.
Once you sign the reset form, you're excused.
Okay.
All right, thank you.
Have a seat and I'll get the form. And
Oh, he's ready. He's the way. He's waiting to move the second year.
yeah.
Yes, sir.
For soda. That's I want to go to the judge prior to my food. Was that last week? The judge came to the door. I don't think he made the docket, but he showed up.
Yeah. Judge, can you?
Sure.
On Thursday, we had Joe Serta, he has a DWI, furthermore. He's the one that's going to SADF in Atascosa. And so we're going to enter into a plea today.
Okay.
And I don't think you're going to want to waive the PSI. So I'm just curious how, I guess the plan would be that you would just have SADF bring him here for sentencing?
No, SADF is, unless this is the case where you all were going to check in.
We were trying to figure it out and nobody could give us a straight answer. The attorney who worked on Atascosa is still currently like right now working on that. Like trying to get somebody to give them an answer.
Because I will tell you what the answer normally is if they have a case that's pending, they won't send them to SADF. So what is the agreement in this case?
It's a opposed offer. It's
Opposed? All right. So if we set this for sentencing, they're not going to send him to SADF and then bring him back.
Right.
But Sean, is that correct? Yeah. So
And that's statewide. I mean, that's not county by county. Yeah.
So, I mean, I'll do the plea today, but they're not going to accept him, and they won't even accept him to decide if whether you all enter a plea or not. They still want to accept him because this case is pending.
So he has that turn-in date over there, but it's not gonna be, so he's gonna end up doing it, probably try to turn in, they're gonna send him out.
No, what will end up happening is they're going to take him into custody, and he's going to be sitting there, and somebody from probation over there is going to say, he's just sitting here because he has an open case.
So then somebody needs to work on it. We need to make sure that Atascosa revises their plan,
Mhm.
essentially.
Yeah.
So yeah, we'll enter into the plea.
Okay.
here.
All right.
He has, I guess I answered my other question, because he had interlock on his vehicle, and we were gonna ask a motion to remove it if he went to SADF, but if we're pretty positive he's not gonna go to SADF, then.
Now, they may take him into custody there, but they're just going to keep him waiting at the jail because he has this open case.
Then we'll have to revise that out there.
And then we'll have to end up having,
A bench.
a Zoom sentencing if they do Zoom. If they don't do Zoom, we'll have to bench warrant him here for sentencing.
We'll handle that as this. Okay.
Yes. Okay, we actually have the full courtroom showing.
So we're
Charges, but not in the murder charges.
murder should be 1A, 2A, and 3A.
I'm sorry, the complicity language is not in the murder charges.
And it should be,
Yes.
and it should not, and it should also be in manslaughter.
Correct.
Okay. And that should be in 1A, 2A, and 3A.
Yes,
Hang on, let me get that in. Okay.
So is it in, like, for instance, he acting alone or in complicity with others killed Christopher Jones by shooting him with a firearm?
No, it is. He killed Christopher Jones by himself or in complicity with others by shooting him with a. Oh, that's not it. Okay.
I noticed in 1B, it says he killed Christopher Jones by himself or in complicity with others, and then it should say by shooting him with a firearm.
Yes, I changed all of those.
Okay. And then so for 2A murder and 3A murder, the same change will be complicity.
Yes, I've changed all of them.
The only other thing I noticed was that in the verdict forms, A, it says we the jury found the defendant not guilty or murder instead of murder.
Okay.
That's all I noticed about it.
We had two other things.
And I changed that order of and the other ones as well. Okay.
Your Honor, on page 1, under unanimous verdict, I believe the court was going to change foreman to foreperson.
Yes, thank you.
And I'm not sure if that's the only location of that word, but
I'll double check it.
Yes, thank you. And then I believe the only other correction is a lettering on page 6. For example, on 2A, we have 2 B's. I think it's the Word document is just trying to.
Does that make sense, Judge? It says B for the, instead of A for the first option, it says B, and then it says B again.
Oh, I see it.
And then on page 8 for instruction 3A.
Hang on just one second. Let me get that formatting correct. Okay.
On page 8, under 3A, on instruction 3A, we have a C and a B, which should be changed to an A and a B.
Got it.
And then I believe page 12, instruction number 6, we have element A, B, and D. The last one should be a C.
Page 12, you said?
Page 12, yes.
No, that goes under B. That's the, because it's not a separate element. That's just the intentional portion. So it should be the same for 2A and 3A.
And then I believe the same lettering on page 15, 16, 17, and 18.
A instead of. I see. Because it went to CD. I gotcha. Okay. Anything else?
Judge, we did do what you asked, and we discussed sort of the logic of today versus tomorrow. I think that we concluded that it will not slow us down to do do closings first thing tomorrow, as long as both sides are ready to go straight into penalty if that's necessary. And we can. We've already done penalty
I
instructions.
just hate to send them home, having been sitting here since 12:30. So we have to do instructions, and then you all think you'll be about an hour each. Is that right?
Yeah, probably less.
I think I'm just gonna push through. We're gonna make copies. Janelle has left, so it's me making the copies. Please bear with me.
He was getting for the client, for us, and for himself.
The copies are still running. While they are, I'm going to bring the jury in, check with them to see if there's any issues with the admonition, tell them what's going on with Tonelli being gone, let you all rest, approach, we'll do DV arguments again, and then the copy should be done. You ready? I'm nothing if not a multitasker. We talked about it already.
I knew this was a different one.
Mm-hmm. Well, thank you. All right, good afternoon. Let me apologize. You know, we try so hard to make things go as scheduled, and sometimes it just doesn't happen. I can't tell you how much I hate it when you all are sitting there for that long. But I assure you we were doing the best that we could. Is there anything that anybody needs to report with regards to the admonition? Did everybody get their phones over here? Okay. We have one juror missing, as you can see. What we understand is he's fine. I don't want you all to be worried about him, but we have gone ahead and excused him for health reasons. Also, Detective Tonelli, you'll see, is not here. With his permission, he has asked that I convey to you that he had to go out of state. His mother was having surgery, and we told him, you know, go ahead and go. We are going to move into the next phase of the trial. When we left Friday, the state had rested their case. Would the defense like to call any witnesses?
Your Honor, the defense rests.
All right. Would you all approach, please?
Okay, for the cases that we viewed on this in the last year, I haven't seen any cases where the defense has rested without presenting a case where they don't end up convicted. So, and I don't think that's going to change here. I was kind of interested in some of the.
In just a moment, you can have a seat. Thank you, Your Honor. You need something else?
Some of the jury instructions, I was going, reckless or, manslaughter or something like that. I don't think so. I mean, you've got one guy who is shot, and 2 weeks later, you've got 2 teens tortured and killed. That doesn't seem like reckless manslaughter, but I guess they have to give the instructions. My friend wasn't able to find anything. I need to give him a call and see if he's managed to come up with anything else since I got his message yesterday. But maybe I'll do that after we have the jury going out to deliberate.
Now, ladies and gentlemen, I am going to instruct you on the law of the case. That's what you're getting a copy of, is your instructions as jurors. After I have instructed you, and that is a thing that I must do, is read through these all the way for all of you. After I have read the instructions, the attorneys will give closing arguments. Closing arguments, just like I told you in opening statements, are not evidence, but they are the lawyer's chance to talk to you about how they sum up the evidence and recommend how you should find after closing arguments. Now, after closings, you will retire to the jury room, where the first thing you're going to do is select a foreperson. That person will preside over your deliberations. It doesn't matter really who it is, as long as you all agree that that person will be the foreperson. The foreperson's copy of your instructions, it really doesn't matter, but you need to have like one official copy. So generally the foreperson's copy will be the copy that you sign. There's no reason for the foreperson to sign any more than one copy, and that will be the copy that you return to the court. If you go back for deliberations and you have a question, please write it out and then knock on the door. There will be a deputy stationed outside the door of the deliberation room at all times. So if you have a question, you are allowed to ask questions. You would write it out, knock on the door or open the door, let the deputy know you have a question, and hand the deputy the paper. And then we will discuss it in here, and I may or may not answer your question. The same thing for when you reach a verdict. Just let the sheriff stationed outside your door know that you have reached a verdict, and we will bring you back in as soon as possible. Now, during deliberations, you can only talk to each other. The deputy will keep your phones. I'll give you a break before that if you need to call anybody and let them know that you might be here a while. If during your deliberations you need to use your phone or you have some kind of an emergency, please advise the sheriff. They, as I said, will be posted outside the door at all times. They will come and tell me and see if it is okay for you to use your phone. There are restrooms also in the area where the deliberation room is, so you don't need to leave for that purpose. All right, at this point, I'm going to read the instructions to the jury. In the case of 16 CR 1891, Commonwealth versus Brice Rhodes, these are the jury instructions. Presumption of innocence. The law presumes a defendant to be innocent of a crime, and the indictment shall not be considered as evidence or as having any weight against him. You shall find the defendant, Brice Rhodes, not guilty unless you are satisfied from the evidence alone and beyond a reasonable doubt that he is guilty. If upon the whole case you have a reasonable doubt that he is guilty, you shall find him not guilty. Unanimous verdict. The verdict of the jury must be in writing, must be unanimous, and must be signed by one of you as foreperson. You should use the form provided at the end of these instructions in writing your verdict. Right to remain silent. A defendant is not compelled to testify, and the fact that the defendant, Brice Rhodes, did not testify in this case cannot be used as an inference of guilt and should not prejudice him in any way. Tainted evidence. If you believe from the evidence that there existed certain items that were potential evidence and that the agents or employees of the Commonwealth unintentionally tampered with them, you may but are not required to weigh this evidence in favor of the defense. Definitions. Intentionally. A person acts intentionally with respect to a result or to conduct when his conscious objective is to cause that result or engage in that conduct. Wantonly. A person acts wantonly with respect to a result or to a circumstance when he is aware and consciously disregards a substantial and unjustifiable risk that the result will occur or that the circumstance exists. The risk must be of such nature and degree that disregard thereof constitutes a gross deviation from the standard of care that a reasonable person would observe in the same situation. Complicity means that a person is guilty of an offense committed by another person when, with the intention of promoting or facilitating the commission of the offense, he solicits, commands, or engages in a conspiracy with such other person to commit the offense, or aids, counsels, or attempts to aid such person in planning or committing the act. Official proceeding means a proceeding heard before any legislative, judicial, administrative, or other governmental agency or official authorized to hear evidence under oath. Instruction number 1A, murder as to Christopher Jones. You shall find the defendant, Brice Rhodes, guilty under this instruction if and only if you believe from the evidence beyond a reasonable doubt all of the following. A, that in this county on or about May 4th, 2016, and before the finding of the indictment herein, he killed Christopher Jones by himself or in complicity with others by shooting him with a firearm. And B, that in so doing he caused the death of Christopher Jones intentionally, or that in so doing he was wantonly engaging in conduct which created a grave risk of death to another and thereby caused the death of Christopher Jones under circumstances manifesting an extreme indifference to human life. Please indicate your verdict using verdict form number 1A. The verdict forms correspond with the instruction numbers. If you find Mr. Rhodes not guilty under this instruction, proceed to instruction number 1B. If you find Mr. Rhodes guilty under this instruction, the verdict form will also require you to make a determination as to whether or not you unanimously believe Mr. Rhodes acted intentionally or he acted wantonly, as those terms are defined herein. Please only answer yes if you all unanimously agree that his actions were intentional, as that word has been defined. There will be a further proceeding at which you will fix his punishment. Next, let's proceed to instruction 2A. Instruction 1B, second-degree manslaughter as to Christopher Jones. If you do not find the defendant, Brice Rhodes, guilty under instruction number 1A, you will find the defendant guilty of second-degree manslaughter under this instruction if and only if you believe from the evidence beyond a reasonable doubt all of the following. A, that in this county on or about May 4th, 2016, and before the finding of the indictment herein, he killed Christopher Jones by himself or in complicity with others by shooting him with a firearm. And B, that in so doing, he was acting wantonly, as that term is described in the definitions herein. Please indicate your verdict using verdict form 1B, then move on to instruction 2A. Instruction 2A, murder as to Maurice Gordon. You shall find the defendant Brice Rhodes guilty under this instruction if and only if you believe from the evidence beyond a reasonable doubt all of the following. A, that in this county on or about May 22nd, 2016, and before the finding of the indictment herein, he killed Maurice Gordon by himself or in complicity with others by stabbing him with a knife. And B, that in so doing he caused the death of Maurice Gordon intentionally, or that in so doing he was wantonly engaging in conduct which created a grave risk of death to another and thereby caused the death of Maurice Gordon under circumstances manifesting an extreme indifference to human life. Please indicate your verdict using verdict form 2A. If you find Mr. Rhodes not guilty under this instruction, proceed to instruction 2B. If you find Mr. Rhodes guilty under this instruction, the verdict form will also require you to make a determination as to whether or not you unanimously believe Mr. Rhodes acted intentionally or he acted wantonly, as those terms are defined herein. Please only answer yes if you all unanimously agree that his actions were intentional, as that word has been defined. There will be a further proceeding at which you will fix his punishment. Next, proceed to instruction 3A. Instruction 2B, second-degree manslaughter as to Maurice Gordon. If you do not find the defendant Brice Rhodes guilty under either instruction number 2A, you will find the defendant guilty of second-degree manslaughter under this instruction if and only if you believe from the evidence beyond a reasonable doubt about May 22nd, 2016, and before the finding of the indictment herein, he killed Maurice Gordon by himself or in complicity with others by stabbing him with a knife, and B, that in so doing he was acting wantonly, as that term is described in the definitions herein. Please indicate your verdict using form 2B, then move on to instruction 3A. Instruction number 3A, murder as to Larry Ordway. You shall find the defendant Brice Rhodes guilty under this instruction if and only if you believe from the evidence beyond a reasonable doubt all of the following. A, that in this county on or about May 22nd, 2016, and before the finding of the indictment herein, he killed Larry Ordway by himself or in complicity with others by stabbing him with a knife, and B, that in so doing he caused the death of Larry Ordway intentionally, or that in so doing he was wantonly engaging in conduct which created a grave risk of death to another and thereby caused the death of Larry Ordway under circumstances manifesting an extreme indifference to human life. Please indicate your verdict using verdict form 3A. If you find Mr. Rhodes not guilty under this instruction, proceed to instruction 3B. If you find Mr. Rhodes guilty under this instruction, the verdict form will also require you to make a determination as to whether or not you unanimously believe Mr. Rhodes acted intentionally or he acted wantonly, as those terms are defined herein. Please only answer yes if you all unanimously agree that his actions were intentional, as that word has been defined. There will be a further proceeding at which you will fix his punishment. Next, proceed to instruction 4. Instruction 3B, second-degree manslaughter as to Larry Ordway. If you do not find the defendant Brice Rhodes guilty under instruction 2A, that should be 3A, you will find the defendant guilty of second-degree manslaughter under this instruction if and only if you believe from the evidence beyond a reasonable doubt all of the following. A, that in this county on or about May 22nd, 2016, and before the finding of the indictment herein, he killed Larry Ordway by himself or in complicity with others by stabbing him with a knife, and B, that in so doing he was acting wantonly, as that term is described in the definitions herein. Please indicate your verdict using form 3B, then move on to instruction 4. Instruction 4, tampering with physical evidence. You will find the defendant Brice Rhodes guilty of tampering with physical evidence under this instruction if, and only if, you believe from the evidence beyond a reasonable doubt all of the following. A, that in Jefferson County on or about the 22nd day of May 2016, he, acting alone or in complicity with another or others, destroyed, mutilated, concealed, removed, or altered items from 763 North Height, including a pink blanket, the knife, and/or the backseat of the blue Mazda, and that in so doing, he believes that an official proceeding may be pending or instituted against him, and he did so with the intent to impair the availability of the evidence at such a proceeding. Please indicate your verdict using Form 4, then move on to Instruction 5. Instruction 5, abuse of a corpse, Maurice Gordon. You will find the defendant Brice Rhodes guilty of abuse of a corpse under this instruction if and only if you believe from the evidence beyond a reasonable doubt all of the following: that in Jefferson County, on or about the 22nd day of May 2016, he, acting alone or in complicity with another or others, placed the body of Maurice Gordon in a yard off an alley and attempted to burn it, and that he had no legal authority to do so, and that in so doing, he intentionally treated Maurice Gordon's body in a way that would outrage ordinary family sensibilities. Please indicate your verdict using verdict form 5, then move on to instruction 6. Instruction 6, abuse of a corpse, Larry Ordway. You will find the defendant Brice Rhodes guilty of abuse of a corpse under this instruction if and only if you believe from the evidence beyond a reasonable doubt all of the following. You'll see there's a typo where the word following is written twice on this one and the one before. That in Jefferson County, on or about the 22nd day of May 2016, he, acting alone or in complicity with another or others, placed the body of Larry Ordway in a yard off an alley and attempted to burn it, and that he had no legal authority to do so, and that in doing so, he intentionally treated Larry Ordway's body in a way that would outrage ordinary family sensibilities. Please indicate your verdict using Form 6. This is followed then, ladies and gentlemen, by a single verdict form for each instruction that I have just read to you. You will need to follow those instructions, and as I said, have the foreperson sign as appropriate in line with your verdicts. Now, we are going to have closing arguments. I expect that they will last until about 5:15 or so, maybe 5:30. Would anyone like to take 5 minutes to step outside and make any calls or anything that you might need to make? Because once we're done with that, you'll go straight into deliberations. That's up to you all. It just depends, on how it goes. So does anybody need to step out? All right, let's take 5 minutes. I'll have you come back at 3:35. Please remember the admonition is still in place.
Let's hope this 5 minutes isn't half of the last 10 minutes. Let's see. Interesting that the jury goes through the main door. I've never seen that before. Of course, usually they're going through they show the ceiling or something, so we don't see any signs of the jury. Okay. 5 minutes. Give me a second.
Am I okay? No. But I'm going to keep going until I am. Just overwhelmed.
Okay, sorry about that. I got a case of the sniffles. Doesn't feel like it's an actual cold, so I think it's some kind of seasonal allergy. I'm going to take a quick look and see if we've got anything interesting which has come down. Looks like Hidden True Crime has the full documents on Ruby Frank pleading guilty. Not seeing anything super short, but getting a few more things for the verdict watch coming up. Over the weekend, I watched a fascinating thing which was talking about Flight 370. I guess they did a Netflix documentary, and it was pointing out a few things that they didn't think were done right there. Oh, interesting. We've got video. It says teen accused of stabbing mom in her sleep appears in court for evidentiary hearing. Sounds like an interesting case. Obviously, he's been being tried as an adult. If he's he's 18 or 19. Let's see how much longer. Oh. Looks like we're getting ready to go for it. Now, they said the prosecution and the defense both expect to take an hour. So, now the big question is, will they start deliberating tonight or will they wait to deliberate tomorrow? I would think that once the jury has the case that you'd want them to go deliberate. And I don't think it's going to be a super long deliberation. I think it's pretty cut and dry. The guy seems to be talking to the jury, but we can't hear anything. Okay, it does seem to be the channel rather than just me. Here we go.
Maybe the next day. Inevitably, the sun came out. When the sun came out, that fort that appeared to be so strong looked like it would never collapse, never fall down. Every single time it did. Every time. The Commonwealth, in this case, bears a heavy burden. They admitted it in their opening. They bear the burden to prove to you every element beyond a reasonable doubt. And at times, they have seemed to have built the strongest, toughest fort that was going to last forever. I want to suggest to you that when you look at it and really, it isn't so. Your job, and we talked a little bit about this when we were selecting the jury, it's not just one thing, it's multiple things. The most important thing that you do is you try to make sense from this witness stand of what really happened. You take the pieces of evidence that you have and you evaluate them. Decide which parts have credibility, which parts don't. When you're thinking about their case and you're thinking about what they proved beyond a reasonable doubt, that's what you have to go from. The evidence that you actually heard from the witness stand. Because the other part of your job, and there's the reason there's 12 of you, right? Because you caught something and maybe you missed something. You caught something else, maybe you missed something else. And that's why you get to talk, right? You're not going to do separate analysis. You sit in a room together and you have your notes. Some of you took a lot of notes, some of you took a little notes. That's up to you, right? That's your business. But you get to talk to each other and you'll have the instructions from the court. And the instructions from the court are very important. That's why not only the judge read them out loud, but each of you gets a copy. Those represent the actual law, the law that matters in this case. And then you get to do something that's sort of amazing. You get to apply the facts of this case to the law. That's part 2 of your job. You get to say, okay, now we've decided what happened. We've done the best we can to figure it out, right? And now we look and we say, did the prosecutor, did they meet their burden? Did they prove beyond a reasonable doubt? And then if they did, what did they prove? Because as the court read to you, there are multiple possible options. And then you're the ones who choose. Now, I'm going to talk to you for a little while, tell you what I saw, what I observed, what I think. The prosecutor's going to get up and do the exact same thing. Okay? What I say is not evidence. The prosecutor says it's not evidence. What you heard in the witness stand, that's the evidence. So let's talk about credibility for a second. You really heard 2 types of evidence in this case. You heard a lot of evidence from either police or people who work with the police. And then you also heard evidence from the other suspects. I'm going to talk about those separately. Because I want to be clear. I want to try and be as clear as I possibly can. There were a lot of witnesses who either were police or worked with the police. And they told you little pieces, really. There's a little piece, sort of like a puzzle, little piece here, little piece there. Sometimes they fit, sometimes they don't. The prosecutor's going to tell you that they all fit. They all make sense. It's clear, crystal clear. It's not. You know it. You sat in this room. You heard the evidence from that witness stand. In their opening, the prosecutor talked about, and I want to get this right because I wrote it down, a monstrous bloody scene. I think those are the exact words the prosecutor used. Monstrous bloody scene. But we heard from the witness stand that was not true. What we heard from the witness stand is that there was an entire bunch of officers with a search warrant who can look at whatever they want that's on that search warrant, right? And went in the scene in Hyde Avenue, right? Where we heard a lot of evidence. And they walked through and they didn't see much of anything. They walked through and they left. They took off and were gone for, though there was a little quibbling about it, it was about an hour and 45 minutes, something like that, before they decided they were coming back for the new search warrant, right? This was no monstrous bloody scene, blood everywhere, any of that sort of stuff. And we know that from the actual testimony we heard on the witness stand. But that's not what the prosecutors want you to think. They want you to picture it different. I'm going to ask you to remember what the real evidence was from this real witness stand. We heard that the police weren't even able to videotape the scene. It sure would have been helpful for all of you. It would have been helpful to me. If there had been a videotape showing us what it really looked like that first time they went in, or the second time they went in. They said they had new evidence. They going back 2 hours later, approximately. And on the third day of trial, we get handed a videotape, the missing videotape, which is completely, utterly black. Doesn't show that. That's not helpful. That doesn't help you, doesn't help me, doesn't help anyone understand anything. Right? It's important to remember what you actually saw, what we actually learned from the witness stand. You know, there was right here these photos that I tried so hard to find the other day. Found them in advance. You know, there was all the testimony. We saw it on the big screen. This dramatic, lighten up blue. And that's the drama. And you see it, and it has colors and lights. But the actual testimony is that none of this was blood. That's, I'm going to suggest to you, that's smoke and mirrors. I don't know what's showing you these photos where stuff lights up and then it turns out it's actually not evidence. That is not helpful. It's like anti-evidence. That is not something that is useful or helpful, and it definitely is not something that helps them prove anything beyond a reasonable doubt. It's the opposite. But it is concerning when people get on the stand and they talk about their degrees and they talk about how hard they worked and they did these things, and then they act like they found something when they really didn't. It's always weird when to stand up here and beat up on the police, right? Police do good things, they also do bad things. We know it, right? We all know it. Anybody reads the newspaper knows it. They're not perfect, they're not completely imperfect. But the important part, the part that matters to us here, what they did in this case, what they didn't do. I don't know, maybe it's normal to not do a report for 2 years. Try and do it from memory 2 years later, all this time later, try and get those facts, and then come into court and act like they know what happened. Maybe that's normal. Seems a little bit weird to me. But we know from this witness stand that that's the sort of thing that was happening in this case. That one officer said when he had to fix something in his report, he went and did an addendum and typed it all up and showed right up. That first detective who talked to us said it's impossible. Once it's down there, it just stays there. And that was his explanation for how he made a big mistake. How he said there were 6 shots when there was actually 1 shot. He said, I couldn't possibly go back in and fix it. I couldn't possibly do another report that explained something as 6 shots, 1 shot. I know that's not 6. I don't have 6 fingers. But what are some of the other things, some of the really big things, some of the very important things that were alluded to, but not really explained from this witness stand? They told you, multiple witnesses, most recently Detective Tinelli, but multiple witnesses told you that there were other adults at Hyde Avenue that night. Detective Tinelli said there was the dark-skinned man and the light-skinned man. There was also a Caucasian woman. I think they finally sort of agreed that the Caucasian woman had left before much happened, maybe, but she had been there. They're unable to figure out who this person was. it is confusing to me why, when they have Carter and Taylor, and we're going to talk a lot more about Carter and Taylor, why Carter and Taylor couldn't inform the police who this missing woman was. I would have liked to hear from her. I would like to know. I have investigators who work for me. If the police don't want to interview her, I want to interview her. I want to know what she has to say. Because I don't think that what we heard on the witness stand about Hyde Avenue is honest. I don't think it's correct. I don't think it's credible. I don't think it's true. We don't get to hear that. But we also heard about the light-skinned man and the dark-skinned man. Now, Detective Tonelli said, well, we just never were able to figure out who the light-skinned man was. I can't invent somebody. Remember? Friday just happened, right? It's Friday. But didn't say he didn't know who the man was. In fact, he told us who the dark-skinned man was. Why in the world was that man not on this witness stand? There's another eyewitness to all of this, and he knows who he is, and we never heard him. Never heard what he had to say. That doesn't make any sense to me at all. Just gone. The police were picking and choosing. The government was picking and choosing what they showed you in this courtroom. Now, the police had already decided who they wanted to charge. They already had their guy. Do. And the problem is, sometimes they're right, but sometimes they're just wrong. Made a decision and decided he was going to charge Brice Rhodes, and then he stuck to it. No, I suggest to you that that is not the way our legal system is supposed to work. The good news is that 12, final 12, I know it's 14 of you now, who sit on this case act as a check to that. Because no matter what the police think for the last 7 years, no matter what they did for the last 7 years, no matter what the prosecution thinks, it's your verdict that counts. You know, when we're talking about things in this case that don't make sense, it's funny. I have kids. After a while, even your kids do or say the same goofball stuff. After a while, it seems normal to you. My kids pronounce the words "I love you," "I love you." That's just how they pronounce it. After a while, that's normal to me. That may sound like a strange thing to say, but what I want to explain is that the folks involved in this case have been hearing the same story over and over and over again. And after a while, it just starts to, it must make sense. I've heard it for 7 years. The death of Christopher Jones does not make any sense. I hope with your fresh sets of eyes and your ears, you heard that, and the first time you heard it said, what? What? This doesn't make any sense at all. It's a fake or made up hit on someone where maybe the wrong person gets, it doesn't make any sense. This is not a plan. What kind of a plan is that? They couldn't make it make sense on the witness stand, and they tried a little bit. And then when it wouldn't make sense, they just passed the buck. But you know what it does sound like? It sounds like the sort of story, sort of explanation that would get cooked up by two teenagers when they're trying to come up with some version that makes them look a little bit good. Or maybe I should say less bad. Doesn't make any sense. And when I say two teenagers, of course, I'm talking about Taylor and Carter, two cousins, two people who had an opportunity, time to come up with something, both before their arrest and then time after the arrest. I have to talk about this car seat. I don't even know what to say about the car seat. It's so bizarre, it stands out like a sore thumb. But when the prosecutor's trying to say, our police officers, you know, had the highest level of integrity, and honesty, and journalism, and you should take for granted all of the testing and all the evidence they did, I want to suggest to you that the car seat really explains why you should not. We certainly don't have a car seat. We don't have one in this courtroom. You never saw one. I never saw one. But the police under oath said, we got a car seat. Said it a couple weeks later. Then a month after that, they were under oath again. And they said, we got the car seat. And the writing, Detective Tonelli says, write this police report. After that, he's got a car seat. I know he's saying there's a lot of evidence. It's hard work. Can't know everything all the time. I hear that. But there's a few. You have to be able to rely on it. That's why we have people testify under oath. They're supposed to get it right. It is their job to get it right. And if they don't get it right the first time, we certainly expect them to get it right the second time. If they don't get it right the second time, we don't expect them to put it in their police report, which gets sent to all of us, so we can do our job, so we can have the evidence, so we can explain everything as best we can to you. But that's not really the part that's a shocker. The part that's a shocker is 3 years later. You can have all the excuses about overwork and lots to do and everything, and I'm sorry I testified incorrectly under oath, and I'm sorry I testified incorrectly under oath again, and I'm sorry I put it in that report and I didn't fix it. But none of that holds water 3 years later. He said, I didn't realize until the fall of 2016. Okay. This is going to be up to you to decide how much slack you want to cut him. It is. It's not me. It's you. But I'll tell you this. 3 years later, in this courtroom, when he tells a judge, a different judge, but a judge in this case, we've had cases we've gone so long, we have had changing judges. When he tells a judge in the courtroom, when we're having a whole big hearing, like you heard, all the evidence, what's the biggest piece of evidence? He says, well, I guess it's going to be the big car seat that I bring up here. He told you under oath that he didn't realize what was really going on until the fall of 2016. How can that be correct when he's still saying we got the car seat 2019? The prosecutor may get up here and say, everybody's overworked and sometimes people are stopped. Sometimes the police is slow. If that's the case, what else was done sloppy? If sloppiness goes to the point of incorrect testimony under oath, how can we judge the credibility of the evidence that you have seen? It raises serious doubts about the credibility. Judge even read an instruction that went to you about tainted evidence in this case. It's not just the defense attorney up here talking to himself talking. Right? That's the law from the judge in this case. But what I think the part that literally woke me up last night thinking about it. It's not the car seat. It's not. They probably did the car seat, but it's not. Burned truck. That stolen truck. I want to know a lot about that truck. Where was that truck stolen? I want to know when it got burned. I want to know where it got burned. And most importantly, I want to know why it got burned. Because I'll tell you, there was an awful lot of mud thrown at Brice during this trial, but nobody ever tried to say he stole the truck, drove the truck, he burned the truck. You never heard those words from anybody, Why in the world did that truck get burned? And why don't I know more about it? Why don't you know more about it? Why didn't we know more about it? Didn't we care about it? So what do we know? What do we know under oath from this witness chair? Well, we know that Carter said he stole it. We know that Carter and Taylor said that he stole it and drove it on the night of Christopher Jones' murder. But we also heard Carter say that he hit Jones with the truck. Now, the ME talked about blunt force injury. I don't know if that's from the truck or not. I have no idea. I know he had blunt force injury to his head. It might be, it might not be. I don't know. Prosecutor may have some opinions about that. They may not. I don't know. But he had an injury to his head. But what I do know is that Carter said he hit him with the truck. He said he hit him while he was down on the ground with the truck. He said he ran him over. prosecutor asked him, I don't remember the exact question. He asked him something along the lines of, well, you know, by mistake. And he said, no, I hit him with the truck on purpose. That's the prosecutor's witness. That's the believable, credible person the prosecutor has put on this witness stand, is a guy who said he hit poor Mr. Jones while he's on the ground with a truck. For what reason? I don't know. I have no idea. I think the prosecutor didn't know he was going to say that. I certainly didn't know he was going to say that. We know that about the truck. Do you really want to know what I want to know about that truck? I want to know if Maurice Gordon or Larry Ordway DNA in that truck. Because you remember from what we heard from the witness stand, their DNA was not in the Mazda. And someone's talking about this Mazda, but DNA wasn't in the Mazda. But from what I heard, there's this truck being driven by someone who has confessed to being involved that is burned. We don't know why. We don't know when. And that never got tested. I want to suggest to you that maybe that truck is actually what was driving the two bodies of those young men around. Does that sound like idle speculation? I don't know that it is. Because why did he burn that truck? That night, there's all this talk about people trying to burn evidence, right? Was the truck burned the same night? The perfect and logical reason for burning the truck would be, in fact, that it had been used to transport the bodies of those two young men. Think about the story that Taylor and Carter told about how the bodies were removed from the house. I listened to it again. They're putting totes, those big blue bins. That's what they described. One of them said the sort of thing you put your Christmas ornaments in. If it's big enough to fit a person, it's not going to fit in the trunk of a Mazda. And we don't have a Mazda. I wish we did. Y'all look at, open the trunk, take out a tote, try and fit it in. But we don't have that. But use your common sense. All of you have had a car, anything like that. Those big totes don't fit. They're certainly not going to fit two in the back. But you know what they fit in real easy? Back in the pickup truck. No problem. No problem. So you get to decide completely if all the things I just said don't matter. You get to decide. You're completely empowered to do so, right? But I'm going to suggest to you that they're worthy of discussion. They're worthy of discussion because the story you heard from Taylor and from Carter, I don't think is possible. It doesn't make sense. But the part that really bothers me is the lack of investigation and follow-up by the police of the truck. And I want to suggest to you that I believe it's because they had just decided who they wanted to charge. They decided and they were charging, that's it. And since he's not associated with this truck, they're not investigating the truck. That's not the way it should work. It's not the way it should work. It's not the way evidence is supposed to to come into this courtroom so that it can be explained to you so that you can do your job. So let's talk for a second about Taylor and Carter's decision. They're cousins. It means they know each other, they're tight. They said they were. They said they were close. How can we evaluate their credibility? Well, one way is, do their stories change? Well, yes, we know they do. The police and prosecutors admit they do. They admitted that they did. There is no question that Carter and Taylor lied. The police are just saying that they like the last version. So that one's not a lie. But there's no question that they lied. There's no question they changed their story. They admitted they did. The police admitted they did. The prosecutor admitted. They changed their story. And that's one of the things that we look at and think about when we're trying to figure out if someone is credible, someone's being honest. Do they change their story? We know that specifically they lied. That's another thing we look at. Not just a changed version, but a full-blown admitted lie. They admitted on the stand that they had lied. They said they were telling the truth on the stand, but they admitted they had lied in the past. Now, Taylor said he was just trying to do the right thing. They're trying to do the right thing. I want to suggest to you that that is nonsense. How do we know it's nonsense? We know it's nonsense because when he first came in here, he refused to say a thing. If he is so gung-ho to tell you that's why he's here, he's going to do the right thing and say the right thing, then why did he refuse to say anything while you sat here? You had to leave the courtroom. He's still on the witness stand after you came back. Remember what he said? I got nothing to say. I got nothing to say. I got nothing to say. He had to be threatened in order to answer questions. That is not somebody who's just in here trying to help, just in here to do the right thing. He's doing the opposite. What he admitted when I asked him was he actually didn't ever want to be in a courtroom like this. And he didn't ever want to tell anyone because he didn't think he was going to get caught. It's going to be up to you to judge the credibility of that witness. But I want to suggest that he's not credible. He's not. He came in and told you is not credible, and neither was Carter. Now, ironically, maybe you say, well, if Carter wasn't telling the truth, he wouldn't have admitted he hit some guy with a truck. I don't know what he was thinking in this courtroom. Incarcerated, he was the guy who had came in incarcerated, right? Testified. Think about some of the other just cold things that Carter said. Said he hit Mr. Jones on purpose with a truck, no reason. When he was holding a cell phone that he stole from somebody he helped kill, or maybe just killed, he got phone calls. He got phone calls from that young man's mother. And he kept the phone. And he just lied to her. So they're sleeping over. He actually said, when asked, I didn't care about her. may not be an exact quote. That's what he said. He said, I think he might have said, I wasn't worried about her. That's the prosecutor's witness. These are the prosecutor's star witnesses. Confessed, admitted, actual murderers. Their final version is the best of the best. Their final version is, we participated in murders. That's the winner in the contest. They would have said anything the police wanted them to say in order to get out. And they both admitted that their testimony in this courtroom was so they could still have their deal. That's why they're here. But I want to highlight 4 things. Put them up here on this chart. Those 4 things I think are very important. I could have gone back through the versions they gave the police, the 126-page version, which is all nonsense. This is all basically jackknife. And then their later version and the later version. But to be honest, at some point, I think it just gives everybody a headache. We have a headache part. But so here's what I did. I went back through only what they said in this courtroom. Only what they said under oath in this courtroom to you, Carter and Taylor. And I picked out 4 things. Why are they important? Because they both are claiming they're telling you the truth under oath. They say the opposite. So when you're judging their credibility, even if all you judge them from is what they said under oath to you in this courtroom, I'm going to tell you what those 4 things are. The first thing, I'm going to put Carter here. And Judge, if you need me to pivot this so you can see it.
Okay, thank you.
Carter was the person who testified first. It's N1. Here I'm going to put Taylor. Mr. Taylor testified at the end of the day on Thursday. The first thing that they testified to you about under oath that they disagreed about, we just talked about, but I think it's worthy of the list. Carter said that he hit Mr. Jones with the truck. Taylor said no, he didn't. He got asked, he said, no, that didn't happen. Didn't hit Mr. Jones with the truck. And the person who was driving the truck. We already talked about why I think that's important, because I think the truck's important. But let's talk about a different fact, and one that hopefully jumped out. Folks, the gun that was used, according to the testimony in this courtroom, to shoot Mr. Jones. Carter was asked point blank, where was that gun purchased? I can't ask you. I'm going to tell you what he said. What he said is, purchased in a trailer park. Said that under oath in this courtroom right there. And what Mr. Taylor said, I purchased it at the home of Larry and Maurice. Same gun, same day. both prosecution witnesses under oath. There's no wiggle room there. One of those two, I'm gonna write it up here. Specifically, he said he purchased it from a relative. We don't know all the details of that purchase. But I was surprised when under oath, the prosecution's second witness had a completely different version of those. Not some far off 7-year ago statement. Folks, we're talking about Tuesday and Thursday. No, Wednesday and Thursday. Those statements are made 24 hours apart. Somebody's lying. Somebody's lying to everybody in this courtroom, and most importantly, that means they're lying to you. Prosecutor may say this next one doesn't matter. I think it does. Remember all the testimony about the vote? I'm going to call it a vote. I'm not going to quibble about the vote. Because people are talking about whether or not someone is going to be killed according to the testimony. Pretty serious stuff. The kind of thing that you want to get right if you're testifying about the details. Carter said that he was the only one who said no. And he was asked specifically about Taylor. And he said, Taylor voted for death. Taylor didn't even mention it when the prosecutors were asking questions. He didn't even bring up the conversation. When I asked him about it, he didn't want to call it a vote. Okay, don't call it a vote. I don't care what you want to label it. But he didn't want to talk about it at all. When push came to shove, he testified under oath that he voted for life. He said, no. They can't both be telling the truth. Carter said Taylor voted for death. Taylor self-servingly told you all he voted for life. Why do you think Mr. Taylor didn't want to tell you what really happened? Maybe it's because Maurice threatened him with a knife. Remember what Mr. Taylor told you about that knife? Mr. Taylor said the same knife he got threatened with by the victim was the one he held in his hand when he stabbed the victim. Same knife. Taylor have something to hide? Yes, he does. He admitted it. He was angry. Of all of the testimony, he's the one with an actual motive to do violence on that night. And the last, but very significant difference is about those Timberland boots. The boots. What did Carter tell you? Carter said Taylor stole boots off one of the victims. That's what Taylor stole. I bet you remember what Taylor said. And I bet you remember because I bugged him about it and asked him about 12 questions about it. That he said, I didn't steal any boots, those were mine. Taylor said they were his. He didn't steal anything. Those were his. You know the problem with that? No matter how much these guys put their heads together and came up with a story, they did 7 years ago. Their story from 7 years ago is going to have pieces that they never talked about. And also, 7 years is a long time. Always a few pieces here and there. Funny thing about the truth, you don't have to hold on to that quite the same way. You know, if somebody tells me a story and it's true, I'm going to expect that if they tell me that same story 5 years down the road, it's going to be pretty much the same. Now that I might ask it different, they might tell it a little bit different, but it's not going to have these sorts of whoppers. You know what else they didn't have the benefit of when they were putting their story together? They didn't have the forensics reports. Because when Mr. Taylor is saying, I didn't steal those, I own those are mine. Detective Vance told you that they belong to the victim, right? I asked Detective Vance, I said, Mr. Carter had an item that belonged to the victim. She had the phone. Detective Vance said, yes. I said, Detective Vance, Mr. Taylor had an item that belonged to the victims. He had these shoes. Detective Vance said, yes. Then I said, and Brice Rhodes didn't have anything that belonged to the victim. Detective Vance said, yeah, that's right. He didn't. But what else do we know about those boots? We know they were tested for DNA. They were tested in multiple spots. We heard the testimony from the DNA folks. And guess what? Mr. Taylor's DNA isn't on his own boots. Oops. It's on his boots. Stolen. Just like Detective Vance said. He's in here trying to, good. He's in here trying to protect himself and cover himself. And he doesn't want to tell you the truth. When you're evaluating the credibility of the witnesses that you heard from this witness stand, remember these things. Testimony under oath spoken to you within 1 day. It can't be true. They can't both be true. We already talked about Mr. Taylor and the knife. You know why they're in here? They're in here because of these. Now you have copies of these. These are yours, right? Everything that got marked as exhibits. It's mostly a lot of photographs, to be honest. And these, we're gonna go back, and you can have them. You can look at them as much as you want, right? I want to suggest to you that you really do look at them. Okay. Those two witnesses, the ones who confessed to being part of murders, 3, who we know lied. Nonetheless, this shows what they were looking at was up to life in prison on each murder, on each one, looking up to life. And what did they get? Because they're willing to come in here, they're willing to say to the police, what I was saying in this courtroom, it got reduced from life in prison for each murder to 5 years. 5 years. That's a pretty big drop. That's a pretty big motivation. Just to make sure that they stayed motivated. In this document, it says, even after you serve your time and you're out and you're done, you still have to come back to this courtroom and you still have to testify under oath. And if we don't like it, we want to say that we don't think you told the truth. If we can convince a judge that you didn't tell the truth, then you're back at life imprisonment. Times 3. So you better do your job and get in here and say what you got to say. It's in black and white. So all of this, we're talking about credibility, all of this matters. Because you're going to have to decide whether or not the prosecutor really proved beyond a reasonable doubt their case. So I want to stop for a second. Why do we even have that? Why does that matter? Why is that the rule? We have that rule because there used to be a time that the police and the prosecutors could literally go out and grab somebody if they didn't like them. Grab them if they just thought that they were guilty. And then there was stuff. There are legal systems where you are presumed guilty and you have to prove your innocence. That's horrible. And one of them is Iran. I don't ever want to get arrested in Iran. I have nothing against the country per se, but that legal system, I don't want anything to do with it for a variety of reasons. Imagine how horrible it would be if the police got to say, I think you, I don't said, I think you did it. This is what we think. And from now on, you're in jail forever until you can prove you didn't do it. How horrible is that? We made a choice in this country and we live by it, and we have excelled because of it. That the government doesn't just get to do whatever they want and charge whoever they want and arrest whoever they want. Because when they do, it may take 7 years, but finally they end up here. And they end up with you. You are here to make sure that it's not a guess. Beyond a reasonable doubt, it's not a maybe. It's not a probably. It's beyond a reasonable doubt. Now, I'm not going to try and tell you what a reasonable doubt is. I'm not going to try and define it. That's up to you to decide. But it's a big deal. It matters. Didn't matter, you wouldn't be here. I'm going to ask you to remember all the way back, and I said it once before, that there are 2 jobs. When you go back into that jury room, your first job is going to be to figure out the best you can what the prosecutor proved beyond a reasonable doubt. Then, and I'm not going to, the judge will read them all. I'm not going to read them at you. I'm not going to, you guys can all read them if you want to. Fine. But to apply the law and the instructions to what you believe the prosecutor proved beyond a reasonable doubt. And I'm not suggesting that's easy. Right? It may take a while. I don't know. It's going to be up to you. It's going to be up to how the poor person, frankly, runs the show back there a little bit. But I have complete faith that you that you have. I've watched. You're all paying attention, taking notes. I think that you will do both halves of the job. And I appreciate that you're going to do it. I'm going to ask you when you're doing that to remember the credibility of the folks who testified, and remember all the other things you know about the investigation. Things can't be, shouldn't be taken at face value. In the final analysis, the prosecution did not meet their burden. I think the police always assume, and government assumes, that if they can put on a big enough show, bring in enough people, that the jurors will just fall in line. Don't do that. You make your own decision, and I'm not going to tell you what it is. But you're more than just pawns for the police. You're the jurors in this case. And what you do matters. In the final analysis, the prosecution did not prove beyond a reasonable doubt the existence of an intentional murder that involves Brice Rhodes. It did not. Now, if you look at those instructions, in there, it's a definition of want. It's a word that probably none of us ever use, but it's a word in our language and the law likes it. So that's why it's there and you get a definition of it. Try and make more sense out of it. That one's a little bit more wide open because it covers an awful lot more territory. Just because it's wide open and may seem more like the prosecutor met their burden there, it's not. You will decide. And there are two different offenses that both require wanton rather than intentional. Again, that's all written down. Judge read it. You can look at it as long as you want. And hopefully it will make sense. There's 12 of you. That's how it doesn't make sense to one person, it makes sense to somebody else. But I'm going to ask you, when you go back into the room, think about all the evidence you heard from this stand. Think about a lack of credibility with so much of that evidence. To return a verdict of not guilty.
Mr. Griffiths, thank you. Ms. Jones-Brown, would the state like to make a closing argument? No.
I'm gonna have some
It's
squeaky
really
noise.
noisy.
Ladies and gentlemen of the jury, it was Brice Rhodes who decided that Christopher Jones was going to die that night. It was Brice Rhodes who shot him. It was Brice Rhodes who decided that Larry and Maurice had died. It was Brice Rhodes who stabbed them over and over and over. It was Brice Rhodes who gave the knife to Anwan Carter, to Ja'Cory Taylor, to Tieran Coleman, to the unknown man, to make sure they were all in it. He learned his lesson last time about people talking. It was Brice Rhodes who took those bodies to River Park and burned them. There are so many profoundly tragic parts of this case. I don't know which is the worst. There's Christopher Jones, father of 3, crossing the street in the West End, nothing to do with any of this. shot dead for the stupidest of reasons. Larry and Maurice killed because they did what we would want any teen to do in this circumstance. Go to your mom. These 4 children, so desperate for adult male guidance that they keep hanging out with Brice Rhodes even after they became scared of him because of Christopher Jones's murder. There's Jacory, who had nowhere else to go, sleeping in stairwells, going over there even when he didn't want to, because that was a place where he could spend the night. Maurice tied up with a sock in his mouth, bound, knowing his little brother's in the bathroom. It's Larry stuck in the bathroom, not knowing what's going on outside, we hope. And then Larry struggling when he comes out and sees the blood on the floor. And Juan Carter and Jacory Taylor feeling they have no other option but to follow the orders of that man who forced them to participate in the murder of their best friends. Forced them to clean up after, forced them into this life that they now have. Arrest, prosecution, juvenile custody, adult custody, felony convictions, prison, having to come to court and testify. That is what this man has done to this entire group of children. Now, how do you know, based on the evidence presented here, that Brice Rhodes is guilty? A lot of it does have to do with the statements of Juan Carter and Jacory Taylor, but their statements were corroborated by other evidence in this case. So let's go over what we have. First of all, this case is charged in complicity, and you'll have this definition with you. It's on your jury instructions. But it means that you don't have to worry about who stabbed the fatal stab. If you believe that Brice Rhodes orchestrated this, if you believe that he was in on it, if you believe that he was commanding or soliciting or engaging in conspiracy with them, you don't have to worry about what stab wound killed them. He is guilty of the whole act. To return to how do we know he is guilty, we will start with the murder of Christopher Jones. Now, Juan Carter told you he was following behind the blue Mazda. He knew that Rhodes was in the driver's seat, or the driver's side rear seat. He saw Rhodes shoot out the window and kill Mr. Jones. He admitted, Mr. Carter did, that he drove over Mr. Jones. And Dr. Lippincott told you that there was a wound on the head, a bruising that could be consistent. We don't know if that head bruising was caused by running over. But whether it was intentional or not, we know that Mr. Jones would not have been in that road lying prone to get run over by the pickup truck if Brice Rhodes hadn't just shot him. So again, complicity, he's in it. Now, Jacory Taylor told you he was right next to Rhodes, and inside the Mazda when Rhodes shot and killed Christopher Jones.
Stop the car. You see somebody in the street. The Brice told me I was shot him.
Who shot him? Brice Rhodes shot him. Jacory Taylor told you he saw Brice Rhodes shoot him. Now, both of them described the Mazda in front, the pickup truck behind, and you saw on the Ring video that Detective Griffin found on the block that night, from that night, that there is a small car driving past, immediately followed by a pickup truck. And that tells you that they're not making this up. Jacory and Juan aren't making this up. Again, the shots that night, the one shot followed by 5. You heard that came in on the 911 call. Somebody said 1 shot followed by 5. Juan Carter told you that after Brice Rhodes shot Christopher Jones, they drove down the block a little way and he fired off about 5 shots at a house. 1 shot followed by 5. Now the defense pressured Detective Griffin on, why didn't you change the report when you only found 1 casing on the street? This is an example of why you don't change a report. Because it is a fact that the 911 call came in that way. Then later they talked to Anwan Carter. They find out why there are 5 shots following. And this goes to show that they're not making this story up. Anwan Carter was there that night. He wouldn't have known about the 1 shot followed by 5 that came in on the 911 call unless he was there. Now, this, he was in front. Jacory was in front in the Mazda. I don't know if he turned around, saw what was happening, and it makes total sense that he wouldn't have seen. He just saw Brice Rhodes kill a man. Makes total sense that he didn't turn around and see what Anwan Carter did with that car. So we know that they were there. I guess the defense wants you to believe that these kids just, took a Mazda and a pickup truck over there to commit this murder for no reason? That's what doesn't make sense. 15 years old, Larry was 14. And so Larry 14, Anwan 15. Then you have Maurice 16, Jacory 17. But these 4 teenagers drove over there. They were there because Brice Rhodes brought them there. And the rest of the story doesn't make sense except how they told it. Larry and Maurice started telling their mother Brice Rhodes was mad about it and he killed them for it. This crime had an effect on these kids, as Jacory told you.
You know, see a lot of that get shot. I'm not gonna lie, because I was doing this him too. He was also all of us.
You were scared? The words and emotions of Jacory Taylor, now age 25, having been to prison, having lived 7.5 years since that day. It affected him. It affected Maurice and Larry. And the defense pointed out that when Jacory Taylor first came in here, he wouldn't testify. He started to, then he stopped. It took a while. As they said, he was threatened, but that was with contempt of court, the same thing any witness has to abide by. You come in here, you have to testify when you're under subpoena. He was here for what is possibly the scariest thing that happens to anyone, to come into a courtroom, to talk about what happened, tell about something that's horrific, public speaking. And he had to do it in front of the defendant and in front of the families of the victims. So it is no wonder that he was scared, that he was emotional, that it took him a while to get there. So they were scared. Larry and Maurice told their mom. Did he tell you what did he do to them? Brice Rhodes said, we got to kill him. And we'll talk about the instructions later on, but this is how you know it's an intentional murder. He told them they were going to go kill somebody with Brice. Ended up being Christopher Jones. And look, we have no reason to think that Christopher Jones had a price on his head, and I'm not saying that the person who did have a price on his head, if that person exists, deserves to die either. No one deserves to die that night. He told that there was a person with a price on their head, and and that's why they were going down there to collect this money. You heard from and Jacory that the money was never distributed. So we don't have any proof whatsoever that Mr. Jones was anything but crossing the street. But that was Brice Rhodes' intent, to kill Christopher Jones, and this is his intent, to kill Larry and Maurice because they were telling. All right, now we come to Saturday, May 21st. Christopher Jensen told you that Rhodes borrowed his car that day, the Dodge Charger. Rhodes admitted in a statement that he probably was in front of Larry and Maurice's house in that car. Later, you have Jacory Taylor and Juan Carter riding around with Q. They stop by Maurice and Larry's. Boys aren't home. They eventually head over to Rhodes's. Q drops them off. Imagine how relieved Q is that he decided not to go in there that night. So Anwan and Jacory arrive. Everything's fine at first. People present are Rhodes, Larry, Maurice, Tyrone Coleman, unknown male, unknown female. I have a few things to say about that while we're here. The unknown female and the unknown male have never been identified because Detective Tonelli has nothing to go on with their complexion and their gender. These were a 15-year-old and 17-year-old witnesses at the time. They went into a house. They weren't introduced enough that they retained names from this situation, if they were introduced at all. Hung out with these people. Female left. The other guy stayed, but they couldn't describe him any more than light-skinned male. So Detective Tonelli can certainly not go rounding up every white female and every light-skinned male in this county, nor do we want him to. He could not continue that investigation without more to go on. But Anwan Carter was able to give him more about Tyrone Coleman. At the time, he was describing him as a dark-skinned male and was able to point out a rap video, local rap video that fellow had appeared in. So based on that, Detective Tonelli was able to build a photo pack, show Anwan Carter, he identified it, and then the investigation into Tyrone Coleman took off. So with enough information, of course, he continued the investigation. He would have liked to have done it with the other individual, but he did not have that extra clue as to what direction to take the investigation in. Now, Tyrone Coleman is obviously not here. You know that his case is being handled separately. If you believe the rest of this beyond a reasonable doubt, then that's one of those things I talked about in voir dire. Sometimes you do have questions. You're sitting there in the jury room, you might be like, well, I really would like to know why Tyrone Coleman wasn't there. If it's not A or B or C on the jury instructions, if it does not affect your reasonable doubt of those questions, set it aside. It's a question that you can ask afterwards, but do not let it affect you now if you believe everything else beyond a reasonable doubt. All right, to return to the events of that evening, we heard from both Anwan Carter and Jacory Taylor. Jacory and Maurice got into it. Maurice grabbed a knife. Jacory jumped back. Brice Rhodes took the knife from Maurice and hit Maurice. He then powwowed with everyone else. What Anwan Carter described as a vote and Jacory described as a conversation. Anwan remembers being the only one. Jacory remembers that he and Anwan did not want to do it. I don't know how he was phrasing things. I don't know what Anwan picked up from him. They are both telling about their memories. I skipped over this one. Purchase in a trailer park. I don't remember that, but if you do, go with your memory. But obviously, as far as the events of that night with how this gun was purchased, as Jacory Taylor was the one who purchased the gun, we have a great anyway, votes for conversation, discussion. But what is important from that is that Brice Rhodes was still planning to kill them. He still had the intention that they die that night, but he wanted to make sure that everybody was involved. So he tied up Maurice, had Jacory punch him in the stomach as a violation, discipline, I guess. And then he began to stab Maurice over and over.
How many times did Brice Rhodes stab him? Where did he stab him? Was he standing up or was he on his knees?
It's on his knees.
And he stabbed him in the chest.
Chest, stomach. His chest, stomach, on his torso.
He stabbed him other places. How long did this go on for?
Until he stops breathing. You saw the autopsy photos. You know that he was stabbed over and over. Larry was in the bathroom. Rhodes dumped Maurice by the door and had them bring Larry out. And he stabbed Larry over and over. And again, you've seen the autopsy photos. We'll have them back there. I don't want to show the courtroom, but we heard the testimony.
Did you know what happened to his brother? Was there blood in the spot that he was at? Did he respond to that?
Kick everything off. Get his hands intact. His hands free still.
Was his brother making any noise at that point?
He did.
So how many times did he get stabbed? Just stabbing.
He stabbed until he's dead.
Brice did.
He passed the knife on him.
Who did he pass the knife to? Why did he pass you the knife? They're both dead, right?
We all would be in it. So no, it's good.
He said, we're all going to be in it. He wanted it to be on all of them now. He had learned his lesson on people talking. Jacory's description was similar. Who stabbed Maurice? Was Maurice tied up at that point? What was used to tie him up? Okay, who did the tying? Where did you see where he was stabbing him? Do you know how many approximate times it was? What was Maurice doing while this was going on? Who was in the room while this was happening?
Brice, two other people. He's pretty much fighting like Johnny. He made him one stab. Once he was stabbed, two of the people that was in there, I didn't really know. They was already there. So I'm thinking, my man, they do stay in there. Where if somebody's gonna do some hustle, I'm trying to interrupt things. They all, I don't know, but that's what he wants to do. Larry was in the back. The same thing happened to Larry. Once he did Larry, he didn't step Larry.
Dr. Lippincott told you that the cause of death was multiple stab wounds. She said Larry had 21 stab wounds. You can see in Maurice's autopsy photos that he has 8 to his abdomen alone, other wounds to his back, other areas of his body. Dr. Lippincott told you the areas, abdomen, torso, pelvis, back, groin, genitals. Rhodes made Anwan and Ja'Cory clean the house while he took the bodies over to River Park and set them on fire. He later drove the boys around to various dumpsters burning evidence. The knife was never found. We introduced photos of the knives that were collected to show you that police collected what they could find. We don't know, maybe those are the murder weapon. I don't think so. They don't match the description. They drove around different dumpsters that night, setting different dumpsters on fire. I would assume that's where the murder weapon is. As Detective Peters told you, there were approximately 7 reports of dumpster fires that day. And by the time 2 days later that he was checking, most of them had already been emptied. It's actually amazing that the pink blanket with Maurice's DNA on it was located. Anyway, that night, they noticed the back seat was bloody. So Rose tore it out and dumped it behind someone's garage, as Anwan Carter told you. Before I turn the page here, whether Taylor sold the boots, he said that he and Maurice both had those boots, that they started out as his, he went with Maurice. He didn't remember how the boots got there that night. He took the boots at the end of the night, though. And they had blood on them, which is all part of the investigation. Now, yes, their stories are inconsistent on these points. I think there's an explanation for each one, but I also think this shows you that these stories were not concocted. They didn't sit there and memorize each other's statements. They came in here and told you about something they remember from 7 years ago. And these are all minor points. It's sorts of things that would become fuzzy after 7 years. The things they did say, the things they do remember, that Rhodes tied up Maurice, that Rhodes stabbed Maurice, that Rhodes made them participate, that Larry was stuck in the bathroom, that Rhodes tied up Larry. Those are the things they remember because that's what you would remember from all of this. All right, we've heard a lot about the police investigation over the past week, so I'm just going to summarize because I know you all took in all this information, witness after witness. The response to River Park, the lack of any identifying information on the victims, how the police were trying to figure out who they were. It was not until Olmsted Academy contacted police and they realized that it was Maurice and Larry that the case moved forward. Detective Tonelli went to Elizabeth Wren's house, spoke to her brother TJ. TJ Wren led Sergeant Vance to Brice Rhodes' address on Hyde Avenue. Vance saw Rhodes go into and out of the apartment and then followed him until they could take him into custody. In the defendant's interview, he admitted knowing the boys. You might have noticed, though, that he chatted with the detectives for quite a while. They were phrasing it as a missing persons conversation. Chatted with them for a while before he said, "Oh yeah, TJ told me they were dead." Which would be a little odd if he weren't involved with this. He admitted he was probably in front of their house in the Charger the last day they were seen. And yes, Detective Tonelli said that was on video, and it wasn't on video. But that's a police investigative technique. Police don't walk into an interview room and say, excuse me, have you participated in 1 to 3 murders lately? No? Okay, well, thanks for your time. They have to use techniques to get people talking, and that was one that they were attempting. And he did admit to being there, probably. Okay, meanwhile, while this is going on, detectives are over on Height serving a search warrant. And no, there was no bloody scene when they walked in. Why? Because the boys spent all night cleaning it up at the direction of Brice Rhodes. They collect the knives because they know that this is a stabbing case, possible murder weapon. Meanwhile, you have Sergeant Vance and the marshals pinging Maurice's phone, finding it with Anwan Carter, who was so young and naive that he didn't know that police could track a cell phone. Anwan Carter was interviewed. And he didn't change his story multiple times. He changed it once. In the beginning, he told them that he didn't know what happened. Then his mother and sister arrived. He spoke to them. He asked to speak to police again. And that is when he changed his story. That is when he told police about his involvement and the involvement of Brice Rhodes in this case. Months later, he repeated it at a proffer at the time of his plea, and in court, he repeated it to you. But it's important to note that he was already saying this long before the prosecution of the case and any sort of plea negotiations had started. He admitted his involvement, and he talked about doing anything he did at the direction of Brice Rhodes. He talked about Brice Rhodes wanting to kill Maurice and Larry and killing Maurice and Larry, wanting to kill Christopher Jones and killing Christopher Jones that night that he was picked up, May 24th. Thus the second search warrant, because now police knew where the murder happened. And you saw the pictures of the carpet being pulled up. This is not something police are going to do willy-nilly at everyone's apartment that's involved in a crime. They needed a second search warrant because now they knew that this was a murder scene. And so now they had enough probable cause to go in and rip carpet up. And yes, the video was dark that you heard from Rebecca Kimmer. They tried to get it on video. It was dark. That's why they turned to the next step, which was just taking the carpet itself and testing that for blood. The police also interviewed the person who had rented the car that Rhodes was driving that day, who happened to be his neighbor, who was able to direct police to the blue Mazda with no backseat, reeking of bleach. Both cars were processed. Other people were interviewed, some of them with no further information. There was a child at Olmsted who was interviewed, Brice Rhodes' mother, cousin Q. The next day, Corey Taylor was arrested and interviewed. Detective Peters and Metzler were finishing up the dumpster search, and later Sergeant Vance collected the boots. So what do we know from all of this? From the second search warrant, we know that the carpet was covered in blood, as was the carpet padding. And we know, because Stephen Barrett, the analyst from the lab, told you, the blood matched Larry at an estimated frequency in the nonillions, which is far higher than the billions of people that are on the earth today. So there's a 1 in nonillion chance that that wasn't Larry's DNA. So they took various cuttings from the carpet. On one of them, exhibit 24-1, it was Larry plus one other person. On the other one, it was Larry. From the carpet padding, same thing, Larry and one other person. The DNA for the other person was too limited to make a determination. But this makes sense, as Larry was the second person to bleed out on the carpet. What else do we know about from the apartment? Thought that was interesting. I'm not saying that everybody that bought White Castle that weekend was involved in this, but I do think that's interesting. All right, we know that these sheets were off some of the beds, pillowcases off the beds. And we know that a lot of bedding was found in that dumpster, burnt and bloody. What do we know from the dumpster search? We know that Detective Peters, Detective Metzler were faced with a dumpster full of trash. We know that the reason they were looking in dumpsters at all was because the back seat was missing. They wouldn't have gone out just to search for one pink blanket. But fortunately, that's what they found. We'll get there in a second. So they come to this dumpster, it's full of trash. They call in and say, found it, thinking that some of this was going to be the backseat material. And that's what Detective Tonelli was left with. This search you heard took hours. It took well past midnight. He'd been told they found the backseat, and they did not come back to him at the end of this and say, we found a lot of bloody sheets and blankets and towels, but we didn't find the back seat. He just did not get that information. So when he went to testify, he testified in the probable cause hearing that he believed they had found the back seat. He qualified it. He said, further testing, we're awaiting further testing, but we believe we have the back seat, because that's what he believed at that time. And it was not until he started getting all the reports, and really, he's got other cases going on. I mean, we all wish that we were all straight on the back seat from the very first moment. But yes, he's got other cases going on. We were sitting here. The judge said, what's the biggest thing you've got to bring in? He's speaking from memory about reports that he looks at from time to time, but didn't study up on before every court appearance. And he said, probably the back seat. If he could find the back seat, he would have brought it to you. He would have tested it. But that back seat was never found. And we know what happened to the back seat. Something that police only found out about later at a subsequent interview when Detective Tonelli did say to Anwan, what happened to the back seat? And Anwan told him and tried to show him on his phone, tried to show him where the garage was, but only knew the neighborhood, didn't know the exact location. All right, so we have the dumpster. We have the pink blanket found in the dumpster. As Stephen Barrett told you, from the pink blanket, in two different spots, Maurice's blood was recovered. Now, while we are on the subject of the labs, what else do we know? The tire tracks from the scene were compared to the Mazda tires. Scott Doyle told you it's really difficult to get a comparison on tires, and in fact, in this case, he was not able to identify or eliminate the Mazda. The shoe prints, he was able to eliminate those shoes from the shoes that Brice Rhodes was arrested in. But we don't know what shoes he was wearing that night. I wouldn't be shocked if they weren't burned in that dumpster or a different dumpster. From the Mazda, swabs were taken from the driver's seat back near the headrest. They were presumptively positive for blood, and Stephen Barrett was able to find a partial DNA profile, mixture of at least two individuals. Due to the limited nature, no meaningful comparison could be made. So blood was found in the Mazda. It was not found on the parts near the where the back seat would have been, either because that area was bleached. Two different detectives told you the car smelled heavily of bleach, and the analyst told you that bleach can degrade a sample, or because the blood was on the back seat that got ripped off. Anwan told you that that seat was covered in blood, and that's why Brice Rhodes decided it had to go. That's where the blood was in the car. And the reason that it is not here in these lab reports for analysts to tell you about it is because Brice Rhodes got rid of it. Now, Brice Rhodes' DNA was not found anywhere but on the gear shift or the steering wheel. That's true. But you know who else's DNA is not anywhere on these lab reports. And Juan Carter and Ja'Cory Taylor. The reason that Rhodes's DNA, Ja'Cory's DNA, and Juan's DNA is not all over the place is because they are not the ones who are bleeding out on all these pieces of evidence. It is Larry and Maurice who are bleeding on the evidence, and it is their DNA who is found. If they want to say that because Rhodes' DNA is not on anything, he wasn't involved in this, the same would hold true for Ja'Cory Taylor and Juan Carter. Their DNA is not on it either. We know they were involved in it because they told you. So the same logic does not exonerate him from that analysis. The DNA in Rhodes' apartment, the DNA on the blanket in the dumpster, the ripped out back seat, these all corroborate what Juan Carter and Ja'Cory Taylor told you. Obviously, the defense does not want you to trust them. They asked in opening, why are Taylor and Carter still alive? Well, one, they weren't the people who told their mother. Two, he had learned his lesson and made them get involved in the second one. And three, the police put an end to this before anything could happen in future. We don't know what would have happened 2 weeks later. Carter told the truth 2 days after the murder, after initially not, but then talking to his mother and sister. Do you think that his mother and sister came in there and said, I've got an idea. Why don't you tell them that you're involved? Why don't you tell them that you stabbed them too? That's a great idea. No, they went in there and said, tell the truth. If this were not the truth, he would have said, I was just an eyewitness. I just saw it happen. I didn't do anything. The fact that Carter gave them so much information that led to his own conviction for facilitation of murder corroborates his statement. Ja'Cory, the next day, May 25th, said he didn't know anything about it. I'm sorry, there's the monster.
What do you all notice about the car?
Hold on. Why didn't you and Anwan just leave during the night?
So
Why didn't you? Well, he was gone. So 2 days after this whole situation, he's forced to participate in the murder, scared, not leaving. 2 days later, he's in an interview room, alone, no father, no mother, no one to talk to, knowing that the last people who told what had happened had ended up stabbed multiple times. So he told police he didn't know what happened. It was not until later, when he had been in custody, ironically safe from this whole situation, until he had an attorney, until he had time to think about this, that he came forward. I'm gonna return to the slide that I had skipped. This is back to the back seat. I just wanted to play this for you in case you missed it. Oops.
What do you all notice about the car? The back seat. And so, how was that handled? Cut the back seat up. And who cut the back seat out? What did he do with the back seat after he cut it out?
So that's why we don't have the back seat. Okay, hold on. I'll get to this in 1 second. But first I wanted to say, if you don't like the plea deals I did with these co-defendants, that's fine. I mean, that's my signature right there. You can write on the back of your jury forms, I think they got too much time. I don't think they got enough time. I don't think you should have amended down. Well, I don't know how you feel about this. So you can call me up later, look up my office number, call my office. But if you believe what they told you, if you believe that he's guilty beyond a reasonable doubt, then your feelings about this plea deal don't affect your verdict. I had to make a decision on what to do with Ja'Cory Taylor and Amon Carter. And one of the things that I knew was important was getting you all the evidence that you heard in this courtroom. And these are the sorts of things, sorts of decisions that we have to make in courtrooms all the time. Because the witnesses to crimes are often also the participants in crimes. So if you are mad at what I did, that is fine, let me know. But that doesn't mean that Brice Rhodes is not guilty of murder. And so let us talk about what you would need to find under the instructions. So it's actually very logical. You go through page by page. You start with 1A, and then the language for murder and the language for manslaughter second is the same for each victim. I just picked Maurice here because he's the one in the middle. And what's in parentheses is the things that change from instruction to instruction. So for Christopher Jones's murder, it says the 4th day of May, 2016, and shooting him with a gun. Obviously for Larry's, instead of Maurice, it says Larry, but the date and the manner are the same. But so for each count of murder, your analysis is the same. You shall find the defendant guilty if you believe beyond a reasonable doubt that in Jefferson County, the instructions actually say in this county, but it's obviously Jefferson County. You saw the map. On or about the dates in question, that he killed each victim by himself or in complicity with others. And we've gone over all that. By shooting Christopher Jones, by stabbing Maurice and Larry. And that in so doing, he caused the death of each of them intentionally. And there's going to be an or that I'll flip to in just a second, or wantonly. You know it was intentional because he planned it, he premeditated it, he told the witnesses in advance that he was going to do it, and then he did it. But let's go to the or that in so doing, he was wantonly engaging in conduct which created a grave risk of death to another and thereby caused the death under circumstances manifesting extreme indifference to human life. So I'm going to flip up to the definition of intentional and wanton. Intentional is what you think it is when the objective is to cause that result, in this case being death. Wantonly is when someone is aware of and consciously disregards a risk, a substantial and unjustifiable risk that the result will occur. And the risk must be of such nature and degree that disregarding it constitutes a gross deviation from the standard of conduct, standard of care that a reasonable person.
And it looks like we have a sidebar. We weren't done yet, so
So if you believe that he's driving down the road, shooting his gun, not specifically intending to hit and kill Christopher
I'm
Jones.
sorry, can you all approach for just a moment?
Let's take a look. How long has the prosecution been going? Okay. Looks like she started 47 minutes ago. Each side was projected to take an hour.
Sorry, to make it clear, I'm giving you an example of how this could be a wanton murder. I'm not saying this is the only way it could be a wanton murder. So for an example, because wantonly means that somebody is aware of, okay, first of all, wantonly is not intentional. So that's what I'm saying. It's like we've moved past you. This is only in the circumstance where y'all think it's not intentional. So it would be wanton if you believe he's aware of and consciously disregards a risk. So he's aware that shooting somebody is dangerous. He consciously disregards the risk that shooting out the window he could hit a passerby. And that the risk of him hitting a passerby is of such nature and degree that disregard thereof constitutes a gross deviation from what a reasonable person would do. So if you think a reasonable person would know, I shouldn't shoot out the window because I might hit somebody, and that disregarding that is a gross deviation from reasonable care, and that he understood that risk was there and he consciously disregarded it, that would be an example of a wanton murder. So just to go back to this, if you believe that he intentionally murdered Christopher Jones and or Maurice Gordon and or Larry Ordway, or you believe that he wantonly murdered them, so the same with the stabbings, like that he was engaging in conduct that he didn't intend to cause murder, but it was such conduct that one would know could cause murder, that he knew it could cause murder and that he did it anyway, and a reasonable person wouldn't continuing to stab somebody. That would be an example of a wanton murder with a knife in this circumstance. So if you believe that he intentionally murdered, let's just say Maurice, that he intentionally murdered Maurice, or some of you believe that he wantonly murdered Maurice, all you have, because you see that this is an or situation, as long as all of you believe.
Mm-hmm.
So as long as you all believe that it was intentional or wanton, then all of you believe it was murder, obviously beyond a reasonable doubt. So to start at the top, because I know this is really complicated, but I don't want to think that I could have explained it better and I just failed to. So in Jefferson County, on the date in question, by himself or in complicity with others, he killed Maurice Gordon by stabbing him with a knife. And we went over the complicity instruction earlier. That it was intentional or that it was wanton. So as long as you all agree that it was murder, then you can sign the verdict form for murder. Now, there is a sub part down here in your instruction for example on page 14. So the foreperson would sign either not guilty or guilty. So that part, you have to sign one of these, not guilty or guilty. Then, if you found him guilty of murder, you add in there if you agreed all 12 that it was intentional murder. So your choices on each of the murders is either not guilty, no more signatures, or guilty, and then maybe you all agree it's intentional and you sign there, or you don't all agree it's intentional and you don't sign there. So one of these top two has to have a signature, and then it's up to you as to the bottom whether it is in agreement that it's intentional. I apologize that our state gives, these are the instructions that we have. All right, so those are for each of the counts of murder. Now, if you don't find him guilty of murder, you go on to manslaughter in the second degree. If you do find him guilty of murder, you skip the manslaughter in the second degree. So it's murder, or it's manslaughter, or obviously not guilty, but you wouldn't find him guilty of murder and manslaughter for the same victim. It's one or the other. Now, you only go to manslaughter in the second degree if you have found him not guilty of murder. So if you do, you will see that the main difference is that there's no intentional on there. And that in the second clause, it just says that he was acting wantonly. So that A is he killed Maurice Gordon by himself or in complicity by stabbing him with a knife. And B, that in doing so, he was acting wantonly. So it omits the intentional and it omits the grave risk of death to another, etc. But you don't get there unless you found him not guilty of murder. And I believe, obviously, that we have proven, for all the reasons I've stated, that this was an intentional murder. Now, there are 3 more charges. We have abuse of a corpse. And as you can see, that instruction defines each of the elements as on the 22nd day of May, 2016, he, alone or in complicity, placed the body of Maurice and the body of Larry in a yard off an alley and attempted to burn it, that he had no legal authority to do so, and that in so doing, he treated each body in a way that would outrage normal family sensibilities. I think that's obvious. The other, well, here is Ja'Cory describing his knowledge of this. And he told you the bodies were burned? Did he tell you where he dumped them? West End somewhere. Then the last one we haven't discussed is tampering with physical evidence. You have to find that on May 22nd, he, acting alone or in complicity, destroyed, mutilated, concealed, removed, or altered items from the North Height address, including a pink blanket or the knife or the back seat. If you believe that any of those items were tampered with, then this would come into play. That he did so because he believed that an official proceeding may be pending. That would be the investigation and prosecution. And that he did so with the intent to impair the availability, so that he burned the bloody clothing so that police couldn't find them and that we couldn't bring them into this courtroom. He ripped out the back seat so that police couldn't test it. We couldn't bring it into this courtroom.
Who's driving the car? Where do you go to? We're going to like different houses. Symptoms on fire. Why different houses? Just spread evidence.
What type of evidence?
It could have been clothes, it could have been, you said, receipts on it, whether you call it some evidence.
And was it stuff with blood on it? What did you all do with that stuff?
It was took to a dumpster.
that is how you know he is guilty of tampering with physical evidence. I have one last slide to show you. Jacory Taylor was 17 when this happened. He's 25 today. Anwan Carter was 15 when it happened. He's 22 today. They've both been to prison. They've both paid a heavy price for not having the courage, confidence to stand up to that man. Nothing compared to the price paid by the victims, obviously, but a price nonetheless. Brice Rhodes preyed on this group of children. He killed an innocent man for no reason. Then he killed 2 children for a horrible reason, because they confided in their mother. There is no other explanation, no other possible motive or defendant to explain why those children were murdered so horrifically. Please bring this 7-year nightmare to an end and find Brice Rhodes guilty of these murders. Thank you.
Ladies and gentlemen, at this time, we are going to draw who our random jurors will be. Counsel, would you all mind to come up? Thank you all. All right, I'm going to tell you who the alternate jurors are. I'm sorry, John, would you mind to move that easel? All right, so I have drawn randomly, literally out of a glasses case, our 2 alternate jurors. Those 2 of you, I'm going to ask you to remain seated. The rest of you will go with Deputy Mills back to the deliberation room. And Deputy Mills, I just need to swear you, please. Do you swear that you will keep the jurors together and allow no person to speak to or communicate with them on any subject connected with the trial, and you will not do so yourself? All right, thank you. So the 2 jurors who will not be going with Deputy Mills are a juror ending in 8801 and juror ending in 9462. So if you all could just stay here, please. The rest of you will follow Deputy Mills.
Can we take this?
No, your notepads have to stay here.
So the only thing we can take is this. Correct.
Cannot take your notepad with you. I said that. Yeah, sorry. I did say that at the beginning as well. And just remember, you'll have 1 copy that you'll have the 4-person sign. All right, for the 2 alternates, can you all come up here, and counsel, you can come up as well. The camera will need to go off now.
It sounds like they're going to go ahead and deliberate today. I don't see that it's going to be several hours. I mean, I think in 2 hours they ought to be able to do it. I mean, it sounds like there's several different charges. I mean, they could find him guilty of, say, the first murder but not the latter, or the latter but not the first, or they can consider all of them, or not desecrating the corpses. So there's a few different permutations, but to me it seems fairly simple. I mean, he was the ringleader. He had sway over these younger, impressionable youths. I don't think that they would have committed any of these crimes had it not been for him. And I think that he knew that they were juveniles, and he was probably banking on the fact that he thought that they wouldn't get prosecuted. And so, put it all off on them. And it didn't work out that way, sadly, for
All right.
I mean, these young kids ruined their lives.
All right, so we are going to go ahead and let you all go since I have your contact information. But like I said, there's a slight chance, something could go wrong. We could need one of you to come back. So in the meantime, you remain under oath as a juror in this case, and you remain subject to the admonition, which I'm going to read one more time just to be clear. You must decide this case based solely on the evidence presented within the four walls of the courtroom. You must not use internet search engines, websites, blog, or any other electronic tools to conduct any research, post information, or help you deliberate. During the course of the deliberations, do not communicate online with anyone connected to the trial, including witnesses, lawyers, other jurors, experts. And if you accidentally encounter any information about the case from any source, immediately bring it to the attention of the court. The other thing that I'm going to do is, because I think what I'm probably going to do is just call you all when we have a verdict, since I've got your information, and then you'll know. I will call you and say, hey, we have a verdict. You're officially relieved from duty. And then if you want to know what it was, I can share that with you as well. Okay. All right, so you all are free to go, and the next time you hear from me will hopefully be me telling you that we have a verdict and will not need you, okay? All right, thank you.
Thank you.
Okay. Are we going to get the feet of the jury?
And you all do not need to go to the jury pool room. You can go straight on out. Thank you. Do we have anybody that might be able to just kind of watch them walk to their car?
What do you need?
I'm wondering if we have somebody that can just kind of observe them walk to their car.
Sure, which ones?
The people who just left.
Okay, I'll have to catch up with.
Okay, well then let's go. I mean, you all also have walkie-talkies. Maybe you could call down to the first floor or something. All right, Mr. Griffith and Commonwealth. I have your all's phone numbers. I do not have your co-counsel's phone numbers. I have Mr. Cunningham's. But typically what I'll do is send a group text to all of the attorneys when there's either a verdict or a question.
Traditionally, what happens with Mr. Rhodes is to stay in the courtroom? Does he go back?
No, we'll let him go back, We'll let him stay up here for a while. Who knows? You know, we might get a verdict pretty soon. But he doesn't really matter to me, honestly.
I don't think he ever really had food. Generally,
Okay.
if there's any chance of.
I mean, the jail's not going to deliver food on demand, Mr. Griffiths. I don't know if you've met our jail. But you all are welcome to get him food.
Great.
Honestly, I shouldn't say that. They probably would.
No, I totally.
But I bet Mr. Rhodes would. Yeah, I know. They wouldn't be happy about it. That's for sure. Thank you. I got it. All right. Tie first 433, 434. I see it now.
Sorry, it's a new
Okay.
number.
It's okay. I got it. I'm just going to go ahead and put you all in here.
Find it interesting to listen to the banter of the people in the courtroom. They always seems to be a lot of sternness and so forth, but when they're off the record, surprising how much bon ami there is. Okay. The jury's been deliberating for 5 minutes in theory. Let's call it 1:45 is when it started. And let's see. Take a look on YouTube and see if there is anything breaking that we need to take a look. Oh, this looks interesting. It says Stephen Smith's tablet unlocked after 8 years after the murder. So let's take a look at that, because that's an interesting case. Let's just get this set up.
Death was initially ruled a hit and run, but in March, SLED announced that they would be devoting more resources to the case as they investigate it as an intentional homicide. Now, 8 years after Stephen Smith's death, investigators are saying they've unlocked his cell phone and his tablet. On Friday, we spoke with a former investigative consultant for the Smith family, who told us that Smith's phone was unlocked years ago.
I find it kind of interesting that they're making this announcement now that they have access to the phone, because when I got involved in this investigation at the time of the Murtaugh murders, when Maggie and Paul were killed, and I first got involved, you figure that was nearly 3 years ago now. It will be 3 years this coming summer. But at that point, the phone had already been accessed. I was given a DVD of all the photographs that were removed from the phone and given to Stephen's mother, Sandy. So law enforcement had access to it back when I got involved over 2.5 years ago. So I don't know what this revelation is that they just got access to it.
All right, so let's bring in our special guest now. He is the attorney representing the Smith family, attorney Eric Bland. Eric, good morning. Good to see you. I was so surprised on Friday when I was getting this information. We had to give you a call and ask you to come on the show and clear things up for us, please.
So Mr. Peterson's slightly correct. The phone has been unlocked for a number of years. What hasn't been unlocked was the tablet. The tablet was not destroyed to the point that what was on it was not recoverable. The tablet, and I think I have confirmation, has been unlocked within the past year. And so now we have additional information. And from what we understand, Stephen communicated a lot with the people that he was associating with and the people he was dating on his tablet. So SLED obviously isn't going to tell us what they're learning from both the phone and the tablet, but this is something new that didn't exist when Mr. Peterson was performing services for the Smith family. The family is a little bit perturbed that, he's out there talking about the investigation when he was the investigator. He doesn't really have the authority to do that. The family doesn't want him talking about it, but it is what it is. He was 50% correct.
Gotcha, Eric. Okay, so correct on the phone aspect, incorrect on the tablet aspect. I have a clip where he is talking about the tablet. Let's take a look at that.
So Stephen's mom turned over the tablet to these two investigators. They refused to say who was paying them, who they worked for. They didn't say. That's a whole nother can of worms. When I got involved, I asked for the tablet. I went back to these two guys and I said, give me the tablet back. They refused to give it to me back. Then I found out that they had destroyed the tablet. SLED got a search warrant to go to them to retrieve the tablet because they wouldn't surrender to SLED either, and they destroyed the tablet. So to my knowledge, the tablet has been destroyed and there was no information that was recoverable.
Okay, and so Eric, you can hear me gasping there as I'm listening to him talking. So that's the incorrect part of this. Thank goodness the tablet is in existence, recovered, and perhaps right now, as you and I are talking, SLED agents are looking through it.
Well, yeah, I mean, that's what happens when you have a number of people talking on about Stephen's case that really aren't authorized to do it and don't have the up-to-date information. And what ends up happening, Julie, is, a misstatement travels halfway around the world before the truth can lace up its shoes. And this has kind of taken on, a life of its own about the tablet being destroyed. Yes, it's true that these investigators came to Sandy and she was kind of bullied into giving them the tablet. Don't know whether they, were cooperating with SLED at the time. I'm not familiar with that, but I do know that SLED has the tablet, and I do know that it probably will yield some information.
That's got to be very encouraging for Sandy Smith, your client, Eric. Could we talk about her?
She needs answers.
As you know, the victims, I mean, they're what this case is about. They're the center of it. We know there's a lot of attention all around the world. But the Smith family, how are they feeling knowing that this could lead to something?
I'm cautiously optimistic, because every time something happens with Alex Murdaugh, this investigation gets pushed to the back burner. I'm confident, though, that SLED wants to get answers for this. They're clearly now under the microscope, and it's our chief law enforcement agency in our state. And if they can't solve this crime, or at least provide Sandy with answers, it doesn't look good for them, because obviously they've been able to solve everything concerning Alex Murdaugh. And I do believe that the same people who have been in the orbit of Alex Murdaugh's machinations and all his different things that we've talked about over the past 3 years, whether it's the murders, the financial crimes, and the problems with, Paul, all those things. I do believe that everybody who's been in that orbit has knowledge of what may have happened to Stephen. And the one question that Buster has never been asked and Buster never has answered is, does he have any knowledge about what happened to Stephen? I have no knowledge that he's part of what happened to Stephen. He clearly denied that. He denied that he had a physical relationship with him. But I think the one question that needs to be asked to Buster, and he needs to answer, is, does he have any knowledge of what happened to Stephen?
I love it, Eric. I love it. He should be asked that question. He should be interviewed if he hasn't been interviewed already. Eric, curious if I know certainly if SLED's conducting their investigation, they may be giving you limited information as the attorney of the Smith family. Have they said anything about whether they've interviewed Buster or not?
Chief Keel won't provide that to me, but what he has said is that this is very much an active investigation, and that there are a number of issues that he has to get answers from several people. And as we have learned over the course of the spring and summer, last summer, there are 5 to 6 people which SLED believe have information as to what happened to Stephen.
Eric, thank you for that. One thing that always troubled me, I'm sure it does you, and we've touched on this before, but I want to play a clip about it from your client, Sandy. It's the information about the Murdaughs, Alec and Randy Murdaugh, being at the scene. To me, this just stinks to high heaven if they were there. Let's watch.
When they removed his body from the road, and that was about 9:30, I seen me and my daughter and my son, Chris, seen Alex and Randy Murdaugh at the scene. When Joel was at the sheriff's department, him and Stephanie were at the sheriff's department, I was on the phone with Joel, and Joel said, "Hold on, Randy Murdaugh's calling." And so he said, that was strange. And I said, what was it? He said, Randy Murdaugh called and wants to help with Stephen's investigation.
So the civil attorney, 2 civil attorneys, really, because that's mainly what Murdaugh was, part-time prosecutor, a disgrace to the badge, as we know. But they're there. This just is so troublesome, isn't it, Eric? Have you learned any more about that since the last time we've talked?
I have. Randy claims that he was there because Sandy's ex-husband, Joel, who was representing, Randy was representing Joel on a workers' compensation case. He said that he was asked by Joel to go to the scene, which kind of makes sense. The question is, why was Alex there if he was there? Now, according to Randy's attorney, Randy said he was not there at the time that Sandy said that she saw both Alex and Randy at the scene. His attorney says that they were there the following day, and it was Randy and an investigator. Now, I've known Sandy Smith now for well over a year and a half. She's pretty smart. She knows what she saw, and she's pretty good with facts. Now, simply, we have a dispute and a credibility issue. The police will be able to solve that. The investigators who were there. Police were there at the scene, according to Sandy, and she said she saw Randy and Alex. All SLED has to do is ask those police officers, did you see Alex Murdaugh at the scene? And that'll answer that question.
That's right. Well, and Sandy Smith has a lot of credibility, as you said, Eric. She knows what she saw. She knows who was there. And certainly it's in the Murdaugh's interest not to be there at the time that she said she saw them, because it really looks fishy. It does. And we know Alec Murdaugh, anything he says,
Similar
you can't believe. Please, Eric, go ahead.
Similar to Julie. Similar to when Alex and his father showed up at the boating accident on the marina and then went to the hospital. It looks like that they're trying to possibly shape an investigation.
And if they did, we could see more charges brought against Alec Murdaugh if he did try in some way to exert improper influence over this one. We've got to leave it there for now. But Eric Bland, thank you so much for your time and all the information you're sharing on this one. Give our very best to the Smith family, if you would, please.
Merry Christmas.
Oh, Merry Christmas to you and yours, Eric. Thank you so much.
Okay, let's see what else we can find. That gotta agree, if the families had it for months, and then what's the big deal about announcing it? I mean, why announce it now? Okay. Let's see what else has come down. Scrolling down. Let's see. Okay, aside from that, I don't see anything which just posted, so let's take a look and see what's still streaming. Okay, it looks like court ended 4 minutes ago in Colorado on the Elijah McLean case. So let's check my playlist. Oh, here we go. Full video, Frankie's court appearance for the plea.
Good morning. Welcome to District Court. We're here in the matter of State of Utah versus Frankie, case number 231501764. Mr. Winward is here representing Ms. Frankie. Let's bring her out. Mr. Schommer here representing the State of Utah. Ms. Frankie is now here. Mr. Winward, we are scheduled for a waiver hearing. Is there going to be a waiver today?
There will, plus a plea agreement, Your Honor.
All right.
I'll ask the bailiff to hand you if it's been executed.
All right. Mr. Winward, you have discussed with Ms. Frankie a preliminary hearing, what's involved in a preliminary hearing. She understands she has a right to a preliminary hearing on all of the charges in the case. She understands what the charges are, and she's prepared to waive a preliminary hearing in the case on all charges.
She is, and that is contained in this agreement on page 7 as well.
Very good. All right, I've been handed a plea agreement, and it appears to be signed by Ms. Frankie. Ms. Frankie, did you sign this agreement?
Yes.
And you did that today? When did you sign it?
The 18th,
Okay. You've read it carefully?
every word.
Your signature represents to the court that you've read it carefully, that you understand what you've read, and that you agree to all of the terms. Is that all accurate?
Yes.
You've had sufficient time to ask questions of your counsel, to go over any questions you have. You're ready to go forward.
Yes,
You don't need any more time.
I'm ready.
Ms. Frankie, is anyone pressuring you to enter into this agreement?
No,
Anyone promising you anything I haven't been told about?
no,
Anything that's not in the written plea agreement?
no,
Are you under the influence of alcohol or drugs today?
no,
Is there anything today that could in any way interfere with your ability to understand the agreement, its consequences, anything?
no,
No physical condition, no medication, nothing?
no.
Any further record, counsel?
No, Your Honor.
Mr. Windward, we ready to proceed?
We are ready to proceed.
All right, then. Ms. Frankie, how do you plead to count 1, aggravated child abuse, a second-degree felony?
Guilty.
To count 3, aggravated child abuse, a second-degree felony?
Guilty.
To count 5, aggravated child abuse, a second-degree felony?
Guilty.
And to count 6, aggravated child abuse, a second-degree felony?
With my deepest regret and sorrow for my family and my children, guilty.
There is a factual basis set forth in the agreement that is a stipulated factual basis, counsel.
That's correct, Your Honor. That is correct, Judge Walton.
The court finds that the factual basis is sufficient. All of the terms of the agreement are stipulated, including that the court obtain a pre-sentence investigation report, correct?
Correct.
There won't be any argument about whether prison is the appropriate sentence, and there's an agreement about the 4 counts running consecutive.
That is correct.
All right, the court finds then that Ms. Frankie's pleas are made knowingly and voluntarily. The court therefore accepts and enters those pleas. The court orders the preparation of a pre-sentence investigation report to be prepared by AP&P and the Department of Corrections. Counsel, what about sentencing on February 20th? I think, do you and your client agree to waive time, counsel?
We do agree to waive time, Your Honor.
February 20th, I believe, is a Tuesday. Is that right? $10 a.m.?
That works for us, Your Honor.
All right. Anything else for today?
Your Honor, maybe, I've heard the court say this several times in a different fashion. We are not binding the court to any specific sentence, and the court retains its right to sentence as it sees fit. I just mentioned that this is not a Rule 11 plea, but although it's a stipulated statement of defendant.
Counsel, approach, please.
Now, back the day after my house fire, I was overseeing an eviction down in Parowan, which is in southern Utah, and I was kind of being pressured.
All right, anything else for today?
No, Judge. Nothing from the state. Thank you, Your Honor.
Thank you. We are in recess.
Thanks, Your Honor.
I was kind of being pressured by a prospective tenant on renting the basement apartment in my friend's parents' home, and I was too distracted by the house fire to really make good decisions, I guess, and so I went ahead and rented to him, and oh, I think within a few months, he assaulted his wife and then fled, and so the police executed a search warrant on the house and busted open a lot of doors, including the upstairs, because they had to make sure that he wasn't up there. And the guy had locksmith skills, so he could have gone anywhere he pleased. And he was eventually found down in St. George, where this hearing took place, and was arrested. And so he would have been prosecuted in one of these courtrooms like this down here in southern Utah. So just a little interesting story. Okay. Yes, she took a plea deal. 2 counts were dismissed so that she would get the deal, and she is testifying against Jody Hildebrandt. So I mean, it's just sad that it had to reach this. Of course, if you look at what happened with the Evander Ark case where the kid died, at least these kids will recover. They may have scars, emotional and or physical, but they will recover and probably go on to live productive lives. Good question. I suspect that there was abuse, but probably not to the extent there was after she got mixed up with Jody Hildebrandt. So it sounded like it really accelerated. She sounded like she was a total control freak. And the husband has filed for divorce. Who could have seen that coming? I mean, she busted up the marriage, made him move out. I haven't heard that much about him. It just sounded like they're typical conservative Mormon types, and that she was one of these mommy bloggers, and yeah, I don't know. I find that type annoying. I kind of watched a few episodes of that. Was it 19 Kids and Counting, or 18 Kids? I can't remember. The Duggars. Before it came out about I think it was the eldest son, Josh Duggar, abusing some of his younger sisters and others. And I can't remember, wasn't he one of the clients of that Washington, D.C. madam. Anyway, he's locked up. Let's see. Okay, we have passed the half-hour mark for jury deliberations. And let's see. Oops. Find. Let's see what else we've got. The Casual Criminalist has an episode on the Zodiac Killer. That one's kind of intriguing. Let's see, it looks like the Ruby Frankie hearing is the big news on today. We got that covered already. Okay, let's go to my list, which is what I was about to do when I spotted the hearing. Come on. Okay. Okay, top 6 funniest court moments in high-profile trials.
You poured yourself a mega pint of red wine, correct?
A mega pint.
I'm winging it, Your Honor.
You smoked before you came here today?
I did not.
I should have.
Sometimes you just can't help but laugh at absurd moments in court. From attorneys to defendants to witnesses and even jurors, you just never know what someone is going to do or say. Here are just a few examples of the law's lighter moments. Welcome to Sidebar, presented by Law and Crime. I'm Jesse Weber. So I don't need to tell you that courtrooms are very serious places. It's where judges and juries, they decide the fates of people accused of some of the worst crimes imaginable. We hear some incredibly difficult testimony. We see some horrifying evidence. There's no denying that. But despite that, sometimes there are moments of levity. There are moments that are just funny, and they usually come out of nowhere. They're unexpected. So we wanted to do something a little bit different here. We wanted to recap 6 of some of the funniest courtroom moments from recent cases. And you can't talk about hilarious courtroom antics without talking about the case of Johnny Depp versus Amber Heard. The weeks-long trial was full of quips and comebacks and jokes, especially from the man of the hour, actor Johnny Depp. I was in that courtroom out in Virginia for a large part of that trial. I was covering it for us here on Law and Crime, so I saw and heard some of this firsthand. Now, a little bit of a recap here. So Depp had sued his ex-wife, Amber Heard, an actress, for defamation after she wrote an op-ed piece for the Washington Post claiming that she was a domestic abuse survivor. Depp argued that although he wasn't named in the article per se, the op-ed was clearly about him. He said that the false claims damaged his reputation, it cost him acting roles that would have furthered his career, and Heard ended up countersuing Johnny Depp for statements that were made on what she argued was his behalf by his attorney, Adam Waldman, statements like her claims were a total hoax. And so you have this back and forth between two Hollywood stars, and the question is, who do you believe? What happened? Now, I'm not going to lie to you. Even though we are dealing with serious subject matter, we're dealing with abuse claims, there were just moments that were comical. Like when a witness was brutally honest.
You are a pretty big fan of Johnny Depp, aren't you?
I am not. To be honest.
Or when a witness gave a very blunt response.
And Mr. Depp was trying to urinate in the foyer, wasn't he?
No.
Mr. Depp had his penis out of his
Objection.
pants, didn't he?
I think I would remember.
Relevance.
seeing Mr. Depp penis.
I'll allow. Next question.
Or when a witness that used to work at the front desk of a building where Depp and Heard lived actually drove in his car and vaped during his videotaped deposition testimony. Never saw anything like that one before. And I'll tell you, his comments were pretty funny.
But in fact, you don't recall seeing Amber Heard on May 24th, correct?
I don't remember. I don't even remember what I got for breakfast. They come down. They say, somebody tried to get into my unit. There's scratches on my door. And like, oh, I'm really sorry, but who will think is going to get into your unit because they saw some scratches on the door, like, what, 4 inches above the door? Because the dog was scratching the door, was trying to get in, and they thought about someone trying to break into the unit.
But during the trial, it seems that some of the more memorable comical moments came from when Johnny Depp took the stand. And that's the moment that we want to focus on. Because his back and forth, particularly with Heard's defense attorney when he was being cross-examined, it brought out the laughter, including these wisecracks that were so quick. You really have to pay attention to what Johnny Depp was saying. Take a listen to a combination of some of this back and forth.
And you may have been drunk in that video, correct?
There's a possibility of that, yes, sir.
You poured yourself a mega pint of red wine, correct?
A mega pint.
Yeah.
I poured myself a large glass of wine.
Right.
I thought it necessary. I once gave Marilyn Manson a pill so that he would stop talking so much. Yes, it's a stack of hit pieces.
Yes, the first one is called
by Ms. Heard's publicity team.
Mr. Depp, we're going to try to get through this as quickly as possible. The next article is an article from May 7th, 2016. It's entitled Johnny Depp, Friends and Family Seriously Concerned About Him. Here's Why.
Yes,
Correct?
how did they know?
The
How
next
my financial
article,
woes would do
May
that.
25th, 2017, a year and a half before the op-ed was published. An article entitled, Where Did It All Go Wrong for Johnny Depp? After a string of flops and a ton of bad press, Johnny Depp's star power looks as wobbly as Jack Sparrow on a plank. Did I read that right?
You read that very, very well.
The next one, Hollywood Reporter, May 27th, 2017. Headline, Pirates of the Caribbean, The Diminishing Returns of Johnny Depp. Did I read that right?
You certainly did. Hollywood Reporter were very nice to me. He asked her what she would like for him to cook. That's hearsay, I guess.
Correct. I know, I just sure offered for the truth of the matter asserted.
He got it.
Okay, all right, well then.
I'm learning.
I gotta say, it was pretty entertaining. And I don't know, it seems like the jurors, they liked Depp on the stand because all comical moments aside, this was a trial about abuse. And in the end, jurors in Virginia agreed with Depp that Heard's abuse claims were false and defamatory, although they did believe that one of Waldman's comments made on Johnny Depp's behalf was defamatory against Amber Heard. So the jury awarded Depp more than $10 million in damages, but also $2 million for Amber Heard.
You know, we've all probably had a night out where we had one too many drinks and woke up the next morning feeling awful. And you've probably wondered why there isn't something we could take to help us not feel quite as bad the next morning. I'm here to tell you there is a product that you can use to make you not feel quite as bad. This is it. It's called Z-Biotics. Z-Biotics is a pre-alcohol probiotic. It's the world's first genetically engineered probiotic. PhD scientists invented it to tackle those rough mornings after.
All right, next up, we're in Waukesha, Wisconsin, where Darrell Brooks Jr. stood trial for driving an SUV into a Christmas parade back in 2021, killing 6 people, injuring dozens of others. Horrible crime, changed the lives of so many people and also the community as a whole. Now, Brooks decided at one point in the case that he wanted to represent himself. And you know what they say, the man who represents himself as a fool for a client. Brooks did a pretty good job of proving that. He didn't really understand most of the law. He argued with the judge. He threw fits in court. He even tried to call the entire state of Wisconsin as a witness. Throughout the trial between Brooks and the prosecution, there were reportedly more than 600 objections. And the prosecuting attorneys and the judge, they often clashed with the defendant. In fact, Judge Jennifer Darrow removed Brooks to a separate courtroom several times during the course of the trial so that he wouldn't interrupt court proceedings. He could still monitor what was going on. And, you know, more shenanigans. Ensued, with Brooks sometimes taking off his shirt, building a fort out of evidence boxes, waving his arms so he could be seen on camera, refusing to wear the headphones so he could hear what was going on. Just incredible. Just incredible. Brooks, I should tell you, also identified as a sovereign citizen, meaning he doesn't acknowledge regular U.S. law as something that he's governed by. And several times he objected to even being called Darrell Brooks or Mr. Brooks. So with all that in mind, here's a sampling of some of his more ridiculous moments.
I'm winging it, Your Honor. Respectfully object.
You can object, your objection's noted, but you need to let her state what she needs to state.
I don't see the relevance for this.
Your objection is noted, it's overruled.
Are you a party to this matter in any way?
Objection.
Grounds.
Irrelevant.
Grounds.
Sustained, it's not relevant.
Do you have a claim in this matter?
Objection, irrelevant.
Grounds.
Sustained.
Have you read the complaint in this matter?
Objection,
Grounds.
irrelevant. Not relevant, sustained.
Objection, I do not consent to being called that name, nor do I know any individual by that name, Your Honor. Objection, hearsay, and speculative.
It's neither one of those things.
Can we address the subject matter jurisdiction before the jury comes out? The jury comes out?
We've already done it.
And is that a judicial determination that you're making not to address the subject matter jurisdiction, which has yet to be proven at this point? It has not been
Mr.
verified.
Brooks, please, the jury's coming out.
We got to cut that out. You know you have to prove subject matter jurisdiction. You know that.
I would like to provide the defendant and the court with a copy.
So that had to be said. So it's the defendant.
That's not how it was said.
That was how I
completely
said. You want to
disagree.
run the record back?
Mr. Brooks.
So I'm the only one. I got one. I
Mr.
got one
Brooks.
ear that work, and I heard that.
This
Come on,
is
man.
Yeah, shocker. His legal arguments weren't that great. And it also didn't help that you had photographic and video proof that he was the driver of the car. And also eyewitnesses, too. Literally people on the stand saying, yeah, I saw him driving the red SUV. Well, with all of his antics aside, Darrell Brooks was convicted on all 76 charges, including 6 counts of first-degree intentional homicide. He was handed down 6 life sentences in prison plus 700 years. And he'll go down as being part of one of the more wild trials that we have covered on Law and Crime and Sidebar. Next, we're going to head to South Florida, where an up-and-coming young rapper is on trial for double murder. Jamel Demons goes by the stage name YNW Melly. Police believe Melly shot and killed 2 of his best friends inside of an SUV in 2018 as they were leaving a recording studio. I'm talking about fellow YNW group rappers Christopher Thomas Jr., or YNW Juvie, and Anthony Williams, or YNW Sack Chaser. Investigators allege that Melly and another friend then staged the shooting to look like a drive-by. And one of the things that prosecutors wanted to do was hear from other people who were at the recording studio that very night to try to pinpoint any issues, any conflict between Mellie and Juvie and Sack Chaser, as well as maybe any problems in Mellie's alibi, namely that he wasn't in the car when the shooting went down. And an important witness was Travion Glass, because he testified that Mellie changed his clothes from the time before the killings to when he saw him afterwards. Very suspicious there. So at one point, Glass was being questioned under cross-examination by Mellie's attorney, and clearly they wanted to establish, is he a reliable witness? But during his cross, Glass made a comment at the end of his testimony that definitely lightened the mood a bit in what, of course, was a very serious case.
So you smoke a lot of marijuana, right?
Possibly.
Well, you smoke it anytime you get a chance, I think is how you phrase it.
It's your answer. Yeah.
That was your answer.
I smoke when I smoke.
You smoke when you smoke?
Yeah.
And when's that?
When I smoke.
And when was that?
When I smoke.
You didn't see any friction exuded that night of any magnitude?
I did.
You did?
I didn't.
Okay, you did. With respect to your daily marijuana regimen, did you smoke before you came here today?
I did not.
Okay. I have nothing. Thank you.
I should have.
I wonder if a lot of people thought, I can't blame them. Not easy facing cross-examination. Maybe that would help a little bit. Look, it was an interesting case to file, and it had an even more interesting verdict because the jury couldn't come to a unanimous decision on the double murder charges, so a mistrial was declared by the court, and a new trial for YNW Mellie has been scheduled for October 2023. Okay, as we recap some of the funniest moments that we have seen in our trials, moving right along to the trial of the now infamous Alec Murdaugh. The once prominent South Carolina lawyer was accused of shooting to death his wife Maggie and son Paul at their country estate back in 2021. Now, toward the end of this very lengthy trial, before the jury got the case, the judge ended up dismissing a juror. And there were reports that this juror might have had conversations about the case outside of the courthouse. Not allowed, clearly not allowed. So to be on the safe side, Judge Clifton Newman let her go, replaced her with an alternate juror. Now, she's not identified or on camera in the clip that we're about to play, but just listen carefully to the very interesting item that she brought to court with her.
And in fairness to all the parties involved, we're going to replace you with one of the other jurors. Have you brought everything that you have outside of, you left some stuff in there? What do you have in there?
A dozen eggs.
Say it again?
A dozen eggs.
A dozen eggs.
Yeah, one of the other jurors brought in eggs for everybody.
Oh, okay.
Eggs in my purse, they got water.
All right, well, you're gonna leave the eggs. You wanna leave the eggs or take the eggs? You're gonna take the eggs. So, Mr. Bailiff, can you retrieve from the jury room her dozen eggs, her purse, and what else? And a bottle of water. You can get those things from the jury room. So they're going to get your things, and then once you're removed from the jury, you can't go back in the jury room. We'll have to tell them goodbye for you. Okay, all right. Well, thank you very much. You can go. Thank you. We get a lot of interesting things, but now a dozen eggs.
Hey, jury service is a tough business. Maybe she thought she'd get hungry. Maybe cook up some eggs in the jury room for everybody during deliberations. That would be nice. I am thinking, though, don't you have to refrigerate eggs? Yeah, that's a bit concerning now that I'm thinking about it. Anyway, not easy being a juror. Not easy being dismissed after hearing all this evidence. And really not an easy case to hear. Really sad when you think about what happened here. And in the end, the jury that did stay on, the jury that did deliberate, they found Alec Murdaugh guilty of the murders of his wife and son. All right. Sometimes it's the courtroom demonstrations that bring the levity to a trial. Let's go to California, where Robert Durst was at the center of one of the most complicated crime stories in years. So in 2021, he went on trial for the murder of his friend Susan Berman, who was found shot to death in her home back in 2000. Prosecutors allege that Robert Durst, the real estate heir, killed Berman so she wouldn't speak with police about what she perhaps knew regarding the disappearance of Durst's first wife, Kathy Durst, who went missing in the 1980s. Not to mention that at one point in Durst's life, he shot and killed his neighbor Maurice Black when he lived out in Texas. Durst actually went to trial back in the day for the murder of Black. He was acquitted of the murder, argued he acted in self-defense, but Durst pled guilty to tampering with evidence for chopping his body up. Yeah, stay with me because I know it's kind of hard to find humor in a case like this, but during his criminal trial in 2021, again for the murder of Susan Berman, a very frail and sick and wheelchair-bound Durst sat on the witness stand as his attorneys reenacted what Durst says happened between him and Maurice Black inside that home. And in a moment of what is really dark humor, Durst's attorneys ended up on the floor during their reenactment, and the courtroom just erupted into laughter.
Mommy, you wanna hang with Big Nate Dogg and the criminal? That's how we do it.
What happens next?
The gun went off.
What?
The gun went off.
Where was you and where was Maurice Black when the gun went off?
Lying on the floor of the kitchen.
So you fell backwards?
Mr. Chesnoff has done his best Hollywood falling back, like still grasping the gun, finger on the trigger.
Galveston, I could get down.
And we'll stipulate that Mr. DeGuerin got down with him. Then he won't actually have to do it.
Where's the television camera for this?
This is my favorite part of the whole trial so far.
I don't know who to root for here.
All right, Mr. Lewin, why don't you describe it? I can't see it.
So we've got Mr. DeGuerin playing Mr. Black. No, Bob. I'm sorry, Bob is on the right side.
Yeah.
They are both.
Why don't I describe it?
Okay.
I'm not sure that I want to.
I'm glad you have a mask on.
All right, so we're both on the floor. My left elbow's on the floor. My right hand's on the gun. Your right hand, Bob Durst's right hand is on the gun, on the top of the gun. Maurice Black has got his finger on the trigger. Is this when the gun goes off? Bob?
Yes.
Can we add that at the time the gun is going off, both Mr. Durst and Mr. Black are flat on the floor?
That's what was being reenacted.
And would also be directly behind where Mr. Black was sitting.
Okay, that's what they reenacted.
No, it's in the doorway. I've got plenty of help.
Definitely a lighter moment. And when the judge asked Durst if the reenactment by his attorneys was accurate, Durst said, "They are a full-service law firm." That is certainly true. Like I said, a moment of comedy in a very twisted and sad case. And in the end, the jury convicted Robert Durst of the murder of Susan Berman, and Durst died in prison shortly after. Well, we're going to finish up our conversation with Alex Jones. That's right. The InfoWars founder and host faced some huge lawsuits from families of victims of the Sandy Hook Elementary School shooting, as well as an FBI agent. You see, Jones repeatedly claimed on his broadcast that the shooting was fake, that it was staged, that it was a hoax, that the parents were crisis actors. So he was sued for various claims, including defamation. And Jones lost both lawsuits out in Texas and Connecticut through default judgments, meaning he refused to participate in court-ordered discovery during the case. You know, how each side is supposed to hand over the other side evidence? Well, Alex Jones, according to the court, really didn't do that. That's a big no-no. So the judges entered orders that he automatically lost these lawsuits. So now it was a question for the juries in Connecticut and Texas. How much would Alex Jones owe the plaintiffs in damages? How much would he have to pay up? What would his punishment be for losing? Now, I will tell you again, very sad cases when you think about what happened here, right? But with Alex Jones in these courtrooms, there was a fair share of ridiculous moments in court. Like when the judge out in Texas, the Honorable Maya Gamble, said he needed to spit out his gum, or was it gum?
Spit your gum out, Mr. Jones.
It's not gum.
What is it? Because you're not allowed food or gum of any kind in the courtroom.
I had my tooth pulled a week and a half ago, and I had some rosin earlier, and it's been causing me to have some pain.
So you're chewing on your gauze?
Would you like me to show you?
No, I
Right
just
here?
want you to answer my question.
No, I was massaging the hole in my mouth with my tongue. I'll show you right here.
I don't want to see
All right.
the inside of your mouth.
Oh, no, there's no gum. Hole.
Sit down.
You can't make this stuff up. I do want to highlight, though, one particularly light moment. I do have to give you a little bit of context here. So Norm Pattis was Alex Jones's attorney out in Connecticut. He was quite loud and vocal during the course of that trial. And Judge Barbara Bellis, who was the judge overseeing this case, she would get into these screaming matches with him, telling him not to interrupt and to quiet down.
He's not an expert, and so what one does isn't what we're
But
here to
that's-
show.
but-
We're here to show what he did.
Right, but
And the
that's a
purpose
different,
is being
no,
offered
Attorney
to
Pattis,
save
Attorney
time.
Pattis, Attorney Pattis. How many times do I have to say when I'm speaking, you stop? I'm not gonna have the comments anymore. I'm not gonna have it. I'm not gonna have it. I'm
Do you
not gonna have
expect me
anybody.
to lay silently when they're directed at me, but inappropriately? Do you expect me to roll over for my client? It's not going to happen.
Okay, now with that in mind, Jones himself got on the stand, but he had trouble hearing Pattis's objections as he was being questioned by the plaintiff's attorney. So Judge Bellis ends up making requests that she never thought she would.
After Bill Oldenburg and after Judge Bellis, who's next, Mr. Jones? Objections.
I mean, I guess if somebody's on national TV, oh, I'm sorry.
Again, no, Mr. Thomas. Again, no, we're objecting. And I sustained it's too warm, and you still answered.
Okay, I'm not hearing him.
Can you be louder? I never thought I would say this, Attorney Pattis.
Yes, Judge, I can be louder. How's that?
A little secret is I have serious hearing damage.
Okay, so.
And I need to get hearing aids soon, so.
So your client cannot hear. So.
Sorry, seriously, I can't hear you, Norm.
Yeah, the Jones trial's full of characters. And thanks to different lawsuits against Alex Jones, he's now been ordered to pay more than $1 billion for spreading lies and bizarre theories about what was a very real and serious and deadly tragedy. You know, looking back, you have to think that there is so much built up tension and pressure in these cases that these lighthearted moments, they can be a good thing at times. It allows everybody just to exhale for a second. Courtrooms, they're filled with real people and real situations, and sometimes just laughter ensues. Who knows what unexpected, candid, and comical moments will happen next, but we will make sure to cover them for you here. All right, everybody, that's all we have for you here on Sidebar. Thank you so much for joining us. Please subscribe on Apple Podcasts, Spotify, YouTube, wherever you get your podcasts. I'm Jesse Weber. Speak to you next time.
Okay, we've just crossed the hour mark for jury deliberation. I can just get that to stop. Let's see. Oh, here's one that we kind of took a look at a bit on breaks on an earlier trial. Logan Clegg, who was convicted of killing a pair of seniors who went on a trail behind their apartment in somewhere in New England. and he was sentenced. So let's take a look at that.
I go into my reasons for the sentences that I'm about to impose, I want to address two things. First, the defendant's suggestion that the Concord police somehow engaged in an effort to wrongfully convict him. I think the words that he used were something along the lines of to throw sand in the eyes of the people in an effort to do so. Let me be clear. There is absolutely no basis to that claim. Having sat through the trial in this case and the pretrial proceedings, there is no doubt in my mind the Concord police worked tirelessly and skillfully to bring the killer of Stephen and Wendy Reed to justice. They developed leads, they carefully considered evidence, and they put together all the evidence in this case demonstrating beyond a reasonable doubt. This wasn't just the Concord police. A jury of 12 people found that the defendant committed these murders. The suggestion that somehow his conviction in this case is the product of misconduct by the police is insulting, it's outrageous, and it's untrue. Nothing else reveals the sort of person who stands before me to make such a claim when the evidence suggests completely to the contrary. Let me address the family of Stephen and Wendy Reed. In my view, the most important people who are here today. Those were very powerful statements delivered in court and also provided to me in writing. I read each of them and I listened carefully to all of you. I appreciate those words because they gave me a sense of who your parents were, who your brother was, who your family friend was, and I feel like I don't know them, but I have a sense of who they are, and I have a sense of what their absence means to each of you, not having them with you. Thought a lot about them in the months leading up to this trial and before today, and have a clearer picture of not just the pictures that we saw of them in those woods, but the lives they lived and the difference they made to each of you is very powerful. Whenever I consider punishment, sentencing rather, I consider the purposes of sentencing. Punishment, general and specific deterrence, and rehabilitation. I've thought a lot about each of those here leading up to today and this morning. The arguments of counsel, statements by the victim's family, the defendant's prior background, and I want to be clear that as far as that's concerned, I'm not going to consider anything that did not result in a prior conviction of Mr. Clegg. There was some reference to a prior stabbing. It's my understanding that that did not result in a conviction. That's not going to be part of the sentences that I'm imposing today. But most importantly, I think about the circumstances surrounding the crimes themselves. The defendant has been convicted by a jury of the murders of Stephen and Wendy Reed, falsifying physical evidence and being a felon in possession of a handgun. As I said earlier, I listened carefully in the course of the trial to the testimony of witnesses, and I considered the evidence that was presented in the course of the trial. I've spent a lot of time thinking about this case before, during, and after trial. What makes this case so hard to comprehend, and some of the victim statements referenced that earlier today, is the question that may never be answered. Why? I don't have an answer for any of you today. And as I said, we may never have an answer to that question. But as I think about the appropriate sentences in this case for Mr. Clegg, there are some things that are clear. On the afternoon of April 18th, 2022, Stephen and Wendy Reed left their home and went for a walk. They went on a trail in the woods a place many people from Concord go to mountain bike, walk their dogs, to hike, a place of peace. Shortly after they entered the woods, they encountered the defendant, by all accounts, a total stranger to them before that day. For some incomprehensible reason, he pulled out his 9mm semi-automatic handgun and shot them multiple times, killing them. There's no question he had a 9mm handgun. The evidence came in about his purchase of that gun, and he was found with that gun when he was arrested in Vermont. As I think about this case, though, I've thought a lot about what Stephen and Wendy must have felt when the defendant pulled out that gun and started firing on them. No reason, no justification, the senseless, horrific murder of two innocent people. But what most of those moments have been like for them? Talking to each other, observed by a witness, entering the woods, having a normal conversation, and minutes later to have somebody pull a handgun and open fire on them. People who devoted their lives to each other, their family, and helping to make the world a better place. Violently shot by the defendant seconds after they encountered him. The defendant wasted no time hiding their bodies and trying to cover up his actions. He burned his nearby tent site, which included almost all of his worldly possessions, and fled Concord. He took steps to fly under the radar, hoping he would escape the consequences of his actions. Bought a ticket to Germany, a false Romanian passport, and amounted savings to get away. Those are not the actions of somebody trying to escape a probation violation. Those are the actions of a murderer in flight from his conduct. The question of sentencing in any case is hard. Most people who are sentenced will re-enter society at some point. The hope is that they will emerge from their punishment and their time in custody, rehabilitated and less likely to offend. For some people, however, who commit acts so senseless, so violent, and so terrible, the sentence needs to be crafted in a manner to make sure that they can never be in a position to hurt another innocent person. From my perspective, this is such a case. Any rehabilitation of the defendant should occur when he is safely in the four walls of the prison. Stephen and Wendy Reed were good people. They should have been able to enjoy their retirement together, their children, their family, and their friends. Go on many hikes together. They should have been able to do that. Logan Clegg is a stone-cold, violent murderer, nothing more. He shot and killed Stephen and Wendy Reed for no reason. His statements today ring hollow. He deserves nothing less than a sentence that fully reflects the magnitude of his crimes. And for that reason, I'm going to fully impose the sentences as recommended by the state. On charge ID 202-7584, a finding of guilty is entered. The defendant is sentenced to New Hampshire State Prison for not more than life, nor less than 50 years. There is added to the minimum sentence a disciplinary period equal to 150 days for each year of the minimum term of the defendant's sentence to be prorated for any part of the year. He has pretrial confinement credit of 422 days. Their sentences stand committed commencing today. He shall pay restitution of $17,564.39, $3,878.08 to Lindsay Reed, $13,686.31 to the Victims' Compensation Fund. I know, given the sentences that I've imposed in his circumstances, that he has no ability to pay counsel fees and expenses. That order throughout for the rest of his life. He's to participate meaningfully in and complete any counseling, treatment, and educational programs as directed by the Correctional Authority or Probation Parole Officer. The Department of Correction shall have the authority to award him earned time reductions against the minimum and maximum sentences for successful completion of programming while incarcerated. Law enforcement agencies may destroy the evidence and return it to its rightful owner. Defendant is ordered to be good behavior and comply with all terms of the sentence. On charge ID 2027585, finding he's guilty is entered on that charge of second-degree murder. Defendant is sentenced to New Hampshire State Prison for not more than life nor less than 50 years. There is added to the minimum sentence of disciplinary period equal to 150 days for each year of the minimum term of the defendant's sentence, be prorated for any part of the year. The sentence is to be served as follows: stand committed. Sentence is consecutive to the sentence that I just read. Again, no responsibility for counsel fees. Defendant participates in counseling treatment and education programs as directed by the correctional authority or probation parole officer. Subject to provisions of RSA 651A, Department of Corrections shall have the authority to award him earned time reductions against minimum maximum sentences for successful completion of programs while incarcerated. I truly hope he engages in rehabilitation, but there's no chance, if this sentence holds, that he will spend a day outside of the prison. Law enforcement agencies may destroy the rightful evidence, destroy the evidence, and return it to its rightful owner. He's ordered to be of good behavior and comply with all terms of the sentence. The remaining charges in charge ID 2091545 for falsifying physical evidence, 2053093 for falsifying physical evidence, 2053094 for falsifying physical evidence, 2053095C for falsifying physical evidence, and 2053096 for being a convicted felon in possession of a dangerous weapon. These sentences are identical and concurrent to the second consecutive life sentence, 50-year to life sentence that I've just imposed. Each of these sentences is as follows. The defendant is sentenced to New Hampshire State Prison for not more than 7 years, no less than 3.5 years. There is added to the minimum sentence disciplinary period equal to 150 days for each year of the minimum term of the defendant's sentence to be prorated for a part of the year. The sentence will be served as follows: stand committed, consecutive. Again, these are all concurrent with each other and consecutive to the first sentence and concurrent with the second 50 to life sentence. And for each of these, no responsibility for counsel fees. And he's participating in counseling treatment and educational programs as directed by the correctional authority, parole officer. The Department of Corrections shall have the authority to award him earned time reductions against minimum maximum sentences, successful completion of programming while incarcerated. Law enforcement agencies may destroy the evidence or return it to its rightful owner. He's ordered to be good behavior and comply with all terms of the sentence. Again, these are all identical and concurrent to each other. It is my hope in imposing these sentences that the defendant never again walks the streets as a free man and that no one else has to suffer the same fate. I hope that the family has peace. I wish you all the best. And that concludes the sentencing hearing. Thank you.
Rise to court.
Your Honor, may I make one request?
Yes.
With regard to restitution, that it be held in abeyance pending appeal, however, to the Victim Compensation Fund. I believe that there's $3,895 that's in.
So, Your Honor, the state had requested that the total amount of restitution be determined within 30 days. We submitted an updated form yesterday, I believe. So the form you may have read off with regard to the total amount of restitution was incorrect.
Okay.
However, the form that would have been submitted yesterday would have indicated that the total be determined within 30 days. There was $13,686.31 to victims' comp, which was reflected in that original sentence, but the amount to Lindsay Reed was inaccurate. So the state is asking some additional time to be able to come up with that total amount.
So in terms of this request that be held in abeyance until after the appeals, I think practically no money's going to change hands in the next 30 days. We all recognize that. Any objection to that?
No, Judge.
I'll make it clear that.
Thank you, Judge.
Where is it recessed?
Okay, with over 2,600 votes in the poll, 91% are saying guilty. Let's see how many non and how many hung jury. Let's take a look again. 5% not guilty, 4% hung jury. So that's pretty overwhelming. We've seen guilty verdicts with a lot bigger not guilty or hung jury sentiments. So most recently, I think that's kind of what it was in the Adelson trial. Seems like I thought that was going to be a hung jury because it was like maybe 50% guilty and the rest of them were between hung or not guilty. So let's take a look at, we started this video out before, but it's worth another look. Let's go over here.
You will have the sole responsibility to cross-examine witnesses, to present evidence, to make arguments to the court, etc. Did you hear me say that?
Yes, ma'am.
And you're informed of all of that?
I am informed.
Objection, Your Honor, asked and answered, and we've gone down this path.
Mr. Schmidt,
objection.
And I'm standing here competent as can be, representing myself today.
From screaming at a jury to sparring with a judge to mentioning Scooby-Doo in an opening statement, these are some of the top times defendants represented themselves at trial in recent cases. Welcome to Sidebar, presented by Law and Crime. I'm Jesse Weber. It's sometimes hard to imagine how someone could represent a defendant, right? A person accused of some of the most heinous crimes that we can think of. Well, I guess it becomes easier when the person representing the defendant is the defendant themselves. Yeah, defendants taking matters into their own hands, acting as their own lawyer in a trial. I will tell you, always interesting to see. And that is what we want to get into, some of the top times a defendant represented themselves in recent cases.
How to open your car door while submerged underwater. A fatal construction flaw in all recent automobiles.
Now, as we go through all this, I want you to keep in mind a phrase. The phrase, a man who represents himself has a fool for a client. Now, why am I saying that? Well, maybe what better place to start than with Darrell Brooks Jr. He's the man who drove an SUV into a Christmas parade route in Waukesha, Wisconsin, killing 6 people, wounding dozens of others. This happened back on November 21st, 2021. And he ended up facing numerous charges, including 6 counts of first-degree intentional homicide. So during his criminal trial in 2022, Brooks' antics went viral multiple times, from him taking off his shirt to him building a fort out of boxes to staring down the judge. But we want to take you through the decision to represent himself and how that all worked out. So despite the gravity of the charges against him and the magnitude of evidence, Brooks told Judge Jennifer Darrow that he wanted to go pro se, meaning represent himself, as is his legal right. And this clip kind of gives you a pretty good idea of what was to come in this trial.
Even though it's the same thing.
You want to represent yourself.
Yeah, but I didn't file the motion.
That's
just
not
merely-
relevant,
I'm just
sir.
merely
The motion is
asking-
before
I'm
me,
just
and I'm
merely
going
asking-
to address it.
I'm
Stop
just merely
talking
asking
over
the
me,
question.
Mr.
That's
Brooks.
it. Just merely asking
I
the
need
question.
to get through the advisement.
And I would like to know the answer to the question. that
You are
I'm
being
asking.
difficult. You are not listening. You are trying to interject irrelevant factors for this court.
It has
So,
merit.
stop.
It's not irrelevant.
Stop.
I have a
Mr.
constitutional
Brooks,
right to
I'm
be able
going
to
to
ask questions.
continue. Please stop talking.
So it is a rush to judgment.
Mr. Brooks. The case law makes very clear you can't waive your right to an attorney. Let me rephrase that. The case law makes clear you cannot act as your own attorney, right? Exercise your right of self-representation while simultaneously exercising the right to counsel. Did you hear me say that?
Yes, I heard you say that, but that wasn't what I was attempting to do. That was the whole reason why I said it was filled out. This form was filled out for a specific reason, the way that it was.
Sir, I'm not going to entertain a request for whether it be called standby counsel, hybrid
That's not what I'm talking
representation.
about.
Your attorneys have told me you want to represent yourself. That is why we are having this hearing here today.
All right, we want to thank Morgan & Morgan for sponsoring this video. You know, life's scary, minding your own business when it seems that everyone and everything, no matter where you turn.
Did you hear me say that?
That's not my reason for wanting to represent myself pro per. It had nothing to do with delaying the trial.
So you don't want to delay the trial, correct?
That's not what I said. I said that the decision to represent myself pro per had nothing to do with a delay tactic. I think I'm very clear with what I said.
Well, I want to be clear. I understand you, sir. If it's not a delay tactic, I take that as you're not requesting an adjournment of the trial. Is that true?
That's not what I said.
Are you requesting an adjournment of this trial?
I can't logically make that decision until you make a judicial determination. Why would I answer that question right now at this point when I still don't know what's been decided yet?
So here's the important takeaway, in my humble opinion, sir. You are being advised that I am not going to adjourn the trial that is scheduled to start next week. Did you hear me say that?
I heard you say that. And
knowing that, sir,
I still can't logically answer what you are asking me because a decision has not been reached.
sir, what you need to understand is that the case law makes it very clear you have the absolute right to represent yourself. That is protected by the US and the Wisconsin Constitution. Did you hear me say that?
I know that.
And Brooks proved time and time again, even during these earliest proceedings, that he wasn't going to be the easiest to work with.
Understands that a lawyer may be appointed if the
I never
defendant
said I
is
understand.
indigent and understands the disadvantages of
Never once said
self-representation.
I understand.
He is voluntarily and freely waiving the
As a
right
matter
to
of
be
fact, I do not
represented by
understand.
counsel and is making a deliberate choice to proceed without counsel. And therefore, the court will grant the motion to withdraw brought by Attorney Perry and Attorney Keys. And from this point forward, Mr. Brooks will proceed as his own attorney.
And if the court thought that Darrell Brooks would behave more professionally as things got underway, they were wrong.
Mr. Brooks, you just interrupted me within a minute of us starting this case here today. I'm asking you to respectfully not interrupt me. That's the second time, so I can go through the list of things that I need to get through this morning.
I just wanted it stated for the record. that
Mr.
I'm not
Brooks,
identified by
it
name
wasn't
that
the
you called me
proper
by, that's
time
all.
to do that. That's now the third interruption. So,
With all due respect, Your Honor,
Mr. Brooks, by saying all due respect doesn't change the fact that you're interrupting me. Your objection is noted, all right? But you need to stop interrupting me so I can get through what needs to be done.
But it is
I have a number of documents.
When the judge is talking, then you intend to, sorry.
It
I
is,
accept it in return. It's a
Mr. Brooks,
value,
that's
Your
yet
Honor.
another interruption. Let me get through this, please.
I just want for the
You will
record,
have an opportunity when I give you an
I want
opportunity. No
to
one
state
else
it.
is speaking at the moment but me. You need to stop interrupting.
I don't identify by that name.
You heard him say there that he doesn't identify by the name Darrell Brooks. He brought this up multiple times before and during the trial. And that's because Brooks identifies as what's called a sovereign citizen, which seems to mean that he doesn't believe the regular laws apply to him. And while he repeatedly said he didn't consent to being called Darrell Brooks or even Mr. Brooks, you know what I was thinking throughout all of that and that whole trial? I don't recall him ever saying what he did want to be called. Anyway, throughout this trial between Brooks and the prosecution, there were reportedly more than 600 objections. And look, despite this being a really serious case, I got to tell you, it was Brooks's antics in court that at times, honestly, it became comical to watch.
Responding to emails takes time, but not with Grammarly. In a few clicks, Grammarly's generative AI.
I'm winging it, Your Honor. Respectfully object to
You
that.
can object, your objection's noted, but you need to let her state what she needs to state.
I don't see the relevance of this.
Your objection is noted, it's overruled.
Are you a party to this matter in any way?
Objection.
Grounds.
Irrelevant.
Grounds.
Sustained, it's not relevant.
Do you have a claim in this matter?
Objection,
Grounds.
Sustained.
Have you read the complaint in this matter?
Objection.
Grounds.
Not relevant, sustained.
Objection, I do not consent to being called that name, nor do I know any individual by that name, Your Honor. Objection, hearsay, and speculative.
It's neither one of those things.
Can we address the subject matter jurisdiction before the jury comes out? The jury comes out?
We've already done it.
And is that a judicial determination that you're making not to address the subject matter jurisdiction, which has yet to be proven at this point? It has not been
Mr. Brooks,
verified.
please, the jury's coming out.
We got to cut that out. You know you have to prove subject matter jurisdiction. You know that. Your Honor, I don't consent to being called that name and would like to address subject matter jurisdiction for the record as yet to be proven.
Comical might be one word. Then again, I think it was exhausting. Yeah, exhausting. I think that's a fair word to describe some of his defense tactics. And Brooks especially sparred with the prosecutors.
So as long as the jury's out, we should probably discuss that. I would like to provide the defendant and the court with a copy.
So that had to be said. So it's the defendant.
That's not how it was said.
That was how I said. You want to run the record back?
Mr. Brooks.
So I'm the only one. I got one. I
Mr.
got one
Brooks.
ear that work, and I heard that.
This
Come on,
is
man.
to benefit you so
No,
that
it's
you
not.
understand
Ain't none of
your
this to benefit me,
witness
so let's be
has a
clear about
prior
that.
record.
Your Honor, when I leave the table, I'm away from the courtroom and I have to elevate my voice. This is the
So she had to
alleged
elevate her
record of
voice
Abel
just for
Lescott.
that.
Stop talking.
Come on, man. Like, I don't know who y'all be thinking y'all fooling. I accept the value, return for value this document.
One more interruption and you're going to be removed to the next
That's
courtroom.
what you want to do anyway.
Judge Darrow even said at one point that Brooks was scaring her when he stared her down. So maybe not surprisingly, she removed him to a separate courtroom several times during the course of this trial so he wouldn't interrupt court proceedings. He could still monitor what was going on. But more shenanigans ensued, with Brooks taking off his shirt, building a fort out of evidence boxes, waving his arms so he could be seen on camera, refusing to wear the headphones so he could actually hear what was going on. But at one point, even Brooks may have realized he was in over his head.
Under the Sixth Amendment, I have the right to assistance of counsel. It doesn't say anything about representing yourself without assistance of counsel. Having counsel represent you and having assistance of counsel is two totally different things. You, Your Honor, gave me paperwork that was a waiver of counsel. We both know that any contract can be altered if I don't agree to certain terms.
Okay, yes, he's correct, but both parties have to consent to it, and she did not consent. She specifically told him the fact that he had made these alterations to the form did not mean that she was accepting it. So, A for effort, but it's not going to fly.
Crossed out everything in that paperwork that I did not agree or consent to, and specifically wrote on that paperwork that I do not waive my right to assistance of counsel. At the very least, I should have been awarded a standby counsel, not someone to represent me, to speak for me, but someone to help me do things in a timely fashion, get things filed in a timely fashion, get motions together in a timely fashion, make preparations to get things done that I don't have the privilege to do in my current situation of being housed at the Waukesha County Jail. I gave you back that paperwork and you accepted the paperwork that I altered, that you understood that I didn't agree and consent to those things that were altered. You accepted it and you filed it.
Yeah, this kind of seemed to me like you can't have your cake and eat it too kind of thing. You want an attorney to file for you, do your paperwork, but you want to do the arguments, right? Seems like he wanted a paralegal, like a legal assistant. And look, under the court's rulings, he forfeited his right to have standby counsel. So it's all on him. He seemed to understand that when he first made the request to represent himself. And by the way, this defendant really pushed the judge to her limit.
So there's this 80-year-old dude I discovered who claims he's able to download information like Neo in the Matrix and develop.
All right, the jury's coming back out, and I'm going to warn you, if you bring this up again, I will pause and I will remove you to the next courtroom for being disrespectful, for being interruptive, for being disruptive, and for bringing up irrelevant matters in front of this jury. You will forfeit your right to be present for the direct examination of this witness.
I object to
Did
that,
you
Your Honor.
hear what I said,
No,
sir?
I did not. I object to that, Your Honor.
Well, you can
And
object, and your objection is noted, but if you
for the
interrupt
record-
when this jury
for
comes
the
out,
record-
they will go, I will have them taken out again, and you will be removed to the next courtroom.
You can't, what is the legal basis for that ruling, Your Honor?
Illinois versus Allen, sir, and all of the
And-
other cases that
and it
I've
doesn't
cited
say
previously.
anything
I'll make the appropriate record. Stop interrupting me. The jury's coming out. We're continuing with this trial despite your repeated efforts to disrupt.
That's a
Yesterday,
mischaracterization
sit
of the
down.
record.
Yesterday alone, sir, 17 interruptions, not including the opportunity that I gave you where you spent 15 minutes, okay, discussing what were primarily either irrelevant or baseless accusations and requests not based in law or fact. I was abundantly patient with you yesterday.
And you still haven't
And-
verified by proof any of what I
And
said,
none
Your
of that
Honor.
is required, sir.
Because it
And
is. You can't verify.
your
any proof.
belief
Where's
that
the
that's the
subject matter-
law
where's the subject matter
doesn't make it
jurisdiction?
so, Mr. Brooks. Your belief that these are legitimate legal positions
They are.
doesn't change the law and doesn't make it so.
It's
So,
clearly
again,
relevant because you didn't want to.
I'm
address
going to
it.
step off and give Mr. Brooks 5 minutes to cool off.
I'm
And
not-
when that
I don't
happens,
need
I'm
to cool
bringing the
off.
jury
I'm
out,
not angry at all.
and then we will
I just wanted
continue.
to. I don't.
And this went on for basically the whole trial. Now, to give you a sense of what he actually argued at his defense, here's a sample. Brooks delivered his closing argument, and he got emotional.
I myself in my own life have had to do a lot of healing. As a man with children myself, I find it hard to believe that anyone who's really had conversations with me, spent time around me, would think for 1 second that this is an intentional act. I've never heard of
someone intentionally trying to hurt someone while attempting to blow their horn. While attempting to alert people of their presence.
And he even at one point suggested the jury engage in nullification, which is basically like ignore the facts, ignore the law, decide this case based on some other factor. It is totally improper for the jury to do that. And totally improper for him, but he also may be real defenses. And that argument seemed to be that the car that he was driving had been under recall and that he had no control over the brakes and was honking his horn to get people out of the way.
Which brings me to more information that I believe that you should have been privy to. And I'm sure that the prosecution will beg to differ. But the fact of the matter is, the vehicle in question, make and model of 2010, Ford Escape. The vehicle in question, actually 2008, 2009, and 2010 of that model was in fact recalled.
Objection, misstatement of the facts, facts not in evidence.
Was in
Improper
fact-
argument, Your Honor.
Sustained.
Was in fact recalled. Was in fact a class action lawsuit against Ford
Objection,
for those
facts not in
model
evidence,
for
Your
those
Honor.
model vehicles.
Sustained. The jury will disregard.
Information that you should have been privy to, that you weren't allowed to be privy to. Why? I don't know.
But he actually did have the opportunity to question a state patrol inspector on the stand who testified that there was no mechanical issue with the car that would have caused the malfunction, meaning the driver wouldn't have lost control, meaning the car hit those people because of the driver and the driver alone. It also didn't help that multiple people testified they saw Brooks as the driver, and there was video and photographic evidence that he was the driver as well. Well, it took the jury only about 3 hours to reach their decision.
We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 1 of the information, dated this 26th day of October 2022, signed by the foreperson, juror number 11. If you find the defendant guilty of first-degree intentional homicide, answer the following question, yes or no. Did the defendant commit first-degree intentional homicide while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 2 of the information. Did the defendant commit first-degree intentional homicide while using a dangerous weapon? Answer, yes. Hey, you are to be removed right now. You will not do that.
Well, you heard there how someone felt after that verdict. Darrell Brooks was convicted on all 76 charges, including 6 counts of first-degree intentional homicide, and he was handed down 6 life sentences in prison plus 700 years. And he'll go down as being part of one of the wildest trials in law and crime history. Well, this next case definitely needs a warning. The crime here, unthinkable. One of the most brutal that we have ever reported on. So let's go to 2018, where 29-year-old Ronnie O'Neill III beat and then shot his girlfriend, 33-year-old Kenyatta Barron, and hacked their 9-year-old special needs daughter to death with an axe. Her name was Ranavea. And if that wasn't terrible enough, he also stabbed their 8-year-old son, Ronnie O'Neill IV, and set their home on fire. The young boy wasn't expected to survive, but miraculously, he managed to recover. In fact, law enforcement testified that they witnessed this young boy struggle to walk out of the home with stab wounds and severe burns. It doesn't get much worse than that. This all happened in Riverview, Florida. When he went to trial in June of 2021, O'Neill decided to act as his own attorney with standby counsel. And when it came time for him to deliver his opening statement, O'Neill took several deep breaths, and then launched into a tirade.
Do this every morning to clear stuck mucus from lungs and breathe easy all day long. Short or weak breathing is easy to...
The evidence is going to show that we are under some of the most vicious, lying, fabricating, fictitious government you ever seen. By the time it's all said and done, you will see who is the mass murderers in Tampa Bay, the state of Florida. You will know why what occurred on March 18, 2018 occurred. And the evidence is going to show that law enforcement tampered with evidence to meet their such high burden of proof. Because originally, it wasn't enough. So we had to tamper with evidence. Since it was such evident already, but we still had to tamper with evidence. The evidence is going to show my son did not see me murder his mom. The evidence is going to show he did not see me shoot his mom. The evidence is going to show my son said many things that are not true.
I've never seen someone scream their opening statement to the jury before. This went on for half an hour. I can't tell if he was trying to do an impression of an emphatic lawyer like one he saw in a movie or TV show, but that's what came to my mind. And some pretty big allegations he's making here about the government, too. Here's some more.
Local law enforcement wanted to make it seem like I'm some kind of menace to society. And I ran after killing Kenyatta Barron, knowing that authority was on the way to kill my own children. I wonder why I would do something like that for no reason. And I'm standing here competent as can be, representing myself today. And I look alone, but I'm backed by a mighty God.
Yeah, during his opening, O'Neill claimed that law enforcement not only manipulated recorded 911 phone calls to make it sound like he was beating his ex-girlfriend and insulting her, but that they also tampered with call logs to make his own 911 phone call disappear. The prosecutor called these claims absurd. Then again, really hard case for him to defend, let alone anyone, considering there was a crucial eyewitness and a harrowing 911 phone call where you could hear Barron screaming, so not really a lot for him to argue. But one of the more disturbing moments came when O'Neill had the opportunity to cross-examine his own son, the son that he was accused of stabbing, burning, almost killing, the boy who was 11 when this trial took place. He wasn't shown on camera, but you can hear his voice.
Did I hurt you that night of this incident?
Yes.
I did. And how did I hurt you?
You stabbed me.
Do you remember telling Detective Dirks? After he asked, did your dad hurt you the night that he hurt your sister? And you said, no, he didn't hurt me. Do you remember that?
No.
By the way, O'Neill actually started this questioning of his son by saying, "It's good to see you, man." Wow. It was so strange. I mean, there was one point when O'Neill cross-examined a detective who adopted O'Neill's son after this incident and thanked him for adopting his son, but then would later suggest to the jury that this showed his son was not credible, that he may be falsely testifying against his father. And speaking of which, when it came time for O'Neill to deliver his closing argument, he went back to screaming at the jury and staring down the prosecution.
He showed you a fraudulent recording where they allege that I beat Kenyatta Barron to death. He talked about Mr. Khalil Brown, my neighbor who stayed across the street. But if Mr. Khalil Brown was a help to them proving me guilty beyond a reasonable doubt, they would have called Mr. Khalil Brown. But I called Mr. Khalil Brown to be a witness for me. You will know the truth, whether in this trial or the next one.
And the judge finally had to step in to calm things down.
If you think I'm here to play around with y'all, I'm not.
All right, Mr. O'Neill, please stop using swearing language. It's not appropriate in a closing argument.
I was wondering when she may say this is too much. And then O'Neill, during his closing, confesses.
I did kill Kenyatta Barron. But I want you to tell it like it is if you're going to tell it.
So he admits he killed Barron, but didn't strike her 15 times as the state claimed. In fact, he seemed to argue that he was acting in self-defense, that he attacked her to protect his kids. Well, not surprisingly, the jury found Ronnie O'Neill III guilty on 2 counts of first-degree murder, 1 count of attempted first-degree murder, 2 counts of aggravated child abuse, 1 count of arson, and 1 count of resisting a law enforcement officer. 2 days later, at his sentencing hearing, this happened.
I am not sorry for something I didn't do, and I am not sorry for the things I did do.
Mr. O'Neill,
All right.
Listen, stop. Stop.
All right.
Listen to me.
I'm not
You're not going to raise your voice again.
I'm
You're
not going to
gonna
raise my
your
voice again. I'm not.
I will have you removed from this courtroom. I can sentence you without you being present.
Yes, ma'am.
You don't conduct
I
yourself.
understand, Your Honor.
Thank you.
But I will say, I'm sorry for your loss.
19 years I've been at this job. I've seen human beings killed at the hands of others in every way imaginable. You name it, I've seen it. Shootings, stabbings, drownings, suffocatings, blown apart by cars, some DUI manslaughter cases, horrible things. This is the worst case I have ever seen as far as the facts go.
And the judge said that she would be haunted for the rest of her life by what she saw during that trial. She sentenced O'Neill to 3 life sentences without the possibility of parole, plus 90 years. All right, next we go to Quincy, Illinois, where a man named Bradley Yan, who was accused of a list of awful crimes, decided that the best person to defend him was Bradley Yan. Yan and a woman, Karen Blackledge, were accused of egregious offenses. Police say they carjacked a 77-year-old woman, Tina Lohman Schmidt, on November 9th, 2021. Yan drove her home, sexually assaulted her, sprayed her with carpet cleaner. Yan and Blackledge then allegedly stole several jewelry items and Lohman's purse. Sadly, Lohman Schmidt died a few weeks later. Now, prosecutors didn't charge Yan in Lohman Schmidt's death, but did charge him with home invasion, residential burglary, aggravated vehicular hijacking, aggravated kidnapping, aggravated criminal sexual assault. Blackledge pled guilty to 1 count of home invasion and 1 count of aggravated sexual assault in April of 2022. She got 40 years in prison. But Jan maintained his innocence and went to trial in July of 2023. And he chose to represent himself with standby counsel there to advise him and answer any questions. But from the very beginning, Jan demonstrated his odd way with words.
There's not many smiles today. However, I did see some yesterday. I appreciate those smiles. That has brought a light to my soul as I've been stuck here in this county jail, tormented for the last 19 months. I ask that you forgive my appearance. This is not normally me. I normally have hair. I did not expect you to feel sorry for me by any means.
Okay. Just a thought, but don't think a lot of people are feeling sorry for him. Don't think that's something he really has to worry about. His opening statement to the jury was oftentimes rambling and, I don't know, maybe not the best.
I once heard that trials are based on persuasion. Who has the best persuasion in their words? Who can be persuaded by the persuadee? Incredible and impossible happenings. We all know what incredible and impossible means. Impossible means not possible. Credible means it's not credible.
Yeah. And then for some reason, Jan launched into an anecdote about his little brother and Scooby-Doo.
My little brother used to run to mother and say, "Mom, BB hit me." BB was my sister. He used to say, "BB hit me." Mom would say, "Well, my lovely young man, where are the marks to prove such?" Well, my mom, show me the marks. He could not show any marks. Mother would say, "I can't tell where the marks are." True story. Come to find out, my brother only had the remote taken from him. Scooby-Doo was his favorite. He would watch it end on end for hours. During them times when my brother would make them claims, we would all come to find out in the end that he had just simply walked away from the TV. Sis picked up the remote and he wanted the TV back. The tells he was telling, you will see that today, here, and throughout this trial, there are major tales told. Tales that are tall, simply very tall tales.
Weird. Just very, very weird. And a strange way to speak to a jury that's deciding if you degraded an elderly woman who eventually died. Now, for our listeners who can't see this visual of this clip, as this is all going on, the assistant state attorney, Josh Jones, he appears to be giving a look during this like, what are you talking about? And by the way, we see this a lot of times with defendants representing themselves. Their arguments, they don't make sense. They focus on the sympathy factor. Remember, they're not trained attorneys. At one point, Mr. Jones made the court aware that Jan's cousin, Travis Bloom, made a disturbance in the courthouse, and Jan tried to argue with the court about it.
Individual by the name of Travis Bloom attempted to enter the courtroom while the proceedings were occurring. He was stopped by security and told he could enter at breaks. At that point, he stayed outside the courtroom, but was heard outside the courtroom making very loud comments that were heard by Sheriff's Deputy Sam Smith inside the courtroom.
Your Honor, throughout my time here, my family has been repetitively denied. I understand Travis Bloom is an idiot. I understand that, fully understand that. He holds a good heart. They didn't arrest him yesterday. If he did all them things, they probably should have arrested him, right? I mean, these are very serious matters. To limit him from the courtroom simply because of this is ridiculous. If a person does not know that they cannot come in during a time that is not a recess, then maybe they should be explained that, or maybe there should be notices posted on a wall somewhere.
And the gentleman in the back courtroom by the door with law enforcement, what's your name? You step outside the door and see if there's anything posted about their entering the courtroom during a recess.
There is, Your Honor.
And what does it say, sir?
It says,
You may only enter the courtroom at recess or breaks.
And you were here yesterday, sir?
I was.
And was that sign posted on the door at all times?
I believe so.
Have a seat, Mr. Yan. Your motion or objection is overruled. Your, as you described, idiot relative Travis Bloom should have read the door sign before he tried to enter the courtroom, and so he was advised of the court rules.
Yeah, not the best argument. Don't argue there should be signs so people know if they can't enter the court or not, when in reality, there is a sign. That back and forth, though, I was outside the presence of the jury. Now, I want to move on to...
He wouldn't know there was a sign on the door because he was locked up and never saw the door. That was a good one.
To this really outrageous moment, I'm going to give you a bit of context here. So at one point, Jan is questioning Tim Schmidt. This is the husband of the victim. And Jan seemed to try to point out that Mr. Schmidt didn't call 911 on the night his wife said that she was attacked. And despite Schmidt saying he did call 911, Jan wanted to impeach him with phone records. The problem here is that those 911 phone calls are not recorded on phone records, and so these records are inadmissible, and Jan can't ask Schmidt about them. And Jan can't introduce them because he has no legal basis to do so. He has no foundation. Well, Jan didn't quite get that, or maybe chose to ignore that, and Mr. Jones, the prosecutor, got quite heated.
And do you recall what time you made a 911 call?
It was a little after 6 o'clock, right after I went home.
And if I said that there...
Objection, Your Honor. I know what he's going to ask next, Your Honor, and if it's going to be an objectionable question that the jury is not allowed to hear.
Just to refresh your memory, you stated you were subpoenaed for phone records, correct?
Objection, Your Honor. We just dealt with this.
Mr. Yan, the court sustained that objection.
Your Honor,
we need to go down a new path.
I'm just letting the witness know where we're at, Your Honor.
He was here, he knows. So next question, sir.
Okay. And you did provide those records, correct?
Objection, Your Honor. Asked and answered, and we've gone down this path.
Mr. Schmidt,
The objection.
Are you aware that there was no 911?
Objection, Your Honor.
I will sustain the objection, Mr.
There was
Yan.
no 911.
Objection, Your Honor.
I'll ask the bailiff to have the jury return to the jury room and we'll address this.
And it seems to only get worse for Mr. Yan because later on he questioned Sergeant Jake McMahon with the Adams County Sheriff's Department about the phone records and whether this was a mistake or he didn't know what he was doing. But arguing there was no 911 phone call that day? This report would suggest otherwise.
And that is a CFS report, which is also known as a 911 report, correct?
I know it as a dispatch ticket, but I
Dispatch
believe
ticket.
CFS.
Your Honor, I'd like to publish this in the jury.
Okay.
It states male came and attacked his wife and broke into the house and stole the car, correct?
Yes, that's what it reads.
This is Quincy, Adams County 911 call for service report, doesn't it?
Yes.
That means there was a 911 call, doesn't it?
Correct.
Yeah, that backfired. This is why we say representing yourself, maybe not the best idea. Now, in terms of closing arguments, prosecutors delivered theirs, and then Jan had a chance to speak for himself one last time. He agreed that whoever did this to Miss Lohman Schmidt was an awful person, but he insisted it wasn't him.
Ladies and gentlemen of the jury, today we're here on some sick, heinous matters. Matters that if I were that person, I wouldn't care if I was a prosecutor or not. I wouldn't sit here and call the defendant a man. I'd call him a piece of shit. Excuse my terminology, Your Honor. But I'd call him a piece of shit. Because that's what he would have been. I promise not to attempt to persuade you, to manipulate you. I'm still not going to. But one thing I'm going to tell you before I go any further is I'm not a creep. A person who does them things are creeps. They're sick. What I think they deserve is one of them pistols right there on the man's hips to be taken and having their heads blown off. My mama taught me better than this. She didn't teach me to go out and do these things, nor did I do them. Please stop, man.
I'm glad we got that straightened out. He also took time to critique the prosecution.
Mr. Jones has put on a great presentation today. Very great. Just like Miss Keck did on Monday last week. She put on a great presentation. Very abnormal and not her normal voice. Not her normal voice at all. She come forward with a presentation that seems so unnatural just to try to persuade you people. Just to try to persuade you. You see the woman right here on the screen? That's from a video. Does it appear if she's hurt, battered, beat? Persuasion. You can persuade anybody to do anything with words. You can persuade them with actions. You can persuade them with evidence. Sometimes evidence isn't evidence.
So, was it a good decision or a bad decision for him to represent himself? I think you can take a guess, because Bradley Yon was found guilty across the board. And to me, he seemed shocked when the jury found him guilty of all of the charges like sexual assault, kidnapping, and home invasion. Seems to me he thought he really could win this. And the judge ended up sentencing him to 130 years in prison with a minimum of 110 years to be served in the Illinois Department of Corrections. During sentencing, Judge Roger Thompson said Yon was, quote, the most reprehensible person I have had in court before me. That says a lot. So as we continue our discussion into some of the most memorable times defendants chose to represent themselves in recent cases, how could we not talk about Trevor Summers? He was accused of kidnapping, sexual assault, and attempted murder in Florida. Prosecutors say he attacked his ex-wife, Elisa Mathewson. So what happened was back in 2016, Trevor Summers pleaded guilty to federal fraud charges. He was awaiting sentencing. And a few months later, as he and his wife were getting divorced, a judge barred the two from seeing each other. But Summers apparently told the couple's teenage daughter in 2017 that he wanted to reconcile. So he convinced her to leave a window open so he could get into the family home and then leave the two alone, instructing her to take her siblings and drive to his home so he can make up with Mathewson. But authorities say Summers planned a murder-suicide and held Mathewson captive in her home for days. He allegedly tried to kill her twice during that time. At one point, he put her in the back of her car, and a witness spotted the vehicle, alerted police. They swooped in, rescued Mathewson. So his criminal trial started in August of 2022, and he started with defense counsel, who delivered the opening statement. But for the prosecution, their star witness was Miss Mathewson, Summers' ex-wife, and she laid out what happened to her for the court.
The highest art is beautiful.
My hands are tied behind my back. And at this point, this is where he is going to kill me. And they're not
That's what you're thinking at this point?
And they're not going to find my body because this is so secluded and such a wooded area.
So what happens?
So he turned me around and slit my wrist and said, that's for getting out of the car in the Walgreens. Pushed me back into the car, tied me back to the seat, buckled me back in with my hands still tied behind my back.
But then, a surprise. Summers decided he didn't need an attorney. He said he would do a better job of cross-examining his ex-wife, so he wanted to represent himself for the rest of the case.
Mr. Summers, you have a request of the court, sir?
Yes, Your Honor.
What is it?
I would like to resume self-representation and discharge Mr. Marchese as lead counsel.
And you believe that to be a wise decision?
Yes, Your Honor, I do.
Are you unhappy with the services of Mr. Marchese?
I'm not unhappy with the services of Mr. Marchese. I do not believe that he fully understands the circumstances surrounding the events, and it would be better if I did the cross-examinations from here on out.
The judge allowed it. And yes, he had the opportunity to cross-examine the victim, his ex-wife. Let me say, this cross-examination was tense.
Did I threaten you to have sex?
You broke into my home in the middle of the night when I was sleeping, attacked me and tied me up. I take that as, yes, you threatened me to have sex with you. Yes.
I'm asking you specifically, before we had sex, did I threaten you or force you to have sex with me?
My answer is yes, you forced me to have sex with you.
Did I hold you down?
No.
Did I push you?
Not at that time of having sex, but prior to having sex, you did push me. You did hold me down. You did tie me up. You did attack me, and you did break into my home when I was sleeping. You raped me.
And I'll tell you, Mathewson barely, if at all, looked at Summers as he was questioning her. And what he tried to do in his questioning was saying, how could she know what I was thinking? How could she know what I was intending to do, that I was intending to kill her? And he also tried to show that she wasn't credible.
Have you consistently said that I just stopped?
No. I came to, and there was no more pressure on the pillow, so he stopped putting pressure on it while I was unconscious.
So you were unconscious, but you knew what I was doing?
I regained consciousness, and there was no pressure on the pillow.
That's not your testimony in this courtroom. Your testimony in this courtroom is that I just stopped. And your testimony in other cases.
Objection, Judge, improper impeachment.
Yes.
Sorry.
As to argumentative, as to testifying, and as to improper impeachment.
Remember that this is not just some random eyewitness. This is the surviving victim testifying directly against the defendant about what she says happened to her at his hands. That's powerful. But Summers was acting as his own counsel, and he tried to convince the jury that there was more to this story, and he delivered his own closing argument.
Gentlemen, reasonable doubt, I believe, is everywhere. And I ask you to please remember that and to please focus on that element that has to be proven by the time that you make these decisions about my life, about the situation that you've been presented, about deciding whether or not to find me innocent or guilty. I ask you to please consider all of these factors and see that what I am trying to show you is that this was a very abnormal series of events, and it requires a lot more information for you to draw a conclusion that would say that I absolutely am guilty of these crimes.
But unfortunately for Mr. Summers, the jury wasn't buying it, and it took them less than 5 hours to convict him on all counts, including attempted murder, and he was sentenced to 3 life terms in prison plus another 224 years. We end today with a bizarre twist on going pro se. Staying in Florida, we want to talk about the sentencing phase of Stephen Lorenzo. So Lorenzo was accused of the 2003 murders of 2 men, Jason Galehouse and Michael Wachholtz, who were identified as members of the gay community. Now, Lorenzo was convicted of drugging and sexually abusing 9 men, including the 2 victims I just mentioned, and he was sentenced to 200 years in federal prison. 200 years. But it wasn't until 2012 that Lorenzo and a co-defendant were actually charged by Florida state prosecutors with the murders of Galehouse and Wachholtz. So Lorenzo's co-defendant, Scott Schweikert, pleaded guilty, agreed to work with prosecutors in their original case against Lorenzo. And Lorenzo would spend years fighting the charges, represented himself, reportedly delaying court proceedings, until he eventually decided to plead guilty. In fact, Lorenzo penned a handwritten letter from jail to the court saying he wanted to plead guilty, he wanted to be sentenced to death, and he wanted to forfeit his right to appeal. Okay. And in pleading guilty, Lorenzo had to explain what happened.
Mr. Schweikert wanted to get some experience. So we allowed him to do some stuff on Mr. Galehouse. Now, I don't know if I should add this, but Mr. Schweikert wanted to have a video done of him having experience as a master he was trying, and I was videotaping it while I was doing this. Mr. Schweikert got carried away. He lost control. The kid started to scream and get all upset. We realized that the kid was going to probably call the police on all of us. So we had a powwow and we said, this kid can't leave.
It's chilling how calmly he explains it. Now, I'll give you a little bit more context here. According to Lorenzo's co-defendant, Lorenzo basically knocked out the two victims. He put Gail House in a sleeper hold. He covered Wachholz's face with a rag soaked in ether. They never regained consciousness. They both died. And from there, Lorenzo and Schweikert allegedly dismembered Gail House, put his body parts in different dumpsters. It's our understanding the body has never been recovered. As for Wachholz, the pair allegedly wrapped him in a sheet, put him in a Jeep, and he was found in a town and country parking lot. So why did Lorenzo want the death penalty so badly? Well, he explained it to a judge during a hearing.
Yes, give me the death penalty. That is absolutely great. That's exactly what I want. I'm 64 years old. I could be on death row for 10, 15 years. The comforts that they get in the death row are a lot more comfortable than it is in the federal system. You get your own private cell, you get your own TV, you get your own computer, you get all this stuff. But your privacy, your daily quality of life privacy at my age is invaluable. I want to do my time my way. It's easy time. So I'm going anyway. As far as I'm concerned, everybody here is on death row. Everybody's got to go sometime.
Well, there was a Spencer hearing that was held a couple weeks later to assess whether Lorenzo had any other evidence to present to the court.
Grammarly now uses AI to help you write, not just revise. Type a prompt and generate a
It sounds like there's nothing else that no argument you want to make, no testimony you want to offer at this time. Is that correct?
No, that's right. The mitigation kind of put it over the top of what I wanted to put in, so I'm covered. I feel I'm covered. I feel good about it. Thank you.
Let me ask you this. Throughout these proceedings, including the penalty phase, you've indicated that you want the court to impose the death penalty. Is that still your position?
Yes, that sure is.
Okay.
I don't know if you want me to explain, but yes.
No, I don't need any explanation. I just wanted to make sure that nothing has changed from your desire as to the sentence that you wish the court to impose on Friday.
Yes, I sure do. Yes, nothing's changed on that.
All right.
Now that Mr. Lorenzo has presented no other argument, no other evidence, we will stand on the proceedings, the previous proceedings, the arguments, the evidence, and the sworn testimony. So that's all we have, Brown. Thank you.
All right.
A few days later, it was time for the judge to deliver his sentence, and Lorenzo spoke before hearing the decision.
The sooner that I get euthanized, as far as I'm concerned, the faster I can get, the sooner I can get, fetch myself a new body and come back again, a fresh body. That's how I look at it, because that's how it is. That's how it's spiritual work. We're eternal beings. So the way I look at it is the sooner I euthanize, the sooner I can come back. I've got better things to do with my time than to hang out and spend the next 15, 20 years on death row or in any prison system. So that's what I'm asking for. It's selfish, but that's what I want. So that's all I really have to say.
All right.
Thank you.
Well, thank you. And I don't know if what you say is perhaps some form of reverse psychology, nor do I care. I will not consider what you want in issuing my sentence.
I know that. Yes.
All right. So I am then ready to proceed. Did you have anything else that you want to say?
No, I'm pretty good. I'm looking forward to getting this over with. It's been 5 long years.
All right. I sentence you, Mr. Lorenzo, to death. That is the punishment that you deserve for these horrific crimes.
Thank you, Your Honor. I
And
appreciate it.
Mr. Lorenzo, may God have mercy on your soul.
My soul is fine. Thank you, sir.
Interesting move by a convicted criminal. You know, I guess you could call this self-representation in this situation a success. He got what he wanted. And again, as the judge said, this isn't about what Lorenzo wanted. This is about justice. Given the gravity of these crimes, not surprised by the outcome. All right, everybody, that's all we have for you right now here on Sidebar. Thank you so much for joining us. Please subscribe on Apple Podcasts, Spotify, YouTube, wherever you get.
Okay. I've seen what must have been video on that creep up in my suggested videos more than once, and now I know what it was about. And Yeah, I think he was trying to do a reverse psychology on. So let's check in back over here. We are 2 hours, 22 minutes into jury deliberations. There hasn't been any signs of any questions. They probably took a break for eating. So let's see. This is in Kentucky. Let's see. Anything else? Oh, we've got a Christmas thing here. Let me cue this up. Just a sec. This one is from Crime Talk. Oops. Nope. I got the wrong video. Let's try that again. Okay, let me get to the segment. I believe. Okay, let's listen to this.
Our dumb criminal of the day. A Florida woman who earned the sympathies of her community after reporting that her kids' Christmas gifts were stolen out of her home has been arrested for, guess what? False reporting. Shayna Hudson, who according to the Lee County Sheriff's Office, had called in a supposed burglar report at her home on November 19th. The detectives who were investigating the case felt especially sorry that in addition to other items, Hudson's gifts to her kids had apparently been taken as well. And so they took the time to reach out to the American Legion and the Sheriff's Office, shop with a cop program, and arrange for new gifts for Hudson's children. Well, an anonymous tip to the local Crime Stoppers tipped them off to Hudson. And the information was that the call led to uncover that she had lied about what had happened. And the stolen gifts were soon found stashed at a relative's home. Not good. Anyway, Ms. Hudson was charged with fraud in the form of a false report to law enforcement, and she'll have plenty of time to think about stealing Christmas from others. I just don't get it, ladies and gentlemen. Anyway, the sheriff noted this is pathetic behavior and it's unacceptable. This woman took advantage of the system and is now paying the price for her selfish choices. Just tell the truth, ladies and gentlemen. All right, let's face it. We all didn't have wonderful childhoods. You didn't get lots of gifts, but if you got something that was good, but you hope your parents wouldn't lie to get you more stuff when you stashed them somewhere else. Just dumb. That's all we have for you today, ladies and gentlemen. Thanks for watching.
Okay, that reminds me of another story which is perfect for the season. Let me pull that up. I'm not sure if I saw this as a video or if I only read about it on the news. Let's see. Okay, it looks like it was a news story. Okay. Here we go. Walmart shoplifting suspect busted at Shop with a Cop charity event. And this was on December 4th. And Livingston County, Michigan. You hear a lot about retail fraud around the holidays, but the Grinch that stole Christmas at Livingston County Walmart took it to a whole new level. It played out during the annual Shop with a Cop last weekend at Walmart near Howell, meant to help kids in need. Police partnered with little ones to help them shop. We bring children that might otherwise not have a good Christmas to get to come to the store, said Lieutenant Renee Gonzalez, Michigan State Police. They get $100, sometimes a $150 card to go and shop for themselves with your family. The event included state troopers and police parading in lights and sirens, so it was very clear that they were there, but a 62-year-old shopper, it didn't matter at all. She loaded up her cart with $730 worth of stuff and dashed through self-checkout. Groceries, clothes, all kinds of stuff, Gonzalez said. It wasn't bagged up, and she walked out of the store with it. She ignored the clerk, who asked for her receipt, and then out to her car, ironically parked right next to a police cruiser, and began loading up her sleigh. Walmart told a trooper who had to leave his little shopping buddy behind to stop the Grinch, who couldn't produce a receipt for any of it. Gonzalez remarked that on the brazen nature of the caper, I do have to say it surprised me because when I'm driving a patrol car, people slow down, he said. When you see 75 cops in a store, I mean, I don't know if maybe they thought we were too busy. The trooper was able to get back to finish the event, but the 62-year-old woman was arrested. She was taken to Livingston County Jail, but bonded out. She will be charged with retail fraud. Fox 2 will release her name once she's charged. I honestly think it's something that you can't be in your right mind doing something like that, said shopper Mariah Mannion. Fox 2 did a court record search of the suspect from this story. She doesn't have any priors, just parking tickets out of East Lansing. And so that's it. The guy, the suspect in this case, hello, Amari West, he apparently has an offensive tattoo that the judge ordered covered up because she found it personally offensive. So, and he's apparently rather Daryl Brooksian type character, but he's had a shock cuff on, and so he hasn't been acting up like he did during the pre-trial hearings. He accused the judge he accused his lawyers of racism and being in the KKK. He threatened the judge with coming after her family. He threatened his lawyers with coming after them and their families. So he's facing additional charges for intimidation or threatening a person, an officer of the court. And so he's just a special kind of stupid, I guess. Okay, let's take a look and see what else we've got. Let's see. Oh, this should be this video is called "Why You Should Never Take the Stand in Your Own Defense," from Dreading, which is Crime and Psychology. I might have to fast forward through some bits, but let's take a look. Okay. Let's get this ready.
Sports, schooling, and was even on the honor roll. He was the kind of kid who people just felt like was going places, even if he didn't know it himself. People gravitated towards him, and because of that, it seemed like things just came easier to him. It was in high school that he eventually would meet his wife, Megan. Megan was like Tony in that everyone seemed to like her, but whereas Tony tried exceptionally hard and made it a point to be the loudest man in the room, Megan was much more reserved. She was much more attuned to how people were feeling and didn't much care for the spotlight the way that Tony did. She was far more concerned with how people were feeling, if they were okay or not, than how they thought she looked. Unlike so many other young people who grow apart as they age, Megan and Tony stayed together through high school and eventually went to college together. While at college, many regarded them as the perfect couple. Most took notice of Tony, as he once again felt the need to take all of the air out of the room with his presence and get most of the attention onto him, but still more like Megan, as she perfectly offset his rowdy behavior. According to one mutual friend, Tony had a tendency to go overboard, but Megan always kept him in check. After college, Megan and Tony got married and moved to Connecticut to be close to their extended family. The newlyweds had both pursued careers in physical therapy, and together they entered, where they gained incredible success. Locally, the couple became famous as the all-around perfect pair. Tony's infectious personality helped him get clients, and he quickly became known as the man to see if you had any sort of pain. His clients would rave about him. They would talk about how they had been overlooked by other medical professionals and pushed aside. But Tony, in one session, was able to write whatever was wrong with their body and simply listen to what they were going through. He also spent a considerable amount of time giving back to the community, coaching baseball and giving his time wherever it was needed. Likewise, Megan was known throughout the town as she was a licensed yoga instructor and an all-around amazing woman. Their practice did so well that they quickly outgrew their office space, and they opened a second location in town. Around the time of them opening their second location, Megan stepped away from the business, as Anthony and her had their first child, Alec. She moved away from the business.
Okay, he was convicted of murdering his entire family, and then he, for some reason, continued to live in the house for like a month after the murders, and until I think police finally came around and let's go ahead and skip forward to when he's on the let's see. Oh, it looks like we got a little bit of interrogation here. Let's go forward to the interrogation.
To try and assuage concern for their well-being and to gain more time to formulate a plan. Him actively admitting that he sent the texts for Megan and his kids directly flies in the face of his story about wanting them to be found and being so out of his mind with grief that he was unaware of what he was doing. The remainder of this interrogation is much of the same, and unfortunately, the audio makes it incredibly hard to verify what they are saying at times. However, Tony has failed in the 3 goals he set out to accomplish. The first, he wanted to solely place the blame of the murders on his wife's chronic illness. However, fairly early on, he makes it clear that he was more than happy to go along with the murders and tries his best to cover them up by texting their extended family, pretending to be Megan and the kids. Second was he wanted to appear to be somewhat impaired so he could claim the interrogation happened while he was in duress and claim diminished capacity. He was incredibly forthcoming and was able to recall key details, such as what phone he Googled how to kill his family on and what laptop that Megan watched videos on. He was also incredibly present with the interrogators, constantly nodding along as they spoke, acknowledging their words and repeating statements back to them when he needed clarification. If anything, he was so outwardly present and competent that to claim otherwise would be ridiculous. 3. He wanted to provide enough false information to the police that he could point to it and state that he was lying. Though Tony did get some details wrong, based on the defensive wounds on his arm, his DNA being found under Alec's fingernails, and the fact that he was able to recall the color of the knife that was used and where he hid certain things, it was clear that he was, at the very least, present when his family was killed and took part in some capacity. Tony hadn't appropriately accomplished what he had set out to do, and shortly after this interview, he stated that he was innocent and the confession had been taken when he was under extreme mental fatigue. The court reviewed the footage and allowed it, as he appeared to be competent in the footage, and no laws had been violated during the interrogation. With that roadblock in front of him, Tony's last resort was his trial, where he would take the stand. Usually in cases like this, we never get to hear what the guilty party thinks about the proceedings. Most defense attorneys will do everything in their power not to put their client on the stand, as it opens them up to cross-examination, which often makes them look bad. But in this case, Tony insisted that he be put on the stand. He felt as if what was happening to him was a huge injustice, and if the world could hear his side of things, he would be let go. We know this to be the case because he declares his innocence in the letter he wrote to his father, Robert. We read the full letter in our video, linked below. From that letter alone, it is clear that Tony is somewhat of a narcissist who believes he is the smartest person in any room he is in. His tone is demeaning to everyone around him, stating that, despite the multiple charges against him, he is the victim of his wife, the police, the FBI, and more. He also tries to demean his father, stating that Robert is a terrible person for putting a hit out on his wife when Tony was a child, without a lick of self-awareness that he did kill his wife and his entire family. He goes so far as to state that his wife's final moments alive were spent praising him for being an amazing person for all that he did, and that his only true failure was being unable to kill her, which is absolutely ridiculous and an insult to Megan's memory. Everything he says is illogical and stupid and doesn't stand up to basic reasoning, but Tony believes he is the smartest person in every room. Therefore, he can sell his line of thinking without any issue. His demeanor is not unlike Diane Downs, who felt as though, despite her claims being illogical, she was so clever she could make anyone around her believe what she was saying. However, like Diane, that is not the case. In his testimony, Tony tries to come across as a man who has gone through an incredible hardship, who loved his family and his life, but he comes short multiple times. So with that preface, let's begin.
Please identify yourself.
My name is Anthony John Tote.
What is your age?
46.
Mr. Tote, we've heard testimony about a woman named Megan Tote. Are you familiar with that person?
Yes.
Tony is on trial for the murder of his entire family, including the woman he has been with since high school. His defense is that his wife murdered the children and the family dog, and his only crime is not reporting that. His wife's name should have a profound impact on him, both because he loved her and she died, but also because, according to his story, murdered his kids. Instead of showing any outward emotion, though, Tony instead closes his eyes for a prolonged period of time, then opens them, nods his head, and says yes, that he does know her. He displays no emotion, and over the next couple of minutes, he will be attempting to make himself cry. However, his emotions and his body movements are not synchronized, and at various occasions, when he appears to be crying and emotional, it will not flow naturally with his posture and body language.
And were you, in fact, married to Megan Tote?
Yes.
When did you first meet her?
It was high school of 1992.
And where was that?
In Montville, Connecticut. Sorry. Montville, Connecticut. Montville.
And did you and Ms. Tote, did you and Megan, we've used first names throughout the case, so I'll do it to that. Hard to remember. Did you become married or become a couple?
Yes.
Now, did you attend the university in the state of Connecticut?
Yes.
And where did you go to school?
Sacred Heart University in Fairfield, Connecticut.
Did Megan also become a student at Sacred Heart?
Yes, she was 2 years behind me.
What was your course of study?
Undergraduate work, a major in psychology with a concentration in health psychology, with a declared minor of pre-physical therapy. And then I finished my master's degree of science in physical therapy.
While responding, Tony wipes a non-existent tear from his cheek. His tone never fluctuates as he speaks, indicating whatever emotion he is feigning having is not in sync with how he really feels. Earlier, his voice also started to shake, indicating heavy emotion, but directly after, he had to spell the name of a location and his tone immediately resets.
Right. Now, did your wife, when did you marry Megan? Was it in college or later?
I had graduated from college already, and she was in her second to last year of college.
What field did she study?
She had the exact same credentials as myself, physical therapy.
Did you practice in the field of physical therapy?
Yes, sir.
And are you familiar with medical terms and medical procedures?
Most definitely, sir.
How long did you practice as a physical therapist?
I received my license in August of 1999 and was practicing up until the current.
This is the first time that Tony fully shifts his position on the witness stand to speak directly to the jury, and it is when he is sharing his credentials and talking about how he is trained medically. He is attempting to assert intellectual dominance over the people in the courtroom and trying subconsciously to assert that despite the circumstances he is in, he should be respected.
Was Megan also involved in the practice with you?
In the practice of physical therapy, sir?
Yes.
Yes. She, whereas I did more hospitalist, nursing care, home care, and outpatient, she concentrated most of her time as a pediatric specialist and did work sometime in nursing homes when we traveled.
What were the circumstances that brought your family to Celebration?
Initially, my wife and I bought the condo in Celebration in July of 2005 when we were traveling physical therapists, which means they put us around the country either to cover for what they call snowbird season or people got on maternity leave. They were generally minimum of 13-week assignments and they could be extended. We first went out to California, wonderful time. Then we came down to Florida and found that since we sold our initial condo in Connecticut, we didn't have any deductions. So we bought the condo in Celebration as a partial investment and partially primary home because part of our contract with our traveling company is they pay for our residence. So at the current time, they're paying for a rental. Why have the company pay for a rental when they can pay for your actual house and help with your mortgage payments? So we bought the condo in July 2005. When would you like me to continue?
Tony has already given up his attempts to appear upset and no longer is trying to force emotion. He talks down to the jury, asking a rhetorical question about having their job pay their mortgage. His demeanor also dramatically shifts when he goes from talking towards the jury to talking to his lawyer, lowering his gaze and looking from under his eyebrows. This head positioning can be seen as aggressive and combative, and he will continue to do this, getting angrier and angrier throughout his questioning. Think about a time when someone has lowered their chin and spoken to you in this manner. It is usually a sign of outward annoyance and irritation at something you've done, and a way to make you feel small. This action is directed at his own lawyer, meaning on some level, Tony believes he is smarter than him.
Let me ask one thing at this point. What was the status of Megan's health when you first met her?
When I first met Megan, sorry, I just needed to collect myself.
Tony states he needs to collect himself before beginning. However, there are no outward signs of emotion. His eyes are not wet, his voice is not shaky, and his posture has not changed. He has been casually moving his chair back and forth, purposely moving himself between facing the jury and his lawyers, and if anything, he seems incredibly callous. There has been literally no physical indication of emotion from him this entire time, but once again, he is trying to force it. He sighs and closes his eyes for another extended period, seemingly to try and push tears out, but none are presenting. He will continue to try to seem emotional to little avail.
Megan had initially been diagnosed as a teen with Lyme disease, in which they say Lyme disease goes into remission. They say Lyme disease goes into just recesses and waits another day to invade, all depending on your immune system, all depending on what research shows and who you follow. She also was diagnosed right around middle school, right before I met her, with a heart issue. This heart issue they diagnosed as mitral valve prolapse and a murmur. They also diagnosed arrhythmias, at which time I found out after I started dating Megan in high school, because I asked her one time, we used to go out to dinner all the time. We used to, normal dating.
I will go over the interruption and his reaction in a moment. However, his remarks about her having Lyme disease as a child do not match with his initial statements and other reporting around the case. He also still has yet to display any emotion. As he goes over her medical history, opposing counsel objected due to relevance. This is Tony's reaction.
Ask your next question, Mr. West.
So this is the face of a man who is fucking pissed that someone interrupted him while he was speaking. Through turning around and cocking his head like this, he is challenging the lawyer directly and silently showing his aggression. This man has no self-awareness as to how aggressive and cocky he is appearing. Annoyance and hostility are the only emotions he has been able to showcase authentically so far.
I'll try and ask you more questions that have a shorter answer.
I apologize, sir.
And then, when you married Megan, what was the status of her health generally?
Generally, she was healthy. She avoided caffeine and she avoided sugars because of the heart issue previously mentioned.
And then, did there come a time when Megan began to have health problems?
Yeah.
And about when was the onset of that?
March 2011.
Once again, Tony is trying to make a show out of his emotions for his wife. In most authentic displays of emotion, the person will usually express some sort of embarrassment, which often manifests in hiding their face, covering their nose and eyes, or shielding their head in some way. Instead of doing that, Tony brazenly turns towards the jury, holds his head up, and tries to force tears and emotion. He begins to blink rapidly, which is a tactic usually helpful in causing irritation to the eyes, but still, nothing comes out. His tone of voice becomes shaky. However, his posture and self-assuredness never changes.
What are the conditions that she experienced?
We were vacationing. I apologize. We were vacationing in Florida. And we were at a theme park. And she got bit by a bug. She described this bug as a 6-legged black bug with a red mark on the back that reminded her of the state of Texas. I didn't see the bug. It was at the end of the day, and this bug bite, which you would think was innocuous, turned into this yellow, green, I can't even describe, pustule. It was a gigantic whitehead. So we went home that night. I went home to the hotel, or it was a hotel at the time, because of the issue.
And about what, that was in 2011, you say?
March 2011, sir.
And then in the ensuing year, did Megan develop any other health complications?
Oh, yeah. Through many trips to the hospital, many trips to the ER, cardiac critical care units. She was diagnosed with a multitude of diagnoses, I guess you want to say. First of which was, they found that she had drug-induced hepatitis. Sorry, first, I apologize, let me back up. They diagnosed her with tonsillar cellulitis. She had these gigantic white pustules on her tonsils. Her lymph node was just totally enlarged, in trouble breathing. In subsequent visits to the ER, subsequent visits to the doctors, they found that she acquired, through the medical aspect, what's called drug-induced hepatitis. So her liver became inflamed, very much so, that it was malfunctioning, to put it lightly. Her eyes were, at one point, the color of the most fluorescent yellow highlighter you ever seen in your life.
Most of these details have not been confirmed in reporting, and again, go against his initial statements about Megan's death. It should also be noted that other people who were around her at this time did not notice a change in her health or well-being. Still, despite his deliberate voice shakes, his rapid blinking, and continued sniffing, he has yet to shed a tear. It also becomes obvious that a lot of his posturing is deliberate, as once again he reacts to an objection with anger.
I swear her eyes could.
Mr. Toe?
Yes.
Notice how all of his overwhelming grief, his constant sniffing, and his tone completely changes the moment the DA objects. He is no longer the sad sap on the stand. He is annoyed that he has once again been interrupted, and he actively postures himself towards the lawyer in silent anger. His rapid switch between emotions shows the lack of sincerity or care he has with what he has been saying and what he is trying to portray.
Did there come a time then at that occasion when she had the hepatitis that it affected her lifestyle or what she could do?
Most definitely. My wife, she was a yoga teacher in addition to physical therapist. She went from a very strong, vibrant woman to barely holding on to 90 pounds. She couldn't keep weight on. She couldn't breathe. Her heart rate progressively was going crazy. At rest, it would be 190 or above. EKGs, all that kind of stuff, saw her throwing atrial fibrillations, PVCs, which are, it's basically your heart operates in a synchronous motion, okay? Valves pump on rhythm. Her valves and her, sorry, not valves, her chambers were beating all irregular. It was basically, you take four wheels of a car.
Objection, Your Honor, lack of medical knowledge.
If you ever wanted to see what a man who wants to strike a woman looks like, look no further. The fact that the DA objected due to his lack of medical expertise was, to Tony, a direct affront. He again believes himself to be the smartest person in the room. And despite the fact that he is not a doctor and is a chiropractor, for someone to say as much for him or in his presence is a slap in the face. Again, his complete shift from his voice wavering, his rapid blinking, and him trying to cry to glaring at the prosecution for stating he isn't a doctor is a direct indicator as to his emotions and their validity.
Mr. Toad, have you, what medical training have you received in conjunction with the physical therapy?
I appreciate you asking me that, sir. 20 years of medical experience working in the hospital, case review with charts, home care, meaning that not only was I operating under a nurse or with a nurse individually at a house, I was also opening cases on my own, which means I received medical information, medical records from the doctors and from the hospital themselves to be interpreted, to be reviewed, and to be deciphered so that I can properly give the appropriate care within their medical limits to the patient.
Thank you for that background. Now, as you're
Think about the last time you were upset and cried in front of people. The sudden onset of emotion is swift and usually uncontrollable, and it takes a good amount of time to recover. But him going from displaying signs of sorrow with a shaky breath and sniffling to no longer showing any signs of sadness shows his lack of real sorrow. Had this man not killed his entire family, his absolute rage and inability to act would be pretty funny. From here, he continues to almost berate the lawyers and the jury, choosing to, for the time, forgo pretending to be sad and aggressively answering some of the questions.
wife continued with her health issues, what was her attitude or outlook or demeanor?
Her demeanor went from a very vibrant young woman in which literally we were best friends. As dating, we always knew we would remain best friends. That's how close we were. We dated for 8 years before we were married. Her family was my family, okay? Her grandparents were my grandparents. That's how close we were, okay? She went from, even though she remained the light of my life, whenever she walked into a room, literally, after almost 20 years of marriage, my stomach would have those butterflies in it, seeing my wife. I existed, but she went from
His lawyer attempts to steer him back on track, and Tony lifts his finger to shush him, clearly showing that he believes he is the one in control of the situation and should be respected. This likewise indicates that he thinks he is smarter than his lawyer. But once more, the female DA objects, as Tony has gone on a weird side tangent about how his wife was his best friend, instead of talking about her demeanor, which was asked. Tony absolutely hates this woman. Nothing is as clear as Tony hating the DA, as every time she has objected, he has tried to stare her down.
Ask the question again, Mr. Wilson.
Now, at that point in time, did you have children?
At the time she got sick, sir?
Sorry?
At what point in time, sir?
When we're talking about this period in her life, when she had gone, when she was less vibrant or less her demeanor changed.
Before she got sick, we were blessed with two wonderful boys. Okay? She went from a mom who provided for everything, including myself. I consider myself a third kid, okay? To a person who could barely walk stairs on certain days. We hired, with the help and the assistance of our family, we hired I guess you want to say a mother's helper, okay? In which to come in, help bring the kids to school, which is something my wife.
What I'm going to ask you to do is to try and I'll try and correct you so that we don't have long extensions, so it's easier for everyone to understand what we're talking about.
I apologize, sir. It's been 2 years since I've been able to tell my story. I appreciate you working with you.
He thanks his lawyer and says it's been 2 years since he's been able to tell his story, and that's why he keeps going off on unrelated tangents, but he is visibly pissed off. Him thanking his lawyer for working with him is meant as a dig to the DA, who he is stating he doesn't appreciate working with. Also, his inclusion about needing to tell his story goes back to his narcissistic notion that if he explains what happened, everyone will believe him and he will be set free. His ramblings are very much in line with Diane Downs.
You and Megan attended Sacred Heart, which was a Roman Catholic university. Is that true?
That's the debate. It's Roman Catholic by name, but it was considered Jesuit run, which I don't know where the derivation between those two run.
But were you raised in the Catholic Church?
I was raised in the Roman Catholic Church and continue to practice as such, sir.
Do you know whether Megan was raised in the Roman Catholic Church?
Megan was raised in the Roman Catholic Church. However, before she went to college, her and her mother and father did shy away from it, but she did get confirmed before we got married.
As you progressed as a family, did Megan seek other religious experiences?
Most definitely, sir.
And what was the reason for that?
When she got sick, we were under the model of traditional med. That's where we were trained. Medicine helps. Progression of her disease process, we went more alternative, or she went more alternative, I should say, because we were told to stay away from medications. Alternatives were not working. Through her yoga practice and her yoga certification, she got introduced to, I guess you want to say, an Eastern religion, Hindu and based. I always thought it was Buddhist, but it was actually Hindu. And she shied away from the Roman Catholic Church, and her progression of her religion through that religion and her following also took over her medical outlook and her medical treatment of herself as she shied away from unsuccessful medical interventions.
Around that time, was there a calamitous event in the life of Megan's parents?
Before the birth of my first son, in November of 2002, her father hung himself. She was very close with her father. She was not close with her mom. I was very close with her father. He was one of my good friends, one of the few males I trusted. One of the things I totally enjoyed about the relationship with her and her family was her relationship with her father. She was that close with him.
All right, sir. And then also, along with having 3 children yourself with Megan, she suffered miscarriages, is that right?
Yes, sir.
Did that also affect her approach towards her health or approach towards how she carried on day to day?
The first miscarriage happened when she first got bit by that bug. And before the whole progression of the disease, in the process under it, there was, of course, depression and that kind of stuff for losing a baby. And then in the fall of 2019, September actually, we were blessed. We found out that a simple weekend away, we conceived. And she went from being depressed to very happy, dancing, singing, something that I hadn't seen in forever. And we lost the baby. And it affected her big time. And obviously affected me, but she went from that singing, humming, dancing person to not to days that she didn't even get out of bed.
What was the religious group that she had migrated towards, the Eastern religion? Did you ever attend their services with your wife? Or
I was very supportive of my wife. I did not understand, nor did I follow this religious aspect. I was Roman Catholic. The way I was raised in a military family. My stepfather was a very proud military man. I was taught respect.
He has gone back to trying to make himself cry. Clearly, it's not working. It's telling that when there are longer stretches of time between objections, he goes back to faking his emotion. He is also sure to make a dig at Megan's mother, which is completely irrelevant to the question that was asked. He will continue to do this with various people in order to try to discredit their statements about him and preemptively control what is said about him.
Repeat your question, Mr.
the
Ward.
question that was asked was, let me ask an entirely different question so no confusion. I want to make sure I tie up some loose ends. You mentioned Lyme disease, and that's somewhat prevalent in New England. Is that correct?
It seems like everybody has Lyme disease, yes.
And that is transmitted by insects, bugs also, correct?
That is correct.
All right. And then what were the effects on that on your wife that you noticed?
When the Lyme disease became apparent and positive, she had breathing problems, heart rate problems, chronic pains. When she had what was called exacerbations, so without getting too technical, your immune system is the best thing to keep any disease at bay. So whenever she didn't feel well, got sick, the Lyme would become more prevalent. So when the Lyme became more prevalent, not only did she have joint aches, she had feelings of hopelessness, depression, not wanting to go on certain days. There were some days where I helped her shave her legs because she couldn't bend over, she was in so much pain or couldn't breathe.
Mr. Tote, did your wife seek a different way to health through the Eastern religion?
Yes, she did, sir.
And was it diet-based or worship-based, or what were the parts that appealed to her? What was she seeking?
She was seeking control over her own medical care. Basically, anybody in a chronic illness wants some kind of control of their own self. She went from traditional medicine, she went to religious following of dictating what her healthcare was. She even followed a book from a guy who listened to a ghost who had no medical experience. to tell her what she should be doing, what she should be eating, and that kind of stuff. Called the medical medium.
Was there any discussion within that religious group about an afterlife?
Yes. This religious group could be conducted mostly by Skype or whatever video thing was at the time. I think it was Skype.
Objection, hearsay.
No,
He actually says no to the objection. He is so annoyed that he says no. This objection does properly shake him from his forced crying once more, but it's also important to note because earlier in his testimony, he stated he never went to worship and didn't partake in Megan's new religious beliefs, as he was a devout Roman Catholic. But now he changes it and says this.
Means of technology. Thank you.
I would sit with her during some of these meetings. They would give her prayers to pray, whether to help with what they were talking about with what was called family lineage karma burning. Because as in the Bible, Roman Catholic, the same thing she followed was the fact that your past, your past family's transgressions follow forward multiple generations. So her, as you asked, please repeat your question, just so I can make sure I repeat correctly.
Was there an afterlife component of this religious practice?
Yes, there was an afterlife component in which each afterlife, she believed that there was reincarnation. And as they burned the family karma in the current life, they reached a salvation in which they were reincarnated to a better life.
And was her desire to seek better health through this process by going into another life?
Better health and better relationships with people who had abused her and had verbally and otherwise affected her in her life.
There was some discussion about a suicide note, and that was apparently directed from Detective Cole Miller to Dr. Nara. Were you aware of any suicide note?
When I came back to the house that day, she showed it to me, yes. But I had no knowledge of it before I came home that day.
What was her demeanor or attitude at that time?
She was trying to explain to me what she did. She was trying to make me understand. It was the whole aspect of it was she was trying to present this as fact. And I was telling her, I don't believe that, I can't believe I called her some names, which I never called her before in my life. But the whole demeanor of it was, this is what I've been told through my meditations. This is what I believe. This is what, as she referred to as, the light has provided for her, and the light.
He is now talking about the day he says he found his kids dead, and his wife killed herself in front of him. He is still yet to break down or show any emotion in any way that is synchronized throughout his body. And once more, when the DA objects, his shaky breath, his facial movements, everything that had indicated any sort of duress or anguish immediately turns to anger and annoyance at being interrupted.
About your own demeanor and how your countenance.
My own demeanor, when I found out what happened, I puked. I cried. I was in total denial of what happened.
Tony is so angry at being interrupted when discussing the moment he, according to his own false narrative, found that his wife killed his kids, he practically yells at the jury. Normally, in moments like this, you would expect some sort of crying, but he's so angry at the DA, he has once again forgotten to be sad. He does seem to remember midway through explaining how he felt that he should act sad, though.
I couldn't understand. And then after that, I was like, I want to get you help. I'll take responsibility for this. Just get help. That's all I wanted. I would do anything in my life to do what she needed, provide for what she needed, provide her a happy life. I held my wife on a pedestal. I didn't care anything to myself. I wanted her to have a good life, period. And I wanted her to get help. I didn't care.
We'll try and work on shorter sentences so that everyone can keep up, and I'll be.
My apologies, sir.
We're fine. Have you progressed from talking about the afterlife to talking about what happened to your children and your wife?
I don't understand what you mean, sir.
When you said what had happened with Megan, what were you talking about?
What had happened that day when I came home?
Which day?
I don't know.
You don't have to talk about calendar date. What was the occurrence that made that day memorable?
I came home and my kids were dead. It was the most horrible day of my life. And what made me more horrible is my wife died in front of me also.
Had there been a blueberry pie that was cooked in the house?
According to what she told me.
Objection hearsay.
And
Hold on just a sec, Mr. Till. Response.
Describe what you know or saw and not what you heard from another person if you can.
Thank you, sir. When I came home that morning, I knew my family the night before was having dessert, and I declined it because you saw my health. I was jogging and losing weight. I came home that morning, and there was a melted purple, looked like a pudding pie. I can't really tell you exactly what it was. She told me what it was later, but it was in a graham cracker crust. And the kitchen, it was my job to clean the kitchen. But when I came home, that purple, bluish, grapish, melted pie, I guess you want to say, a pie dish was sitting there on the counter with some residue on the kids, at the kids' places on their plates.
At that time you came in, you saw that there were desserts that had been served up on the table?
I saw the remnants of it, yes.
And then did you then discover that your children were dead?
Not initially, no. I had gone upstairs. Well, I had too much information, but I had to pee. So I went to the bathroom and came out, and my wife was at the top of the stairs. My house was very quiet. Very unnormal having 3 kids, one 13, one 10 at the time, the other one 4 years old. She brought me in the room. I had been feeling nauseous that morning anyways, because I had these shakes I was taking for weight loss, all that. And around the same time that she was telling me I was puking. It was then that I understood what had transpired. She had blood on her shirt. And after that, after I said a few uncolored words to her, I then discovered the kids. I went into the rooms and found them dead.
You saw the video yesterday where on the 15th, Cole Miller and another investigator in a tiny room talked to you at length. Did you have an agenda for that discussion?
I don't even remember that day. Last thing I remember was falling down the stairs and smacking my head on the stairs, which I resulted in a fracture of my neck. Next thing I knew, I woke up here. And seeing that video yesterday, that was the first time I saw that video. I had no agenda consciously, but I can tell you throughout my relationship with my wife, especially after she got sick, I would put myself as a forefront and take responsibility and protect my wife.
There's a lot wrong with his statements. First off, he tries to state that he fractured his neck because of mishandling from the police. He stated as much in his letter to his father, where he also said that they had planned to let him off the hook for his Medicaid fraud. All of that is untrue, and there has yet to be proof that he ever hurt his neck during his arrest. He also has given various statements about not being able to recall what happened when he was in prison. But then he gave an incredibly detailed description as to what happened in the interrogation, which is consistent with him lying about his recollection. He also was not the righteous husband who would do anything to protect his wife, as he states here. He constantly talks down about his wife's physical appearance, said she was no longer womanly or attractive to him. All the while he looked like this. He also tried to later blame the Medicaid fraud on her, saying she was in charge of the books for the physical therapy practices he ran, even though no proof exists showing that at all. It's important to note that all the proof points to him, but he tries to make it point to her on various occasions.
You said in the statement that you stabbed the children and there was blood everywhere. Do you remember that from yesterday's video?
I remember it just seeing on yesterday's video. I wasn't aware of anything I said till about June. So maybe June or July, 6 months after I got here, when I got the transcript of what I said that day.
Why did you say that you performed the knife, the incisions on the bellies of the children?
It goes back to the aspect is I was covering for my wife. Obviously, unsuccessfully, because as you saw by the video, compared to what they said, I had no clue had my kids died.
Did you have ideas of joining your family in the afterlife?
After I saw everybody die, after I saw my wife die and saw my kids, most definitely. I wanted to be with them. That's the only thing I wanted to be. I didn't care by what means. I didn't care by what anything. I sliced my wrist. I took multiple doses of Benadryl. I tried to hang myself several times. I bought a pellet gun to shoot myself because I couldn't get a gun to, as you call it, eat a gun.
It bears mentioning that if he had the presence of mind to buy a pellet gun to kill himself, he would likewise have the presence of mind to call the police, so at the very least, the bodies of his family could be recovered. But he didn't do that. Also, amongst the markings he had on his body, likely from where his oldest son, Alec, tried to fight him off, there was no sign of him trying to slice his wrists. It is much more widely believed that he only really attempted to take his life when the FBI came to his door, as he didn't want to be arrested.
Did you ever try to poison yourself?
With Benadryl, yes. And also, I was just under recently of medical care and I was given metformin for diabetes. And at one point, I swallowed the whole bottle of metformin.
Now, I think there was evidence that you remained in the house for up to 3 weeks after the day that changed your family's entire future. During that time, how many attempts did you make to take your own life?
I would have to go through them to count because in my head I can't count them. Do you mind if I tell you?
Can we close your eyes for about 15 minutes and about 15 seconds and try and formulate the answer?
Unconscious recollection, I can tell you I remember at least 8 times. However, since being here and through other diagnostic testing, I found out there were additional times. So 10 times, at least.
And was Benadryl the primary agent that you were trying to use?
Benadryl was one of the agents. There was also a knife I picked up. I saw my wife stab herself. How hard could it be to stab yourself? You gotta be freaking kidding me. You see a knife with a blade like this and you want to instill that into your body? No, no way. I chickened out, yes. I tried other means. I tried at least 3 episodes of Benadryl.
And did you not keep it down or vomit or what happened?
Benadryl, as you know, can make you sleepy. Okay? The first time I took it, I didn't know what I was doing. I had no plan of this. I just wanted to be with my family. I woke up, I don't know when, how long. Obviously, I didn't take enough. Next time, I took a whole bunch of, the wall dry. I remember that distinctly because that stuff tastes horribly. But the children's, which is no different, it's just a better flavor. I took, I think it was equivalent of 5 glasses about this tall I had prepared. Okay? I fell asleep before I finished it entirely. The last thing of Benadryl, which I took when going back and looking at the dates and whatever, it turned out the day before that they came to my house. I saw the aspect of the 12th on one of the phones. At that time, I took over 200 pills of Benadryl. Now, mind you, a normal dose of Benadryl is 2 pills. And I took 2 family-size liquid Benadryls. In order to stay awake, and also because I was feeling nauseous, I took a Mountain Dew and an energy drink. The energy drink to keep me up because I kept falling asleep, and the Mountain Dew so that I wouldn't throw this stuff up. I wanted this stuff in my system. I was so frustrated I couldn't kill myself.
In the crime scene photographs that were shown to the jury, there was a Huffy bicycle in a box.
Yeah.
And were you prepared to assemble that bike?
God, my babies.
Every time thus far he has had to show emotion, he has closed his eyes for a sustained amount of time, furrowed his brow, and changed his breathing. This obviously has not been able to produce the effective amount of tears he has wanted, but he has done it when describing finding his kids, seeing his wife kill herself, and trying to take his own life. Now, at the recollection of a bike in a box, he covers his face, says, "Oh my God, my babies," and then puts on a higher effect in order to seem more sorrowful. This is not in line with how he has shown his emotions previously at all, and his continued ability to drop his sorrow at the first sign of an interruption indicates once again this is staged.
That was to be a Christmas present to my daughter. I hadn't picked up the boys' bikes yet because the boys were some of my best friends, and I could never say. I went over there that night to...
Again, the objection ruins his act. It's as if he's an actor in a stage show who keeps being interrupted by a director. His response to the following question shows his continued hostility and aggression, without even an ounce of the sorrow he was feigning.
Okay, next question, Mr. Wesley.
Did you open the box? Did you assemble the bike?
I never made it there to assemble the bike. That's where I went that night, to assemble that bike.
There are also new Christmas gifts, wrapped Christmas gifts that were shown in either the photographs or in the inventory that's collected. Did you and your wife buy gifts and have gifts ready for Christmas for your children?
Yes, some of those gifts were ours. New bed set, not bed set, I apologize. Duvet cover and sheets and all that kind of stuff the boys picked up. There was even a dollhouse that we picked up for my daughter. It was her first dollhouse. And there was also presence there from the family that had been sent down, yes.
Mr. Tote, what could have prohibited Megan from killing her children?
I have no idea. We woke up that morning, she was pain-free. Everything was good. I took the opportunity to try to go over and put the bike together. I had no knowledge of this. I don't know what could have prevented it. I have no idea. And that's the biggest thing that affects me, is the fact that I didn't even see this coming. They say, blindsided. This was a blindside by like a Mack truck filled with dynamite. Sorry.
No,
I'm sorry.
collect yourself.
Tissue or something. I'm sorry. Deputies. Thank you, sir. I appreciate it. Do you mind if I turn around real quick? Can I turn around? Sorry.
Do you remember the religious groups sending messages and having, I guess, prayer or singing sessions in Megan's memory and, information back?
I really do not understand that question, sir. I apologize.
Was the person who was thought to be the leader of this Indian or Eastern Indian religious group called Gari?
That was one of them, yes. That was the primary one, yes.
And they had individual contact with Megan, would leave messages for Megan and contact her?
Yeah, contacts would be via phone, via, like I said, the Skype computer thing, FaceTimed sometimes.
And did they contact you or give you information that Megan had crossed over?
They didn't tell me directly. They had contacted my sister, and my sister told me that she had a conversation, that Megan was at rest and she crossed over. I don't know where that, I don't understand it. But to hold it in my heart, she crossed over and she's at peace and not suffering. That's all I can hope for.
Mr. Tote, did you kill your family?
No.
Thank you, Your Honor.
Thank you, Mr. Wesley.
Tony was finally able to make himself cry and properly display emotion. However, again, he showcased a lot of desynchronization throughout his movements. After he was able to cry, he requested a tissue and asked to turn around, all the while biting his lips. Many have stated that the lip bites could indicate him trying to suppress a duping delight smile, as he was happy to have finally cried on the stand. While looking at this moment alone, it could be seen as genuine. Mere moments later, though, when the prosecution is allowed to start cross-examination, Tony's true emotions become all the more visible, as he is finally able to express the high amount of anger and aggression he has built up towards her.
Now cross-examination.
December of 2019, what was Megan's medical conditions?
Megan's medical conditions consisted of neck pain, back pain, hypothyroidism, Lyme disease, heart rate issues, breathing issues.
And did all of these medical issues make her frail?
Frail is a very subjective term. Can you please be more descriptive? Please?
Anthony knows what frail means. He went on a long tangent about how she was, in fact, frail previously. However, he does this to try and assert dominance over the opposing counsel here because they, on multiple occasions, said he was being vague and that his responses lack relevance. All of his sadness towards his family has gone, and he is just angry at the woman questioning him.
Did all of Megan's medical conditions make it hard for her to engage in everyday living?
Yes.
Did Megan's medical condition make it hard for her to walk?
At times, yes, but she hid it very well.
So going back to the date that you remember coming home to your family being gone, how was Megan walking that day?
She was walking fine. She had woken up pain-free the day before because she had told me that the light had interceded and the light had enabled her to do so.
Tony's movements show agitation and aggression. He is moving his head as if he is a bully on a schoolyard, picking on a smaller kid. It's apparent he thinks less of the opposing counsel and is trying to get under her skin, without realizing how terrible he looks towards the jury. In his mind, he just won them all over with his acting, and they are most likely already on his side. This is in turn his victory lap. He also very clearly begins to bite his lips and inside of his cheeks, showing that he is quite literally holding himself back from saying what he would like to say to her.
Okay, so she was walking around fine.
Correct.
And did she complain to you at all about, you said she was pain-free, so she didn't have to take any medication?
She was on a whole list of herbal stuff, some of which I had no idea what she was taking. Plus, she took this whole diet thing in which she would boil these mushrooms, in which she would do whole sorts of, there's so many things she would do.
Okay, so she was engaging in holistic practices.
Holistic and religious and spiritual practice, that's correct.
Okay. And you said that Megan had gotten diagnosed with Lyme disease as a teen.
That was her initial diagnosis, that's correct. And she had exacerbations. Like I told you before, the diagnosis.
My question was a yes or no question. Let me ask my next question.
Well, allow me to elaborate.
My question was a yes or no question.
That's fine. Thank you, ma'am.
He does not respect this lawyer. She is giving him absolutely no leeway. He tries to subtly assert that she isn't paying attention and isn't skilled at her job by saying he already told her this piece of information. She doesn't allow that to slide and instead forces him to respond yes or no. And when he tries to push back, she again tells him no. His body's entire positioning and reaction to her, as opposed to his own lawyer, is completely different and so obviously aggressive that it's uncomfortable. From here on out, anytime he is asked a yes or no question, he will purposely try to give a lengthy response to aggravate her. And when she asks a question that could have a longer response, he will try to answer it succinctly or pretend not to know how to answer for the same reason. His behavior is like that of a child after they are told no.
After she was diagnosed, or you were told she was diagnosed with Lyme disease, how long was it before she experienced symptoms?
Which time?
The first time.
I didn't know her when she initially got diagnosed with Lyme. She initially got diagnosed the first time when I was in 2011 and went through exacerbations, up and down cycles, all depending on her condition of her health, condition of her physically, condition of her mentally, condition of her stress-wise, condition of her emotionally.
And did she get diagnosed with Lyme disease as a teen or in 2011?
Like I explained before, I guess you want to say the jury is out of whether or not you have Lyme disease or Lyme exacerbations coming back and forth.
Okay.
She got diagnosed initially.
I don't have any other questions.
Allow me to finish, ma'am.
I don't have any other questions about that.
Thank you, ma'am.
Is it your testimony that from 2011 until December of 2019, Megan was suffering.
From 2011 to
Yes.
2019?
Yes.
Off and on, yes. But she consistently had all the breathing issues, the pain, and the heart rate issues, all depending on how bad they were and how bad they were affecting her to the day.
Prior to the day of the deaths, had Megan been suffering?
Most definitely.
When was the most recent time that she had been suffering?
Like I told you, I woke up that morning, all of a sudden, she was pain-free. The night before, I had worked on her. I had worked on her continuously every day for over a year after she weaned from Zoe. Before she went to bed, when she woke up in the morning, to help with her pain so that we can get her to the regular doctors. She had a doctor's visit scheduled for the Thursday after Thanksgiving. Forgive me, I do not have the date, in which she canceled because she had said, there's no hope. There's nothing more that can be done.
Okay. So what kind of work did you do for Megan?
Did myofascial release, craniosacral, any type of relaxations that, my apologies, ma'am. Manual therapy, in which I was trained under. Different things I would go to school for, or continuing ed for, to help treat her. Stuff I've read about, stuff I've gone through, everything within my scope of practice.
I'm asking you what you specifically did. So if you were going to treat her,
Yep,
what were the different things that you did?
that's what I'm trying to explain to you. Okay, there's no cookbook recipe in physical therapy. It's treating her ailments and treating her pains.
Okay,
So
so you
whether
did
or not her liver was inflamed, I did myofascial release to help release the liver. She had digestive problems. I would do integrated manual therapy to help with those digestive problems. She had neck pain. I helped with her neck pain. She had relaxation issues and stress issues and heart rate issues and vagus nerve issues. I would help her desensitize that through craniosacral therapy. I would do anything she needed to get done to help her get better, to help her progress in her life.
When was the mother helpers hired?
The mother's helper hired was initially after Tyler was born to help here and there to bring the kids, bring my oldest son to C school. So that would have been 2010-ish, 2011-ish, but she was up to more after she got sick to help provide through the assistance of her aunt who helped finance her and ourselves.
Okay. At what point was the mother's helper no longer necessary?
It was no longer never necessary. She had moved on to another career. We got another nanny, worker, that kind of stuff, which Megan and her did not get along with. Then she decided that warm weather was better, so she came down here. In many pleas to help get somebody else, we got a babysitter in which you want to know the whole truth. I'm telling you the whole truth.
My question, at what point did you not have assisted help?
At what point?
And year?
After year, let's see, we moved down here in 2014.
So
No, I apologize. Nope. Full-time was after Zoe, so full-time was 2016 she came down here. After that, we had no help because she fired the babysitter that we had.
Okay. So was Megan the caregiver for the children during the week?
Through the couple days that I was away, yes.
And you mentioned the couple days that you were away. You still had a practice up in Connecticut at the time,
We
right?
had a practice in Connecticut, that's correct.
And isn't it correct that you would travel during the week up to Connecticut?
That's correct, as long as my wife's issues and my wife's health dictated such. There were times in which I would literally land and I would get a phone call from my son or my wife that things are bad, and I'd hop on the first flight back.
Did that happen often?
It happened quite a bit.
And when you say things were bad, is this mentally, physically, what are you talking about?
All the above, from the miscarriage and bleeding, to the fact of her ripping the shelves off the wall, and my boy was scared, to her breaking the dishes, to her not being able to get out of bed. And then as things progressed, and I found that my older son was preparing a lot more meals, before I would leave for the couple days I was gone, I would make sure that
Objection,
there was-
non-responsive.
Ask your next question.
It wouldn't be far-fetched to say that Tony's entire strategy in this court case was to appear as a loving husband who would never hurt his wife or his family. His entire court case relied upon
It looks like we have a verdict. The clock stopped at 3 hours and I think it was 38 minutes. Looks like the judge isn't in the room yet. So people are still coming back. Okay, here's the judge. Somebody needs a cough.
Everybody's getting it. Okay, does anybody want me to poll the jury? Okay, and then is there anything else I'm gonna ask you?
Judge, before they leave, if there are signed forms, we'd like to examine them with the Commonwealth bench.
That's fine. Oh, okay. The only other thing I was gonna do is talk to everybody about reactions in the courtroom. So I'm gonna bring the jury in a moment. I want to thank all of you for being so respectful throughout this trial. I most certainly hope that that continues. If there is a guilty verdict, we will be back another day. Please do not behave in a way that makes me say you cannot come back another day. That goes for everybody. But like I said, everybody has been really respectful. I appreciate it. And that should continue as the verdict is read. Okay, would you mind to, I told them I would ask somebody to signal them. Thanks.
All words for the jury.
All right, everybody may be seated. Who was the foreperson? Thank you. Has the jury been able to reach a verdict in this case? All right, if you could please hand the form to Deputy Mills. Thank you. All right, the court will now read the verdict. Verdict form 1A, murder as to Christopher Jones. We, the jury, found the defendant guilty of murder. Having found the defendant guilty of murder, we found that the murder was intentional. Verdict form 2A, murder as to Maurice Gordon. We, the jury, found the defendant guilty of murder. Having found the defendant guilty of murder, we found that the murder was intentional. Verdict form 3A, murder as to Larry Ordway. We, the jury, found the defendant guilty of murder. Having found the defendant guilty of murder, we found that the murder was intentional. Verdict form 4, tampering with physical evidence. We, the jury, found the defendant guilty. Verdict form 5, abuse of a corpse, as to Maurice Gordon. We, the jury, found the defendant guilty. Verdict form 6, abuse of a corpse, as to Larry Ordway. We, the jury, found the defendant guilty. I'm now going to ask each of you by just kind of pointing, beginning with the back row and going down and then the front row. Is this your verdict? Is this your verdict? Yes. Counsel, can you all approach? All right, so I just kind of want to give you a sort of an idea of what will happen from here. First of all, thank you for your consideration of these matters. In Kentucky, jurors also handle sentencing. And so what we will do next is called the penalty phase of the trial, but we're certainly not going to do that tonight. We have some witnesses who cannot be here until Wednesday, but we also don't want to slow this down too much. As you can tell, we're on track to finish before Christmas, which is good, before the holidays kick in. So what I'm going to have you do is come back tomorrow at 1 p.m., see if we can knock out some of the evidence that we need to get entered. And then Wednesday, I expect will be the day that we conclude, okay? Now, I don't think you will be here too late Wednesday, but there is a chance you could be here after 5. Tomorrow, you'll probably be done by 3:30 or 4. All right, so be back outside the courtroom at 1 p.m. tomorrow. And in the meantime, the admonition remains in effect. You cannot do any research. You cannot post about this case. You cannot discuss it with anyone, including each other, when you're not in the deliberation room. So tomorrow morning, I will again ask if there's anything anybody needs to report, okay? Tomorrow afternoon at 1, thank you. Tomorrow afternoon at 1 p.m. And I believe we'll have somebody walk you all out as well.
All rights for jury.
Well, there we go. So I don't think we've done where the jury is over the penalty, or at least gives a recommendation. Welcome back, Tracy. You made it back for the verdict. I usually like to have things on to listen to while waiting. Listening to the Tote case, his direct exam or his testimony on the stand has been really interesting.
And then I'm going to have everyone else stay in the courtroom for about 5 minutes.
We'll save the rest of the stuff to play during breaks during the punishment phase.
Now, Mr. Rhodes, you can stay here, go back, whatever you want to do. I just want to give there some breathing space between the jurors and everybody else. We'll see you tomorrow. Thank you all.
No sense for him to stick around in the courtroom, but then he's going to spend the rest of his time soon behind bars. So I'd probably want to stay in the courtroom for another 5 minutes. Well, Aowen is weighing in on the verdict. She seems happy. So, I will set up the stream for tomorrow for the first part of the penalty phase, and I guess I will need to get things organized for getting ready to go up for Christmas, since I was figuring that would be done for a couple of weeks before sentencing, but since the jury's involved, we'll want to see that. So I thank everybody for being here today for this. Very satisfying to see him being found guilty. And so we'll be doing this again at 1 p.m. Eastern, which is 11 a.m. for me. And let's see. I got a flaw in my computer there. Yes, thank you. So we'll bid you good night and enjoy the rest of your evening. Bye-bye.